I can't hear anything.
Yeah. Yes, it's unmuted. Okay.
Okay, apparently, I'll start that over again now that we're unmuted.
Sorry about that, guys.
Jill, give me a thumbs up if you can hear me. Okay, all right. We'll bring, Welcome to the June 24th Mine Land Reclamation Board. Thank you everyone for joining us. Obviously, we are doing this in a hybrid fashion with the hearing room and also via Zoom. So thank you everyone for your patience with technology, and thanks to Cammie and team for getting this all together. Like I said when I was on mute before, we do have some microphones here between us in the room, but because of these plexiglass screens, we realize it may make our voices a little muffled. So please let us know if you can't hear anything. Don't be shy. We want everyone to feel like this is as normal as possible, and fair and equitable for everyone to have their voices here as we possibly can. We are going to end up with some longer transitions as we bring folks in. You know, we're really limiting this room to 10 people only. So, you know, everyone who's coming in here to speak will have to swap those seats out. So there will be some transitions. That hopefully is going to be a good time for, if you need to take a very quick break, you can. If you need to just stand up and stretch your legs, we realize that Zoom is tough and it's not the same thing. And we'll try to, you know, give some breaks where possible, but speak up if you need to take some time out. Really quickly, I want to make sure I've got everyone here in the room. So John Singletary's here, Tim Mock's here, Nell Wareham. I see on the screen, I see Jill, I see Lauren, I see Karen, and I'm looking for Forrest. I see Forrest. Okay, so that's everyone from the board. Sounds good. Okay. We are going to start off here with the approval of the May 2020 summary of minutes. Any commentary? You want to get a chance to?
Motion to approve.
Okay. Tim motions and John seconds. Thank you. Continue. Oh, I guess we've got to vote too, don't we? Yes. Elisa is paused, but she's raising her hand. Cammie, she can't talk. Elisa is trying to talk.
I'm having a hard time hearing. Can we have everybody really speak up?
Are we? Okay. Is that better?
Yeah, that is better.
Better?
So just really speak loud and give everybody time in between. I would appreciate it.
Got it. Okay. So we just did the motion for the summary of minutes and Tim Mock made the motion, John Singletary seconded. And now we'll call for a vote. All those in favor, please say aye.
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 Any
Aye.
opposed, same sign. Hearing none, motion passes. Thank you. Okay, so approval of continuances and withdrawals. We did have one withdrawal on your agenda item. It's agenda number 6. The enforcement hearing for Jay Rude has withdrawn. So we will not be covering that. So that's number 6, Jay Rude, file number M-1989-009. Okay, I'm not aware of any other.
Need a motion?
I don't know, do we need a motion for that? A motion? Motion to,
I move to approve the withdrawal from the agenda.
Second.
okay, a motion by John to withdraw the item from the agenda and a second from Tim. All those in favor, please say aye.
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 Opposed? Okay, hearing none, we will move to withdraw the J. Rude enforcement hearing M-1989-009. Thank you for the reminder. Okay, so we'll have an executive director's office report followed by a division director report. And again, please make sure that we can hear you. And if you can't hear us, please speak up. Let us know.
Madam Chair, Director Brandon, members of the board, good morning. Tim Mock, Deputy Director for the Department of Natural Resources. First, I just want to thank the DRMS team for arranging for this and really appreciate everybody's patience as we beta test a hybrid type of meeting. I think this is a good step, especially as we have more complicated hearings and try and continue to keep pace with the workload. So I really appreciate the effort that was put in place here. Also, I hope everybody and your families continue to remain healthy. At DNR here, we are continuing to work from home. We recently just directed staff or informed staff that we expected, and my microphone's run out of batteries here. Swap. All right, I'm back. We recently directed staff that we will be, for the most part, continuing to work as is through Labor Day, working from home. I think we continue at DNR to reach about 75% working from home. Our state parks and campgrounds continue to be fully functional and are continuing to see high demand. A couple other updates here from us. Late last Friday, U.S. District Court granted the state of Colorado a stay on implementing the Trump administration's Water of the United States rule, blocking the rule from going into effect on this past Monday. A California court denied the motion for a nationwide injunction, meaning that the rule will go into effect in all other states except for Colorado. We've also activated the drought plan here. Drought conditions continue to deepen and currently cover 81% of the state, with severe and extreme drought covering 33% of the state. Given those current conditions, the executive directors that chair Colorado's drought task force requested and the governor signed a phase 2 activation of the Colorado Drought Mitigation and Response Plan for the agricultural sector within 40 counties. This plan directs the drought task force to assess initial damages, impacts, and recommend mitigation measures. Also activates the agricultural impact task force, which will conduct an initial assessment on physical and economic impacts and recommend opportunities for incident mitigation. I think everybody's probably been aware that the Oil and Gas Conservation Commission has transitioned. The Governor Polis recently announced appointments to the new 5-member board. That includes Priya Nanjapa, serving as a member with formal training, substantial experience in environmental protection. Karen McGowan to serve as a member with formal training or substantial experience in public health. John Messner to serve as a member with substantial expertise in planning or land use. John was is actually a county commissioner in Gunnison and will be resigning that post here shortly. Bill Gonzalez of Denver to serve as a member with substantial experience in the oil and gas industry. And Jeff Robbins from Durango will serve as a member with professional experience, demonstrating an ability to contribute to the commission's body of expertise that will aid the commission in making sound, balanced decisions, and he will serve as chair. That means what we've also done is that Director Gibbs has hired or appointed Julie Murphy, the current COGCC Chief of Staff and Senior Policy Advisor, to replace Jeff Robbins as the department's director. And then finally, just a courtesy heads up that the Division of Water Resources is finalizing the initial abandonment list for publication in July, satisfying the statutory directive that the division engineer prepare decennially every 10 years, no later than July 1, an abandonment list comprising of all absolute water rights that has been determined to have been abandoned in whole or in part. And so we expect that to be published here early next week. And that concludes my report. Any questions? Thank you.
All right, any questions for Mr. Mock? No? Ms. Brannon?
Yes, good morning. Can everybody hear me? I was having some sound issues earlier. Are we good?
Yep.
Okay, great. Good morning. Ginny Brannon, Division Director for the division. The major thing that's happened since a couple major things have happened since we last spoke. One, the 10th Circuit a while back did remove the North Fork exception to the Colorado roadless rule, but remanded to the district court to issue an order to formally vacate it. There was a bit of a lapse there in time. So the conservation groups that spearheaded this effort filed an emergency motion with the district court saying, asking for the order, which the court did very, very, very soon grant. However, it was like a short 1-paragraph thing that just said, okay, order to vacate the North Fork exception to the Colorado roadless rule. So once that was vacated, but we do expect the district court, we think on the 26th perhaps, is going to come out with a more detailed order, sort of really outlining what that looks like. So we're looking forward to that guidance. However, with the order to vacate, we did go ahead and issue a cessation order to Mountain Coal Company, which is a subsidiary of Arch Coal at the West Elk Mine in Gunnison County. And what that cessation order says is they can't do things that are contrary to the Colorado roadless rule. So they can't build roads, they can't cut down trees, they can't do any new construction. That eliminates for now panels 2, 3, and 4. However, panel 1, which they're in now, they don't have to do any of those activities to mine out panel 1. They've already done those activities. And so now they can go ahead and mine panel 1. So this will give them about, they've got maybe 8 months left in panel 1, about 8 months for all this to sort itself out and to shore up the path forward. So in our cessation order, our reason was, of course, that the North Fork exception had been vacated and that therefore they no longer had legal right of entry, since any activities would be in violation of federal law. then that means you don't have legal right of entry into federal lands, and they're on Forest Service lands. So we also have catch-all language in our statute that says that the operator must be in compliance with all laws and rules, federal, state, and local. So that also is a second reason. So they have indicated to us that they will appeal the cessation order, and we think that you will see that at the July hearing, which right now is shaping up to be a 2-day hearing. So that's going on. Meanwhile, the Forest Service and the company are engaged in a sort of a briefing war with the conservation groups. The Forest Service is aligned with the company, and the conservation groups are saying, hey, you know, there's an order to vacate the North Fork exception, so you can't do this stuff anymore. And the Forest Service and the company are saying, yes, we actually still can, because we have the lease modifications, which were upheld by the district court and the 10th Circuit, and those were not vacated. And we think that the absence of vacating those things was deliberate. They're also arguing that what the conservation groups are asking for is an injunction. And they're saying that their motion for enforcement of the remedy is really an injunction masquerading as a motion for enforcement of the remedy. Really good briefings on both sides, and we'll see what happens. We'll see what the district court does with that. But that's a battle that's playing out, that we're watching, of course, but we're not part of. But the cessation order is in place. Panel 1 continues to be mined. The workers are still working, and you'll see that appeal in July. And that's, oh yes, I have something else. We've been busy in inactive mines. We've had 3 coal mine fires. Of course, these are all abandoned pre-law sites. And the inactive mines program successfully put out 3 of them. And so we've been hiring local contractors for that. And it's just good news all around. One, putting out the fires, and but also hiring those local folks to do the work. So that's all I have.
Thank you, Jenny.
Hey, Jenny, this is Lauren Duncan. Who are the conservation groups who are involved in that North Fork Road?
There's a number of them. There's a coalition of them, but I would say primarily Wild Earth Guardians and High Country Citizens Alliance would be the 2 leading ones.
Thank you.
Any other questions? Okay, wonderful. Thank you so much. Okay, moving along here in the agenda, item number 5. This is an enforcement hearing. Eagle Mine, file number M-2011-029, consideration of finding of financial warranty section forfeiture with Peyton Lee. Oh, yes, it's right. And Clayton, you and anyone else who intends to speak, you don't have, you can stand, virtually stand, and do you swear to tell the truth?
I do.
Okay, thank you. And Russ as well, do you intend to speak? Okay, thank you so much. Yeah, you can go ahead, Clayton. Sorry.
Okay. It's telling me that I'm not able to share my screen at the moment.
Okay. Let's see if Candy can fix that for you. Just working on
It
it.
shows that you should be able to, unless somebody else is sharing their screen. You want to try it again, Clayton?
Yeah, I'm getting the same message.
So you want to try, so right now you've got it on, not multiple.
Yeah, I just want to
Yeah.
switch to you.
Okay, there we go.
You got it? Okay,
I believe so.
great, thank you.
All right. Okay. Good morning. My name is Clayton Wine. I'm an environmental protection specialist with the Active Mines program. I'm the lead specialist assigned to the Eagle Mine minerals permit number 2011-029. We're here today to ask the board's consideration of financial warranty forfeiture for failure to submit the required 2019 annual report, MAP, fee, and failure to complete the corrective actions outlined in the December 19th, 2019 board order. Some chronology and background information on the site. On August 16th, 2019, the annual report, MAP, and fee were not submitted or received by the division. On August 28th, 2019, the division mailed a reason to believe letter and notice of hearing to the operator. October 23rd, 2019 was the Mine Land Reclamation Board hearing, at which hearing the board found the Eagle Mine to be in violation, revoked the permit, and found the financial warranty subject to forfeiture. The operator was not present at this hearing. On December 19th, 2019, the board order for the October 23rd, 2019 hearing was issued. This board order included the corrective actions and a deadline for those corrective actions. On January 17th, 2020, the division received an extension request for the corrective actions from Mr. John Golden of Honorable Ventures, LLC. The division approved this extension to allow time for legal issues to be resolved in court. The date for completion of the corrective actions was extended to April 16th, 2020. On March 19th, 2020, the division received a letter from Mr. Golden notifying the division that the legal issues would not be resolved in time for the April 16th deadline. He, in this letter, requested a second extension. The division at this time did not approve the March 19th request for an extension due to the previous extension being approved in January of 2020. On April 16th, 2020, the deadline for the corrective actions passed and none of the corrective actions had been completed. On April 23rd, 2020, a notice of board hearing for forfeiture of the financial warranty was mailed to the operator pursuant to CRS 34-32-118, parent 2. The division holds a cash bond from the operator for this site, so a separate notice for a financial warrantor was not necessary. In the board order sent on December 19th, 2019, the board found the financial warranty for permit number M-2011-029 to be subject to forfeiture under CRS 34-32-118, parent 1, parent B, for the operator's failure to cure a default under its performance warranty. Pursuant to CRS 34-32-118, parent 2, when the board has a reason to believe the financial warranty is subject to forfeiture, the board shall notify the operator and all financial warrantors. The board shall afford the operator and all financial warrantors the right to appear before
That's
the
what I
board.
brought. Oh, I didn't bring it. I got my own lunch today. I got a sandwich coming. Oh.
Hey, if you're not muted, please mute unless you are making line.
The board shall afford the operator and all financial warrantors the right to appear before the board at a hearing to be held not less than 30 days after the party's receipt of such notice. Pursuant to CRS 34-32-118, parent 3, parent A, at a hearing held pursuant to CRS 34-32-118, parent 2, the board may withdraw or modify any determination that the financial warranty is subject to forfeiture, settle of compromise the determination, or confirm its determination that the financial warranty should be forfeited. The division recommends that the board find the financial warranty for permit number M-2011-029 and the amount of $67,769 is forfeited, and direct the financial warrantor to immediately deliver the financial warranty to the board pursuant to CRS 34-32-118, parent 3, parent B. And now the division has time to answer any questions that the board may have.
Any questions or discussion?
Lauren has a question. I'm just trying to help her unmute. One
Okay,
second.
thanks, Bill.
Sure. Hey, Clayton, can you stop sharing your screen for me?
Yeah, let's see here.
Go to the top and it should say.
There we go.
There you
There we go.
go. Okay, perfect. Thank you.
Just helps. Okay, so let's.
Yep, so I can see. Okay.
Alrighty, there we go. This is Lauren. Thanks, Jill.
Yeah.
I was wondering what kind of timeline the operator suggested in their extension request in March, if they thought maybe this could get resolved this summer, or if they're looking at another 6 to 9 months, or what they were thinking.
At the time the operator had notified us, actually the attorney that was contacting us is not representing the operator. The division has not had any contact from the operator since enforcement hearings had begun.
Okay.
The lawyer or attorney had been representing some of the shareholders of the company. He was requesting on their behalf a 2-month extension to our deadline, which would have put it to June 16th, 2020. He did not indicate to us when he knew exactly when the courts would resolve their legal issues.
By forfeiting this financial warranty, then, are we negating their other efforts?
This is Russ Means with the division. One of the reasons we went ahead and moved forward with this is because this is not the permittee requesting the extensions, but some shareholders and stuff, and this has been going on for quite a long time. So
Okay.
we made it really clear in December that we would extend until April, and then the extension for 2 months and stuff was, we think we might be able to do something in 2 months and stuff. But since we haven't had any contact with the permittee, the actual permittee, we went ahead and brought this to the board.
Okay, thanks for the clarification.
Any other questions or discussion? Would anyone like to entertain a motion? Would it be helpful, maybe, Clayton, I know we asked you not to share your screen, but your summary slide, I think would be helpful, maybe in entertaining a motion, if you don't mind sharing that again for us. Thank you. Does that help you, Tim? Or do you want the next slide?
Next.
I think we'd like to see slide 6, please. Yeah, that's great. Thank you.
Okay. I'll make a motion that the board find that financial warranty for permit M-2011-029 in the amount of $67,769 is forfeited. Direct the financial warrantor to immediately deliver the financial warranty to the board pursuant to CRS 34-32-118, parent 3, parent B.
Second.
Okay. Motion by Tim and seconded by John. Any discussion? All those in, thank you, Clayton, that was really helpful.
Yeah.
All those in favor, please signify by saying aye.
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 All those opposed, same sign. Okay, hearing none, the motion passes. Okay. Okay, so as noted prior, item number 6, the enforcement hearing for J. Rood has been withdrawn. I think we're still doing okay on time. Everyone's feeling okay. okay if we move on to item number 7. This is an enforcement hearing for Thomas Gravel Pit number 4, file number M-1981-286. Anyone who will be speaking or swearing in, I believe we've got Eric Scott and Russ Means. Am I missing anyone who needs to be sworn in? And Michael Cunningham, is that true as well? Okay. Do you swear to tell the truth?
Yes.
Yes. Thank you so much. Okay. Thank you, Eric. If you can share your screen.
This screen is essentially the copy of the presentation form that is in your board packet and summarizes the enforcement item for today's hearing for Thomas Gravel Pit number 4. Permit number M-1981-286. This is a sand and gravel permit in North Central Weld County held by RWT Excavating and Demolition LLC. The reason for today's hearing is the consideration of violation, civil penalty, cease and desist order, corrective actions, and permit revocation for failure to submit the required 2020 annual report, map, and fees. The legal basis for the revocation is the operator was found to be in violation pursuant to CRS 34-32.5-116, parent 3, parent A and B for failure to submit these required materials, and pursuant to CRS 34-32.5-124, parent 6, parent A, upon determination after hearing that a violation of a permit provision has occurred, the board may suspend, modify, or revoke such permit. The required notification, reason to believe a violation exists letter was mailed on May 1st, and proof of receipt has been included in the board's packet for this meeting. Therefore, the staff recommends that the board affirm violation number MV 2020-007 for failure to submit the annual required report, map, and fees for 2020 in accordance with CRS 34-32.5-116, parent 3, parent A and B. Affirm the cease and desist order issued by the staff on May 1st, 2020. Affirm the civil penalty of $791 issued by the staff on May 1st, 2020. And order that permit number M-1981-286 be revoked. Are there any questions?
This is Lauren Duncan again. You already know what I'm going to ask. Have you had any contact with the operator or any communication at all?
I was able to reach them by phone probably about a month ago, actually, and inform them that these materials were overdue and there was an enforcement hearing pending. They said that they would look into it, get back in touch with us. We have not had any communication or have been able to get in touch with them any further since then. So they were provided with the notice letter for today's hearing, teleconference, also no contact with them since that was sent. So they've sort of dropped off the radar.
Okay, thank you for following up with them.
This is Jill Bernard. You note in your form that the bond is inadequate. How inadequate is the bond?
It's substantially inadequate at this time, and that is due just to the extent of the disturbance. Their original permit conditions limited them to, I believe, 15 acres of disturbance. They have since exceeded that, and this is a high and dry pit in North Central Weld County. So it's not that it's a deep pit. There's the extent of the high wall is probably 6 to 8 feet around a portion of the perimeter of the pit, but they have gone to a disturbance of slightly in excess of 50 acres at this point. So it's a superficial disturbance, but it significantly exceeds what they were originally permitted and bonded for. We issued them a surety increase notice earlier this year, which was due the 22nd of June, as it turns out. They have also not responded to that.
Thanks.
Sure.
Any other discussion? Russ, anything to add? Questions? Anyone feeling ready for a motion here? Does everyone like to have enough information?
This is Lauren. I'd be happy to make a motion, but if you could share your summary again, that'd be very helpful.
Lauren, it's also on page 23 of our packet, if that would be
great.
easier to get.
Yes, it is. All right, great. Great. So I'll go ahead and move that we affirm the violation number MB-2020-007 for failing to submit the required annual reports, maps, and fees for 2020 in accordance with CRS 34-32.5-116, parent 3, parent A, and parent B. I move that we affirm the cease and desist order issued by staff on May 1st, 2020. I move that we affirm the civil penalty of $791 issued by staff on May 1st, 2020. And we order that the permit number M-1981-286 be revoked.
Thank you, Lauren. Anyone second that motion?
I'll second.
Seconded by John Singletary. Any discussion? Okay, those in favor, please say aye.
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 Those opposed? Okay, hearing none, the motion,
Great.
oh, okay, Alyssa.
Hold on.
I was not able to hear who did the motion. And
Sure. Lauren did the motion and John Singletary seconded.
okay, thank you.
Thank you, sorry about that. Okay. So that is, I think this seems like a natural break here while we move into item number 8. We're gonna bring some folks into the room and make sure that's all going okay. So can we make sure that we are back at our computers or wherever we are by 9:45? Is that enough time for folks? What's that enough time for you? 9:45? Okay, thank you.
They never come out one at a time. Okay, we wanted to bring this.
Miss Elizabeth? I just wanted to let you know that I made you a co-host on it, so you can mute or unmute yourself.
Yeah, that was part of my presentation. That was basically it.
Yeah. It's, I mean, it's less weird now because like, at least the outside playing, but you know, during the winter, it was like, and, you know, she can't go play dolls in her house. She can't, I mean, they did let them play outside in the snow, run spaces together, but that's not what they normally, they had played outside and gone over it.
Well, it's just once you
They did a virtual
stuff there and then.
where they have their computers and they all watch the same video.
So what we'll do is, Jason's gonna start just kind of introducing the pre-hearing order. Go with the board on the kind of line over that you filed a motion to readjust the time. Jason, you kind of pre-hearing order. Discussion on that, then we'll then take action on the next order. Petition to correct the order and see. And what is happening. And you guys got the walk. That does have a camera in it, so if you want to be probably speaking, use this chair. Okay. Otherwise, you can just sit in those chairs and all. Take side and say, stand up and back. Say it. Now, you take masks off and the top is what.
And Steve and I talked about doing process remotely for all of that.
How is the sound?
It's good. It's good. I'm glad you got this sharing story about somebody wanting to record it. Run our presentation remotely, so I'm glad that's working.
Yeah, it's even okay, and Kim will allow them to share. So yeah, they want to go to all of that. Perfect.
I can only when you're that. That was for sure. It's scary.
We'll start off with
Yeah.
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 Well, we
don't need to be close to the microphone so that everyone can hear.
This computer also is hooked up to Zoom, so.
Is it? Okay,
presenters
so
in
if
this
they
seat will-
sit there, their face will be there. I'm
Yes.
just trying to think about making sure you folks
Yeah.
are on camera.
Yeah, so anybody sitting in this chair will be
Okay,
seen through via Zoom.
okay.
Okay. They were just trying to figure out the stacking for presenting on the motion. I mean, I guess if no one's touching the computer, probably doesn't need.
Oh, you're talking about like.
Yeah.
Yeah, I don't know if it,
If nobody's touching it and stuff, then we should be fine.
as long as it gets sanitized before.
Yeah, before part of the package is sanitized.
Both hands.
Yeah.
So there's no, you don't have a presentation for the motions, right? It's just the motions are in the board packet. They start at page 190, or somewhere toward the back.
want to make sure so I'm translating because we're over there. How would you prefer I? Do you want to stop? Okay, looking at the screen. Trying to see if everyone looks like they're back. Jason's in the room, Lori's on the screen. Okay. Just gonna wait a second, make sure I've got the full board back. Forrest, are you on? I see your name.
Yeah, can you hear me?
Yep. Yep. Okay.
Okay.
Forrest, Lauren, Karen. Oh, I see her. Okay. Our screen's just a little rearranged, so I'm making sure we've got everyone present. Okay. We are on item number 8. This is a formal public hearing for Continental Materials Corporation, file M 1977-2011. Consideration of a 112C amendment application with an objection. I think the way we're going to start this off is Jason. So for those of you on Zoom, the way that this room is set up, you can see part of us from the board side of things at the tables, but then typically those 2 tables where folks usually sit, we've got the Zoom computers set up there so that they are in the room and on your screen. So they'll be coming up and standing up as well as they speak. So Jason's going to get us started off here. Thank you.
Thanks. Good morning, Jason Music with Division. I was also appointed the pre-hearing conference officer for the Pikeview Query Amendment 4 application. I'm here today to present the revised draft pre-hearing order that was agreed upon by all parties and the division during the pre-hearing conference.
Jason, I'm going to pause you for 1 second, just because your screen says it's muted, so I want to make sure that we're not picking up just the audio in the room. Is it okay?
I think if it's unmuted, it may echo. So
Are you guys okay, Jill?
Yeah, it's fine. I can hear him.
I just wanted to make sure that we weren't missing that. Thank you. Sorry about that.
Yeah. So I'm presenting the draft pre-hearing order for the board's adoption, recognizing that it is a draft and the board at its discretion can adopt it or revise it or amend it. Also recognizing that there were a couple of motions filed concerning the board order. One was some language in the draft order that spoke to approval with conditions. That has since been revised. The board order was revised a few times just to get the dates right, since this order or this hearing was postponed for a couple of months. If there are any questions on that board order as it was revised, or if there's any questions on the timing.
I think we need to speak up a little bit so our court reporter can get everything. I may have spoken too early that we could hear you.
Yeah, good. Yeah. So that's basically it. If there's any questions on that order, I'm happy to address them prior to hearing any motions on the time.
I guess I just have a question on swearing people in, just since we've in order to kind of be able to see people face to face, you've just got this screen. Would we like to do everyone that's in the room currently right now, or would we like to swear people in as they sit in front of that computer?
My recommendation is kind of we, once we're on the other side of the motion,
Okay.
getting ready for the actual public hearing.
Okay.
To just go ahead and swear everyone.
I can't hear you guys at all. That's going on in the room there. I'm having a real hard time hearing you at all.
Yeah, sorry. I'm just trying to make sure, just knowing that we have people in the room that are going to talk and discuss these.
Yeah, everybody on the Zoom, I can hear very well, but in your room, you're all going to have to speak up.
Okay.
I was just saying, my recommendation is to go ahead and swear folks in after we move the part and go ahead and do it over Zoom. I think we'll be able to see everyone. The witnesses are either going to be in this room or downstairs at the time, so we should have eyes on everyone. It should be okay.
Okay. Sorry about that.
That's okay. No questions for me.
Okay.
Try not to touch anything. Morning, everyone. Scott Anderson. I'm counsel for Continental Materials Corporation. We did make a motion after the pre-hearing order, the draft pre-hearing order was issued. Really just goes to timing. Originally, the pre-hearing order has about 6 hours and 5 minutes allocated for testimony. And again, that's just testimony. So there's dead times of moving people in and out. There's deliberations, whatever you take as a lunch break. And frankly, part of our motivation in doing that was to make a virtual hearing more efficient. We really try to make it possible. Well, here we are. I will say that I think 6 hours of testimony is still probably excessive, and I think we're gonna have trouble fitting it in today. If you look at page 189 of your materials, that's where we set up a schedule that comes in at about 4 hours and 25 minutes. You know, obviously we'll do whatever you guys want to do, but we do think that we could do this more efficiently, and you know, we'd be happy with the schedule. We try to keep it all proportional, you know, the same proportions that we had with the 6 hours and 5 minutes. So that's the major motion. Mr. Music's right. We had one concern about drafting that's been taken care of, so that's no longer an issue. So anyway, we would recommend a shorter time period, maybe somewhere in between there, but recognizing that you have to manage to your deadline today. And the only other thing we'd ask is you kind of keep those same proportions on time so that we're always the third one to speak, and we're a little worried about getting squeezed out on these. So we'd like to make sure, you know, we're protected that whatever time is allocated, we've got our fair share of that. So that's it for me on the motion, unless people have questions about that.
Good morning, members of the board. My name is Steve Mullick, and I represent Warren Dean, who's the objector here. We have down in your pre-hearing order that we'll have 90 minutes for presentation of our witnesses. We need that much time. I do anticipate this hearing will go shorter than probably the fully allocated time, predominantly because of rebuttal. We have a fair amount of time on both sides for rebuttal. And so we believe that we'll get finished today. It should get finished today. But I wouldn't agree to condense our presentation. We need that full 90 minutes to put 3 witnesses on, plus my presentation.
Okay, so essentially you're saying that on that chart as laid out on page 189 of the board packet, just line number 3, presentation by Mr. Dean. Initially it's drafted at 90 minutes. The CMC proposed allocation is 60 minutes. You are saying you need 90 minutes.
Yes, ma'am.
Are you feeling like the other proposed times are adequate, you know, rebuttal from 45 minutes down to 30 minutes? Does that
We can work with that.
feel appropriate to you? Were there any other outliers in that outside of your presentation?
No, otherwise we're okay.
we have other discussion about, asking for the, initial 90 minutes by Mr. Dean?
Sorry about this, but we probably need our 60 there. And again, I don't know that we have 60 minutes, which also includes time for cross-examination. And given we don't know everything that's going to be said in those 90 minutes, I think preserving that 60 minutes for us on the direct, I'm more than happy to take the rebuttals down to 30. I don't think any of us expect to go 45 minutes in that part anyway. So that'd be certainly one place to save some time. We'll try not to use 60, but I just, given the uncertainties, I'd like to be able to keep that, just to keep that balance in place.
So you're saying you would feel comfortable that, again, I'm referencing page 189, says presentation by Mr. Dean, draft allocation 90 minutes, that presentation by CMC, draft allocation 60 minutes, and then everything else in the right-hand column, including introductions, rebuttals, closing statements, fall more into that 30 or 10 minute. Maybe we can do math as appropriate there. And you are going to be the timekeeper on that sort of thing. Any other discussion, any questions from?
That's what the division
yes.
thinks about all of that.
Jeff Hugo here on behalf of the division. First, it's good to see all of you. I appreciate the patience in working through this process. On behalf of the division, I do agree with the kind of the underlying theme of the motion that a 6-hour hearing on this matter is excessive. You know, we're fortunate that there are no other matters set on today's agenda, so we do have some flexibility on the time. But I think at the very least, the division supports the board affirming 30 minutes for rebuttal time, and with the assurance from the parties that we'll try to trim time where we can throughout the day. I also want to confirm on the record that board questions will not count against parties' presentation times, but the cross-examination time does. I think that's the parties' understanding. So with that would just be the questions that you
I need you to speak louder. I cannot hear you.
The request that you modify the rebuttals to 30 minutes a party and closing statements to 10 minutes per party. That will turn up some time. And then we'll try to shuffle people in and out as quickly as we can.
Thank you. So this is a motion. We do need to. Okay. Board discussion on the motion as it stands with 90 minutes for a presentation by Mr. Deans, including cross-examination, but board questions do not count against that time. 60 minutes presentation by Continental Materials, same thing, board questions do not count against time, but cross-examination does. And adhering to 30-minute rebuttals and 10-minute closing statements. I have to say I have not totaled up that new math, but if anyone wants to clarify that for me, they're welcome to.
This is Jill. I move to approve the pre-hearing order with the amended times as you just laid out.
Okay.
Second.
Okay, a motion from Jill and a second from John. Any discussion? Okay, all those in favor, please say aye.
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 Those opposed? Okay, hearing none, the motion passes. We will move forward with the time as proposed. Making it a, keep our time tracker go. About 5 hours, is that what it comes up to? Okay, so. And then back to Jason.
No, Jason's gone. You don't have anything that's
Right. I didn't know who was speaking of that, so. Oh, okay. Thanks.
Morning again. Yeah, I think because it's our petition, we probably have the opportunity to talk about it first. I'm going to do this very efficiently. We've had a look at it once before.
Please identify yourself.
Oh, sorry. Scott Anderson, counsel for Continental Materials Corporation, the applicant here for the permit, and also the applicant for this petition. So,
You talk a little louder.
Yeah. Okay. We'll get this all figured out before we're done today. 5 hours.
5 hours.
Yeah. So thanks for that. We have, the issue is fully briefed. Materials are in your packets. Our petition is at page 193, and Mr. Dean's response is at page 205. I'm not going to take you through the entire line of argument, although if anybody have any questions about kind of the logic of this. I want to talk briefly about the substance and then talk a bit about the process and where we're at procedurally. And again, the fact that we're here today kind of changes the dynamic and the nature of the decision. Just briefly on the substance, it's clear under your rules that not everybody gets to be a party, that you have to be aggrieved, adversely affected under your rules. And as a result, there's a test that a party has to meet. And an objection can only be made by a party. That's why this matters. It's also clear under Colorado law that the interest of the individual has to be something different than the interest that any other citizen would have. It has to be peculiar to that particular applicant or objector. And here, the one advantage we have from having filed our petition is that in Mr. Dean's response, he makes it clear that his interest in this is no different than any other citizen of Colorado Springs. He tells us he owns property in Colorado Springs. You can see the Pikeview Quarry. He said if the bond is inadequate as a taxpayer, and every taxpayer in Colorado would have to pay, make up the difference if the bond is inadequate. And he says he's interested in conservation, which again, you look at that Colwitz case, that's really why Ms. Colwitz lost her chance to participate, because she didn't have an interest any different than the citizens of Boulder. And here, Mr. Dean doesn't have an interest that's any different than any other citizen of Colorado Springs. So he doesn't meet the test of a party. So that brings us to the process. We filed this petition for declaratory order. I know Mr. Mulliken may tell you that it's not a proper process, but it's a separate process from the motions process that follows a pre-hearing order. It's there to terminate controversies, and that's what this would do. I would say that given we're here today, we're ready to do the hearing, there are kind of two options. One is you could look at the petition for declaratory order and simply decide it now. Then there wouldn't be a hearing if you decide that in fact it's not a party. You can also fold it into this process. And I got the impression when we talked about this a couple months ago that that was the thinking under Rule 2.53, that we have this formal process, you can decide it. Our view is that the other alternative would be to simply fold it into the process and put it into your deliberations. We think you're going to be happy with the permit amendment, and if you decide that the permit amendment is appropriate, you could also decide that Mr. Dean's not a party as an alternative basis for upholding the application. You wouldn't necessarily have to not decide the permit issue and do that at the end. But we're here today, we're ready to go, but we do think that it's a jurisdictional issue. Even if we didn't file our petition for a declaratory order, it's really something that the board has to figure out whether or not, objective. This is again unusual because you just have the one objector. But I think it's an issue that you could decide entirely on your own without any petition from us. And so our recommended alternatives would be to decide it now based on our petition, fold the issue into your deliberations and decide it as part of this process. And given we're here and ready to go, either approach would be acceptable to us. So that was a very quick tour through that, trying to be efficient, but happy to answer any questions about this issue, or again, provide more detailed analysis of the logic to it if that's useful.
Any questions?
This is Forrest. I guess I would be interested to hear what the lawyers have to say about this, the ones representing the Mineland Reclamation Board and DRMS.
I also think Mr. Mulliken probably has some thoughts that might be slightly different than my thoughts on this.
Mr. Anderson, before you step down, I had a question. This is Jill Benord. When you're looking at directly or adversely affected, at what point, who would you say would qualify to object? I don't think you're saying only immediate landowners, but how far does that go?
Right. No, the definition of aggrieved is actually a fairly broad definition. And it includes people with aesthetic interests, people with conservation interests. But again, it's, directly or prospectively directly affected. And that's where that Colwitz decision really kind of helps us draw the line. I think if you were someone who lived in the area and looked at the mine every day, and again, the other point on this is that, the objector has to demonstrate the interest. So I think it's a fairly broad standing test. But there has to be something that distinguishes the objector from everybody else, where they have some direct impact. But the definition of aggrieved, a very broad definition that includes aesthetic issues, conservation issues. So a lot of folks could meet the test, but Mr. Dean doesn't.
Okay, thanks.
Forrest, I think we will have an opportunity to get the thoughts from the Mineland legal. Any more questions for Mr. Anderson?
All right.
Okay.
Thank you.
Yes.
Take off my power mask. Good morning again, Steve Ellikin for Objector Warren Dean. We did file a full brief in response to this motion, and I'll incorporate that by reference. I'll try to be brief, but we think this is a motion that clearly should be denied. The petition should be denied. What it is ultimately is an effort to silence public comment, to silence my client, Warren Dean, and that's wrong. First of all, technically, this was styled as a petition under Rule 2.5. It is wrongly a petition. It really is a motion to dismiss us as not an aggrieved party and therefore having no standing in that. Motions were due by March 16th, according to the pre-hearing order. So this is the motion when it was at least a month late when it was denied. It should be denied for that reason alone. Additionally, we think at this point in time, any right to try to dismiss Mr. Dean has been waived by the applicant, by Continental Materials. Mr. Dean has participated in this process since June of 2019. We're not new to the table now. He has been in this issue since the challenge to the adequacy of the bond. They've known that. Mr. Dean has spent money, hired witnesses to try to silence that voice now. They should have waived their right. As I think was admitted by Mr. Anderson, the definition of aggrieved party is a very broad definition. It's currently or potentially aggrieved for economic, aesthetic, ecological interest, and Mr. Dean has all of those. I think they made their motion saying he doesn't live next door to the mine, and he does not. He lives south of the mine. He has commercial properties that look at the mine. He's got business interests in the vicinity of the mine, so he clearly is an aggrieved party. Also, from the standpoint of the ecology, Mr. Dean has great interest in that. He's currently on the board of the local chapter, Colorado chapter of the Nature Conservancy, as well as on the board of Great Outdoors Colorado. So he has those interests as well, and he represents citizens that have those types of interests. So I think he meets the definition of an aggrieved party, though he should not. And the last thing I would say to you is this is a very technical interpretation of the rule that's being thrown out. It's being thrown out to really silence the public. I know that's not what this board intends to do. You give public notice so people hear about these things and they can come to speak to you. And we have very, very important information you need to hear today. So I would urge you to deny the motion. You obviously need to get your own legal advice, but it is a motion. It's untimely, easy to deny just on that basis. Lastly, we did in our response also say, well, to the extent you're moved by this motion, we filed a petition to intervene, which is something you can grant in your discretion. And if you're troubled by their motion at all, allow us to intervene because we should. You need to hear what we have to say today. Thank you very much.
Any questions or discussion for him? I know Forrest was looking for some clarity.
Jeff Hewitt here on behalf of the division. Division doesn't really take a position on the motion for party status. We often don't. Standing is something that the board does consider fairly infrequently. As the board's aware, standing for hearings in the administrative process is not a high bar or burden, but the objecting parties do have the burden to carry here. So I think that both the operator's brief and the response give you all of kind of the outlines of the rules, the relevant rules here for party status and whether or not Mr. Dean satisfies that effective or agreed status. Unless the board has questions of staff, we're taking a position on this.
Jeff, with the late filing, doesn't it have some regarding the, and plus we're a public board, we entertain everybody, that's why we advertise, but wouldn't the late filing kind of disqualify it? They're almost a month late, that's the way I read it.
At this point, it was filed as a request for declaratory order under Rule 2.5, which is a separate process. I think Mr. Mulligan indicated that it could have been, and he argued maybe should have been filed as a motion to dismiss, which would have been under a different motions process under Rule 2. But as filed under the declaratory order, it's on its own timing and schedule. Obviously, the board, and I'll defer to Chuck on legal advice, you could consider it untimely if you want to interpret it as a motion to dismiss rather than a declaratory order. It was filed as a declaratory order.
And just an aside, I appreciate your seriousness with regard to coronavirus. See, I haven't gotten a haircut.
Yes, thank you. My wife will disagree that it's a good thing.
Gotta have another levity.
Okay, thank you, Jeff. Anything else from the board? Questions while he's sitting up here? No.
Thank you.
Okay. So we have a couple options here on the table for deliberation, discussion, understanding. One option is the board could go into executive session for advice from legal counsel. So that's one option, or we can just have a broader discussion here. I don't know, we'd appreciate feedback from the board on what they need for what kind of tools you need to have the information. Does anybody strongly feel they would like to go into executive session? I'll ask it that way. Okay. By your silence, I'm going to.
Madam, this is Karen Utterback, Norman. I have a question, and it may be a fine point that has escaped me. Is this not what we talked about last month? And the board made a decision about letting the objector participate. Are we not rehashing the same thing, or have I missed a fine point here somewhere?
Go ahead.
Karen, this is Chuck Hoyman. Yeah, you are right. This is, as Mr. Anderson mentioned, the board did consider this, and the decision of the board at that point in time was to not entertain the petition, and because of the way the deliberations on the motion was teed up, a lot of the consideration for the the board in not deciding the petition at that point in time was kind of based on the fact that it involves a matter that is pending before the board, and that's what we're here to do now. And I think Mr. Anderson was making the point at the beginning of his presentation today that, you know, the board, they're suggesting that the board can do one of two things: either rule on the petition now, which would be kind of different from what the board decided previously, or simply take it as part of the presentation. And so that could get folded into, you know, in order on the application, you know, whether it's just a simple, whatever the board, after deliberation, the conclusion they come to, whether or not Mr. Dean has party status, that can be folded into a board order if, as you put it, rehashing it right now and kind of deciding the actual petition and banging through it is not what the board wants to do. It can become part of the board deliberation at the, you know, kind of after the presentation, sort of look at the merits and at the same time determine whether or not Mr. Dean has party status. And so that's kind of where we're at.
Thank you.
Does that help clarify a possible kind of two separate paths forward that we might be able to discuss? So we can either, to Karen's point, go down this path somewhat again right now, or we can fold it in to the order and hear this and make it part of the discussion.
Tim Mock here. I think I would support rolling it into as part of the process. Gives us an opportunity to hear some of the presentation and get a better understanding of the party status.
Okay, I mean, I just don't see how we can avoid letting people participate in the public board. That's all right with me.
And John, make sure you lean into your microphone, okay, just a little bit, just so that everybody can
Did anybody hear that?
Yeah.
No.
I just don't see how we can deny people when we advertise it and people are on the internet. But this is a public board, that's what we listen to, but I concur with Mr. Mock if that's what the board would like.
Further board discussion? We feel like we're at a time where we could, someone could make a motion to this. Jill, I can tell you're thinking.
Sorry, this is Jill. Are we gonna hold on a motion until we talk about it later? I thought that's what I understood.
Yeah, I guess I just want to know, do we need to formally say that we're doing anything with this?
Oh, I see.
We say this we're going to, I guess I feel like if we're going to say we're going to fold this into the conversation, there's a bit of a roadmap to say, here's what we decided to do and here's what we will honor at the end of this conversation. So maybe it's not a motion, maybe it's a.
I think that's fine.
Okay, so maybe we won't make it a motion, we will just reiterate what we're intend to do.
Yeah, this is Chuck. I think either way is fine, just for the sake of clarity. I mean, the board's decision last time was to not consider the motion. So maybe since that is on the record, the cleanest thing to do would be to just go ahead and have a motion to fold the consideration into the merits of the application. We'll take it from there.
Jill, do you feel comfortable with the motion along that line?
Yeah, that's fine. I will move that we hold consideration of the motion until board deliberations.
Discussion?
I'll second.
Oh, okay, you're seconding. Thank you, Karen. Okay, those in favor?
Aye.
Aye.
Are there any opposed? Okay, the motion passes. Thank you very much. Thank you for the time in considering that. Okay, make sure I've gotten all my eyes here on what we've got to do next. Russ, do we have anyone moving in and out of rooms right now?
Yes.
Okay. We are about to move some people in and out of rooms, which is, we'll figure out how long this transition actually takes. We don't really know. But we think about 5 minutes. So if you need to stand up for a second, please do that. And we will resume at no later than 10:25.
Hey, Candy? Can I just, for those of us sitting here, is the sound being picked up by that computer?
It's this mic and your mic is up there.
I'm sorry, say that again?
There is a mic here and then your mic's there.
That's the camera.
That's the camera.
It's actually, it's coming through the speakers.
We can't turn this one on because that's how we get.
Right, but the sound that, for the folks on Zoom, they're catching it through the computer, not from the microphones into the system, correct? It is, the system in the.
Yeah, so we've been trying to figure out how to turn it up because there's no metal button on the receiver. Without them?
Yeah, Chris Aaron was texting me saying, hey, it's hard to hear. I was just wondering if we were supposed to speak up loud enough to catch the computer microphone.
Well, we were like, okay, so what I'm trying to do is actually get some more mics out so that there are more individual mics. Hopefully this will work. We tried to figure out where the volume was. So, you know, it's like everybody just has to speak up.
Yeah, I mean, as long as, get it, we're okay, but
Well, and I like how she's been.
yeah, it's work for all of us to talk about it.
Yes.
Talk about it.
That was my takeaway.
And that's just it.
Anybody can vote on
Anybody
can vote on it.
We need to do like the best girls coming into spring break. And.
I know we held some presentation on it, so I like to figure out our intro.
One real quick question, and that motion and stuff to trim
I already
time and
did it.
stuff.
Yeah, I
They
did.
cut us by 5 minutes, and we didn't really get a chance.
I think
to
next
comment
time we
on
do
that
this,
presentation-wise.
I would do the microphone straight
So
into
we're
here.
kind of right there. We're-
and not
we'll
use
be
that
at
one.
the same time as everybody else. Stuff
You know what?
Next time I would do the microphone from the
We
room
should be able to-
straight in
We're
here.
right there, so.
Okay, like
Yeah.
old times.
Huh?
Like old times.
Yeah, we'll try that next time and see if we can do that.
Is there
Like
any
that
way
one.
for us just to plug it in now?
I don't want to do it and lose what we have.
Okay.
Yeah,
Just wanted to make sure.
yeah. I
I know you
just
said
don't want to
something
lose
right.
what's working right now, but we'll try it after we're done today. But just adding microphones is going to help.
Okay, yeah, that's what I did. I might have to steal some more batteries from you. I've got four.
You don't need one.
That's fine, but you know, you could actually, I was thinking about giving that to Chuck, and that, because for the 90% of this, I'm not gonna say anything.
If everyone's done got one,
Yeah.
so
Nell's
that's
got
one.
one.
Yeah, so if we could get one, we have more in the box, don't we?
With one more.
And we have more batteries, right? Yeah,
I've got one more thing of batteries. This is it.
Can we fire that up?
I've already had to change most of them.
Yeah, I do think if each of us had a microphone, that would be.
That is more, that's what we were
Yeah,
just
because the
talking
way
about.
that it's set up is what you're talking through the microphones is hitting this speaker and then this microphone is picking it up. So, yeah.
It works.
It's not a direct.
I'm sorry?
It's not a direct wire.
Right, right.
We're
So
gonna,
next time-
next time.
Next
we're
time I
gonna-
will definitely do
Oh
it
my
differently.
I'm thinking lavaliers after.
Well, I think that if we just run these microphones straight to this laptop, we should be good.
Okay.
But I'm hesitant to change it now because I don't want, yeah.
No, it's working enough now, and I think
Exactly.
that people are comfortable enough that I think they'll say something.
Yeah.
And if you, yeah, Tammy, if you can just keep an eye, and I think, you know, it's a little rough now because when these guys are talking, they're the big screen.
Uh-huh.
So you lose a little bit of that whole
Yeah.
board view, which
Yeah.
is what it is, right?
Yeah.
Right now, unfortunately, yeah.
But I think
We're
that
learning as we go.
I've been listening in, and the only person I'm having
Oh.
For those on Zoom, we're just making sure this room's all ready to go. You just got the thumbs up. Okay.
Just gotta make sure you turn on.
So one thing I was noticing, you know, how when the person's speaking kind of takes up the majority of the screen. So because essentially that table is showing the main screen, I am not seeing all of your faces on the board. If you're having trouble hearing something, can you please send a chat really quickly? Because I think that'll be the fastest way to see it, since I can't see if you unmuted yourself immediately or whatever. If you can't hear something, if you need something repeated, if you didn't hear who did the second, whatever it might be, send a chat. Cam, you'll keep an eye on that, and hopefully that'll help us going so I don't lose you. And the way we're going to kick this off now, we believe that we've got everyone here. So we have some folks down in 220. We have folks here in the room. I believe there's some folks here on Zoom. If you intend to speak during this hearing, I'd like to swear everyone in at the same time. So those of you who intend to speak, please stand. Do you all swear to tell the truth?
Yes, I do.
Okay, thank you, everyone. So we're going to do an introduction by the division and maybe go into the presentation by the division. About 40 minutes total allotted. Okay.
please, just a reminder, please introduce yourself, even if you come up to the mic several times, just so that we've got that really clear. Yep, you're good to go. Thank you.
Good morning. My name is Tim Kazare. I'm representing the division in this matter. I am a registered professional engineer in the state of Colorado. I've got a master's degree in environmental civil engineering and about 25 years of experience in the mining industry. So what we're here today to talk about is the formal hearing for file number M 1977-211, Amendment 4, Pikeview Quarry, Continental Materials Corporation, and consideration of amendment application. So, today's hearing is screen is too small. I don't have my reading glasses.
Want to borrow mine?
That's okay. I'll just move the microphone over here and bring up the screen. So today's hearing is for board decision regarding amendment number 4, where an objection was received. The categories of the issues brought by the objector include geotechnical concerns, the reclamation plan, hydrology, financial warranty, and a request for some clarification. The division has recommended approval of amendment 4 as outlined in the division's recommendation to approve a 112C permit amendment application with an objection sent to all parties on March 6, 2020. There's a more detailed chronology in your board packets, but I'll just hit the highlights here. Continental Materials Corporation submitted a 112C amendment application for the Pikeview Quarry in response to July 25th, 2019 board order, directing the permittee to submit an amendment application within 60 days of the June 26, 2019 board hearing. On September 20th of last year, division called that application complete, and on 9 days later, after the board hearing in September, the board issued an order affirming a stipulated agreement requiring a permittee to submit an additional financial warranty of $6,924,090 within 60 days of the effective date of the denial or withdrawal of that application. On September 28th, the permittee published the first of 4 consecutive public notices of the application in the Colorado Springs Gazette. On November 8th, the public comment period ended with the division receiving 1 objection and 2 agency comments. Those agency comments are from the Division of Water Resources and History Colorado. On December 16th, the permittee requested an extension of the decision date, which was December 19th, to January 18th, 2020. 2 more extension requests were received on January 21st and January 31st, extending the decision date to March 6th, 2020. 3 untimely comment letters were received from the objector after the close of the public comment period on January 14th, February 19th, and February 26th. On February 28th, the division received an objection from the permittee citing the untimely comment letters and questioning the objector's status as an aggrieved person. We heard earlier. And on March 6th, the division found the applicant had addressed all the adequacy concerns and pursuant to CRS 34-32-115 parent 4, issued its recommendation and rationale for approval. So here's a slide 6 shows as a location slide. Pikeview Quarry is outlined in light blue in the lower left. The Air Force Academy is highlighted in a yellow dash line, and I-25 is also highlighted in a yellow dash line. The permit location is about 4.5 miles south of the Air Force Academy. Brief summary, permittees, Continental Materials Corporation. The permitted acreage is 240.5 acres, which is also the maximum lot effect acreage. Current affected acreage is about 160 acres. Primary commodity is limestone. Post-mining land use is wildlife habitat and recreation. And the division currently holds a financial warranty of $15 million. As to permit in disturbance areas, slide number 8, there's a light blue line showing the permit boundary. There's a yellow line encircling what's known as the slide area. At the base of that, or on the slightly to the right, is what's called Area H, named after what was a hole that was caused as part of the slide. Then in a light brown or tan outline is the currently disturbed area, about 160 acres. Set conditions, this is a pre-law mine, operations beginning around 1900. The disturbance expanded to roughly the current footprint in the 1950s. As part of that was construction of the Air Force Academy. Several slides have been experienced historically, and multiple investigations were performed on site stability. Active mining or excavation in this way at the site has ceased. Material from part of stockpiles though is still being sold. The current focus of the site is on reclamation. So in 2020, we did an aerial inspection. This is in January 24th. This is a view on slide 10 from to the west of the site. There are 4 blue arrows with white highlights around. These show the various drainages that are up gradient of the site. There's a red arrow in the middle that shows a distance of approximately half a mile from the site to the neighborhood down the hill. Give you a quick overview on Amendment 4. Final Materials has worked to address the stability issue since Amendment 3's approval. That was in 2013. Amendment 4 is a less invasive reclamation plan that disturbs less land but still ensures safety. Backfill of the pit area, place an engineered fill from the bottom up to cover the buttress, the landslide area. Grading to be completed using traditional construction equipment with minimal blasting. And weather granite, which is on the uphill side, will be pushed downhill to into place or loaded in trucks to be transported to the fill zone rather than being pushed all the way downhill, which is what was proposed in Amendment 3. Drilling and blasting will create rock slopes with an overall slope of 1 foot horizontal, 1 foot vertical. The slope will contain rock high walls and vegetated benches. The lower slopes will be backfilled and graded to approximately 2 1/4 horizontal to 1 vertical. Slide history. There are 2 slides experienced in the mid-70s and one in 1993. The most recent in 2008, 2009, and 2015. At the time of the 2008 slide, quarry was excavating material in Area H, the hole, which I showed you earlier. Geotechnical investigations were performed by multiple consultants. 2008 slide investigated by the Chronology Survey as well as MSHA, Mine Safety and Health Administration. Amendment 3 and technical revisions 12 through 16 were submitted to address the 2008 slide. This is another January 24th aerial photo looking south on slide 13. The slide area is encircled by a red dash line, and Area H, that was the hole, which is mostly now backfilled, is a yellow dash line. I just wanted to point out here that you can see the effects of the slide, but none of the slides that occurred on site have ever had any off-site impact.
Sorry, can you repeat that last thing you said? You can see the what?
None of the slides that have been experienced on site to date have had any off-site impact. In other words, all the slides that occurred of all the impacts have been within the permit boundary and nothing off-site.
Thank you.
After the 2008 slide, Geological Survey investigated and found the quarry wall failure was a combination of the steeply inclined strata that daylight into that Area H hole inherent weakness of the rock mass caused by the round part range fault zone. So this is occurring in a fault area. The loading excuse me, of the upper core benches was spoiled. So there was some material that was deposited at the top. Then there's potential rock damage at the toe of the slope from production blasting. This is in the area H hole. And effects of water from the offsite drainage swells. Those are those 4 blue arrows I showed earlier. And then the undermining and steeping of the rock slope in area H. So the CGS investigation recommended primarily 3 things. A monitoring plan being implemented, incorporating a continuous monitoring system, fill area H to buttress the existing rock slide, and leave the upper scarp and tension cracks at secured long-term hazard zone with an ongoing monitoring program. And then fill area H and begin excavation above the highest tension cracks and lay that slope back. Likely require an additional area and a Forest Service owned area or managed area to the west above the mine and pioneering new access ramps adversely raising the visual scar of the mine. All applicable CGS recommendations have been implemented. And there was an additional investigation by CGS in 2009 following that slide, and it didn't significantly revise the findings from the 2008 slide. So the monitoring system was put primarily in place for worker safety and not for submitting information to the division for reclamation purposes. And the CGS's recommendations were geared towards an ongoing mining at the site and not where we are now, primarily focused on reclamation. So slide 16 is another aerial slide from our January 24th flyover. This is looking more towards the southwest. The dashed yellow line is a cross section that was analyzed. There's several cross sections analyzed for slope stability, but I'm pointing out 2 of them here: the dashed yellow line and the dashed green line. And I think that's 2 important issues on that slide. So this is a geologic cross section map. Different colors denoting different geologic features, but the 2 high sections that were pointed out in the previous slide, section E, which is the yellow line, and section C, which is the green line, are 2 of those sections. You can get an idea of where they, what areas they go through. That white area in the middle, that's the slide area. So these cross sections, this is cross section CC. The important thing note here are the big red arrows on slide 18 show the fault zone. That's the Rampart Range fault zone. And then the various colors in the middle show the mine commodities, the limestone that they're mining, and the steeply dipping beds that are subject to the sliding problem. The next section on slide 19 is that section EE that goes through the slide area. So the white hatched area on the middle of the slide is that's slid. And then at near the bottom, near the purple zone is a red outline that's the area H excavation area. And again, the Rampart Range fault zone is pointed out with the 2 red arrows on the left and the right. This is a slide from one of the investigative reports. This shows the hit before the slide in 2008. Important thing to point out here is the material that shows some erosion rolling in the middle is material that's pushed down from the top and not actually a failure or a slope failure. Slide 21 is an aerial view from December 2008 after the slide fire. You can see the scarp point here. This is the area that fractured and material is what slid. At the top of this, there's three yellow arrows pointing to a tension crack. This is a pretty significant crack and part of what the ongoing concern was. So that's just for future reference. Slide 23 shows the monitoring locations, all the vertical black lines. There are arrows with each one has a monitoring number and showing a relative location in that slide where those monitoring instruments are placed or were placed. Slide 24 shows the current slide monitoring locations, and with respect to all the red dots are where we currently have monitoring.
I can jump in with one more question on that last slide with the red dots. Are there monitoring locations on that cracking area that you mentioned in previous slides? I just can't tell.
There's one, yeah, there's one above it, right over here. I believe that's about the right spot, and one right on the. It's hard to tell with the scale whether it's above it or below, but I believe it's above it. And there's a couple down along the edge of where you can see some revegetated benching here to the side. There aren't any monitors really in the slide area because those are difficult.
Sure. Okay, thank you.
So here's a slide 25 is a monitoring example of a graph of what some of these different monitoring locations have shown. This is a 4-month period in 2008. So as you go from left to right on the graph, it shows the displacement of various monitoring or prism locations. You can see some of the stuff at the top is stable and not moving, but there are others like the yellow and white line that move quite a bit in that period from January to end of April 2008.
Just a quick question on that. You said January to April. Do we notice more sliding freeze thaw or thaw at all?
I've had several discussions with and so part of the monitoring system is put in place to detect movement. So some of that can be just like you said, freeze thaw or thermal action. Sometimes it's even they'll pick up. There's a glass in front of the theodolite that scans these, and as that glass heats up, there's a thermal impact. So that's why you see, like especially on the top of this graph, it's kind of jiggly. There's a lot of noise. So the important thing to pick up when you look at the monitoring data is, is this movement due to just thermal impacts, or is this something that's actually moving? And so it needs a trained eye, a technical specialist, a geotechnical engineer to look at it and determine what if anything, is actually moving.
I've just seen some of these faults sometimes, especially in the winter, you kind of get this ice band behind it, and it'll really start to kind of go in your runoff season, just naturally,
sure.
But especially in these fault zones. So that's why I was wondering if there was a seasonal impact there.
There's a lot more impacts than that, and then so it's kind of weeding the chaff from the wheat sort of thing is what it boils down to. So.
Fair enough. Oh, John.
You're continuing to monitor that since 2008?
They have monitored, and this is, I guess, important note on this, is that none of this monitoring data is required to be submitted to us. We haven't been monitoring it. This is primarily put in place for worker safety, so there's a check. They'll check every day before they go into green mining, and they do a periodic survey of the surface using drones and whatnot to compare that. And then there's the continuous monitoring system that will let them know if something's moving, and they've got which I'll get into later, a criteria for when that needs to be. But this is not something that's been required to be submitted to us because it was for worker safety and not for reclamation monitoring. So slide 26 is we're going to cover some information on concurrent reclamation. So the mining in the south end was initiated in the mid-1990s. The concurrent reclamation there was well underway in 2003. Again, post-mine land use as wildlife habitat in that area, and bighorn sheep regularly are seen in that south end. I'll show you some slides here. This is a Google Earth image from 1999, as far back as we can go. There's on slide 27, there's a red dashed line encompassing the lower left of the site that encompasses the area that was starting to mine in 99. And just keep your eye on that red area there. So in 2003, which is the next available Google Earth image, you can see that there's benches there, and they've already got some vegetation on those. So in the span of 4 years, they mined it and got vegetation established on the upper benches. Then it continued on in the next image was in 2011. Again, that vegetation looks pretty well established, and they're trying to put some backfill in the lower part of that slope. And then in 2017, continuing to grade the backfill at the south end, and the vegetation is still pretty well established on the upper benches. Then I was out there on a January 8th, 2019 inspection and saw a large herd of bighorn sheep out there grazing that area. That big, massive rock in the background is part of the slide area. So the issues identified here for the pre-hearing conference were geotechnical concerns related to engineered backfill, slope monitoring, and the stability analysis and demonstration of such. There were reclamation concerns related to performance, vegetation, and topsoil quality and care, as well as bar area reclamation. There were concerns related to storm water with respect to eroding topsoil and backfill on the steep slopes, and concerns related to the hydrologic analyses and hydraulic design of the stormwater control. There's a concern over or a question as to whether the reclamation process was adequate, and then the final one was requesting some clarification on the tree exclusion in certain areas. So the current status, the mine is in final reclamation. Area H has been backfilled. The last slide occurred in 2015. No damage to offsite areas or to structures has occurred as a result of any of the previous slides. And the division holds a bank warranty amount of $15 million. Any questions on the intro? I'll cover in a short period of time.
Minimize on the top.
Oh, that's okay, did everybody see the presentation then?
Let's make sure we got. You need to go back. You need to go back and then hit share screen. All to the right.
Oh, there it is, yeah. All right, want to go see the presentation now? All right, with that introduction, again, the main part of the presentation here. So the purpose of this hearing is for the board decision regarding amendment number 4 or objection procedure. There were 5 categories that were brought by the objector, which is covered, and the division has recommended approval of amendment 4 as outlined in the division's recommendation to approve a 112C permit amendment application with an objection sent to all parties on March 6, 2020. Again, just a quick outline of the site. Slide number 3 shows permit boundary in light blue, area H in that dashed black line, and the slide area shown in the yellow area, yellow hash or yellow outlined area, and then the disturbance area in the light tan or orange. So there are 5 general areas that we covered in the pre-hearing conference. You want me to go through these again? I think we just covered that, so no objection, we'll skip through that. So I'm going to get into the specifics here. So related to geotechnical concerns, there were the 4 different areas. First is engineered backfill. So some of the comments or concerns were all fills should be engineered and compacted to ensure it will hold back the sliding material and provide a stable information area, and to ensure that there are commitments by the operator to adequately demonstrate that the engineered fill is placed. Hold on.
Exactly.
Just technical difficulties on our screen. Just a second.
Not quite sure why I did that, but there you go. Pretty much.
So the second concern there was related to the ensure whether there are commitments by the operator to adequately demonstrate that engineered fill is placed in a verifiable manner and that there are adequate tests to demonstrate final stability. Statutes that support this are CRS 34-32.5-2016, parent 4, parent J, and Construction Materials Rule 3.1.5, parent 3. All grading shall be done in a manner to control erosion and precipitation of the affected lands, to protect areas outside of the affected area from slides and other damage. If not eliminated, all high walls shall be stabilized. Then there's Rule 3.1.5, parent 9, parent F. If an operator intends to backfill inert structural fill generated outside of the permit area, the operator must provide the office notice, which must include a general engineering plan stating how the material will be placed and stabilized in a manner to avoid unacceptable settling and voids. As to the demonstration of adequacy for engineering backfill, the imported fill, which is approved in technical revision number 19, be sampled and analyzed by a geotechnical laboratory for important properties, including shear strength, particle size distribution, and standard particle density for purposes in determine what appropriate compaction is. And the testing rate is 1 per 100,000 cubic yards, which is acceptable for this type of project. Minor variations in the material properties are not expected to affect the effort to compact the material. Mixing things where there is a difference in material to get that uniform type of slope to place. Each truckload of material is visually inspected prior to use as structural backfill. The fill material is placed in approximately 1 foot lifts, and there's an exception allowed for work within a limited distance of that rubberized slide area, and this is for worker safety, and use a different method of compaction in that zone close to the rubberized area. So the level of backfill in this, or engineered backfill is beyond what is normally required for a construction material site. So they've gone up above and beyond what we normally look at for this kind of, for a construction material site. Finally, unsuitable material is rejected or blended with other grading materials available on site. Additionally, specifications for placing the fill and testing compaction using accepted industry standards were provided in the February 7th adequacy response. Moisture conditioning based on the standard Proctor test from the laboratory, and bulldozer traffic are expected to provide sufficient compaction of the fill material to achieve at least 90% standard Proctor density. Kind of materials will demonstrate compaction is achieved by fill density testing at a rate of at least 1 per 5,000 cubic yards. So that, given their rate of putting down material, we expect that to be 2 tests per day. So field testing records will be kept on site and available for our inspection. And CMC will submit monitoring summary reports on a monthly basis during the construction process. So in the division's view, the applicant provided all information required for a reclamation plan in accordance with CRS section 34, 32.5, 116, parent 4, parent J, and rules 3.1.5, parent 3, and 3.1.5, parent 9, and parent F. Slope monitoring is another additional concern. Specifically, Castle should verify how they are monitoring the quarry and present data and engineering upon which it is based its plan so we can verify it. Continual, we being the objective. Also, a continuing commitment to site monitoring and measurements of the faults, etc., must be included, and reports of those measurements must be required to allow DRMS and the public valid information on which to make decisions. The statutes backing this up for making it jurisdictional are CRS 34-32.5-116, parent 4, parent J, and construction materials rules 3.1.5, parent 3. They've now eliminated all high levels, so we stabilize. So as far as the adequacy demonstration, the monitoring performed to date methods include robotic prism surveying. That's where I showed all the different points on the maps earlier. Visual inspections, which are performed daily to see if there's anything that looks suspect. And then there's the drone imaging they use to survey to compare surfaces over a period of time. The reporting for this is not required under the current approved Amendment 3 within the following technical provisions. So this would be a new, under Amendment 4, would be a new requirement. The prism system is designed to detect movement, displacement from the thermal effects settlement slides is what the board asked for about earlier. Then the detected movement is first analyzed by qualified professionals. If it is determined to be significant, further investigations are performed. And the prism system alarm has been established at a 1/10 of a foot of movement per day. So it doesn't mean you have to move a whole 1/10 of a foot, but it's a speed of displacement rather than a magnitude of displacement. In addition, following an alarm, the data is and will be reviewed by CMC personnel on an as-needed basis in support of worker safety and additional inspections are performed as necessary. Under Amendment 4, CMC will prepare monthly monitoring reports summarizing the data to be included in the public record. These reports will be invaluable in the future assessment as to whether the slope is stabilizing as the engineer backfill is placed. Engineer backfill expected to be completed in 2 years from the approval of Amendment 4. This allows a minimum of 5 years of monitoring under the reclamation plan for assessing the effectiveness of the backfill to stabilize the slope. And at the end, anyway, the site will not be released until the qualified engineer deems monitoring is no longer necessary. And it's important to note here too, if there's an imminent failure that the materials is observed, or as our case might happen, they're required to notify the division and relay plan. Excuse me. So under with all the adequacy responses here, the division is provide all information required for reclamation planning in accordance with CRS 34-32.5, parent or -116, parent 4, parent J, and rule 3.1.5, parent 3.
I had a quick question. You said it built the, sorry, I was going to look at your slide and you moved on, but that whether someone deems is no longer necessary, what would make it no longer necessary? Like that it's not moving at all, or that it's only moving a very small amount?
Excellent question. That'll be, there'll have to be a demonstration that's stable. As we talked about earlier, there can be some movement that might be just thermally related or just settling from compaction, I talked about earlier, this is engineered fill, going to be compacted to 90% optimum. But so these are going to go in 1 foot lifts. As each layer goes in and is compacted, you put another layer on top of it. It adds more weight to it. And it's kind of like if you have a big stack of papers, you put them down one at a time. If they're a little bit wrinkled, you can see some space in it. But by the time you get a whole ream of paper on there, the stuff at the bottom is really, there's no space in between it. So the same thing happens when you put down soils. So the compaction effort is basically accelerating the natural process of getting the material to consolidate. So it gets us to that final, you can't compact it anymore at a quicker rate than if you were to, I think the general rule of thumb in the Front Range is that it takes like 17 years to consolidate a stockpile without any engineering controls and whatnot. So this just gets us there faster. You're going to get there eventually anyway with placing material, but this just gets us there faster, so we have more time to monitor it. So with the movement, some of it's going to be settling, some of it's going to take a qualified professional geotechnical engineer to determine whether this is settling or whether there's actual movement. So there'll be a lot of evaluation and analysis to figure out where we're at.
Okay, thanks.
So the last geotechnical concern is the stability analysis. Specific, there is no data to back up the stabilization claim, and the amendment needs to include database scientific reports supporting the redesign. Statutes to make this jurisdictional. CRS 34-32.5-116 parent 4 parent I and Rule 6.5 parent 2. On a site-specific basis, an applicant shall be required to provide engineering stability analyses for proposed final reclaimed slopes to ensure areas outside of the affected land are protected from slice or damage occurring during the mining operation and reclamation. And Rule 6.5 parent 3, where there is a potential for off-site impacts due to failure of any geologic structure or constructed earthen facility which may be caused by mining or reclamation activities. The applicant shall demonstrate through appropriate geotechnical and stability analyses that off-site areas will be protected with appropriate factors of safety incorporated into the analysis. So as far as our adequacy demonstration goes, the sort of supporting documents included the CPS report, which I referred to earlier, which is included in an exponent report, which is another firm that did a geotechnical investigation that shows detailed mapping of the bedrock and the major faults. Then there are additional in Appendix 37 of exponent report. This is a 1,042 page report, so it's pretty extensive. That's why there's an Appendix 37. It's not even the last one. They're used to construct the site map and the cross-section profiles. There's additional Sigmuller report, which adds a conservative 5 pounds of weight per cubic foot to all the soil material, results from the exponent report, thereby increasing the mass. So this basically adds conservatism to the analysis. It shows we're just putting a little bit more weight on all the soil, so it's more likely to move. And finally, there's a 0.03 gravity pseudostatic seismic factor based on accepted practice from white paper published by Heinz Griffin and Franklin in 1984. This procedure specifies a seismic factor safety greater than 1.0, which is, so this is procedure specific, and all the amendment 4 factors of safety all exceed 1.3. So they're way above what's required for this specific procedure.
I have a question. This is Karen. Can you hear me?
Yes.
Yes.
Okay. Going back, if that using that PRISM alarm system, if that alarm goes off, has there been any discussion of what steps would be taken, or other than, well, the alarm will go off if there is movement that is excessive of what you want? Is there any plan in place of what would happen if that goes off?
Yes, I've talked to, again, this is for worker safety, so this isn't something that the division has been involved with, but I've talked with the operator and their consultants on numerous occasions during inspections. And so when that alarm goes off, all work stops, people are moved from the area, and then they do an evaluation of, okay, what was the information that was, or what kind of movement did they see? And they do additional investigations, and if it turns out it's not actual movement, but maybe thermal effects or something, then they go back to work. But if that alarm goes off, again, this is for worker safety, and this is what their utmost concern is, and they will stop work and investigate it and determine whether or not there's an issue.
All right, thank you.
So additional demonstration on the stability analysis. Amendment 4, Exhibit 6.5 includes the stability analysis for 3 cross sections of the pipe recording. 2 analyses were conducted for each of the 3 cross sections, one under static conditions and the other accounting for earthquake load under pseudostatic, using industry accepted software. All 6 analyses resulted in factors of safety meeting the board approved standards, static factor greater than 1.5 and pseudostatic factor greater than 1.3. The division engineering staff uses in-house software to verify the models presented in Exhibit 6.5 and found similar results, also meeting the board approved factor safety criteria. And Zach Trujillo is the one that did this. He's downstairs and not in the conference room, so if there are questions specific to that, he's available for answers to questions. So finally, with adequacy demonstration on the stability analysis, material strength properties were obtained from available information and previous technical studies from pipe core materials include the following. There are core logs from 4 drill holes, laboratory test data from drill hole core samples, laboratory test data from both soil samples, so cover both the rock and the soil, and then previous engineering reports from CTL Thompson in 2009, exponent failure analysis associates in 2011, and the Signal International report in 2012. In the division's mind, the applicant provided all information required for a reclamation plan in accordance with CRS 34-32.5-116, parent 4, parent I, and Rule 6.5.2 and 6.5.3. The next category was reclamation concerns. Specifically, will reclamation stall for a long period of time, or is there a commitment that there is a commitment by Castle to complete the work within a specific time frame? And there are multiple requests for commitments and guarantees. So the statutes, I won't read through them all just in a matter of time, but it's CRS 34-32.5-117, parent 1, CRS 34-32.5-17, parent 2, and CRS 34-32.5-116, parent 4, parent Q, parent I. And then finally, there's the performance standard regulation 3.1.10 that provides requirements for revegetation. I will point here that it's just, well, everybody would like to see this reclamation done in 5 years. The division won't release this site until there's a demonstration by a qualified professional geotechnical engineer that the site is stable and that and monitoring is no longer required. So if it gets beyond 5 years, the board does have the authority to provide an extension to that 5-year reclamation period.
Say that again.
So the board would have, if we get to say 5 years and there's maybe some issues that we're not quite ready to release it, the board has the authority to extend that 5-year period. So performance adequacy demonstration, Exhibit D reclamation timetables include backfill completed in a 2-year period, allowing 3 years for the vegetation establishment. Continental Materials is committed to placing topsoil, seeding, and planting on the lower portions of the backfill as it's completed. thereby providing as much as 4.5 years for vegetation establishment on the lowest portion of the slope. So the division holds a requisite performance warranty for the Type 4 and will require a newly signed performance warranty upon approval of the board. That commitment. As far as vegetation, specific concerns were how long will Castle use the weed control program? The middle section of the reclamation between elevation 7540 and elevation 7250 has only painted junipers. The operator should commit to a standard for tree survival, and will tree planting be followed by an initial watering to saturate the roots. Statutes supporting our jurisdiction are Rule 3.1.10.6 and Rule 4.17.2.5. I should note here that the operator, Continental Materials, has an approved noxious weed control plan, and they're managing the noxious weeds to date. We have never cited them for a problem for noxious weeds on site. As far as vegetation adequacy demonstration, Exhibit E proposes a diverse selection of grasses, forbs, shrubs, and trees that vary by elevation, including the following. So there's a little over 69 acres below elevation 7250. This is the lower slopes. It includes Gamble's oak and mountain mahogany mix. So there's a little over 37.5 acres above that between elevation 7250 and 7450. An equal mix of pinyon pine and juniper with a 70% survival rate of the trees, a standard for tree survival, plus a mixture of 12 different grasses, forbs, and shrubs. And finally, at the upper elevations above 7450, there's a little over 32 acres of an equal mix of Douglas fir, ponderosa pine, with again a 70% survival rate for 30 trees per acre, and a mixture of 20 grasses and forbs. And the reclamation cost estimate includes watering of the planted trees, so that's part of the reclamation plan as well. So the division's mind, the applicant provided all information required for a reclamation plan in accordance with Rule 3.1.10 and Rule 6.4.5.
Excuse me.
Yes.
When you saw those big orange sheep there, what kind of growth, what kind of plant life do you see there now? And how long has that been in place? Is that are we going to replicate that or do something additional, or what's happening there?
I mean, that's the goal. That was a January inspection, so things were pretty, there wasn't much greenery there. But that was that same area that showed the progression of concrete reclamation over from 2003 through 2011 or 15. So it's been pretty consistent that vegetation is well established. You know, so the goal is to get to that same level.
What kind of vegetation is it?
It's mostly, I guess, grasses. Well, I'm an engineer, I'm not a veg guy. I'm not going out there to, inspect it, especially with sheep like this. So, yeah, there aren't trees in that. I guess if that's what you're getting. It's mostly grasses and forbs.
Okay.
So with respect to topsoil quality and care, the concerns will provide details of maximum thickness of the stockpiles, steepest slopes, and seed mixtures, grades, timing, of seeding, etc. And how will Castle guarantee that topsoil will be clean, weed-free, and have sufficient nutrients to sustain reclamation growth? Jurisdictional statutes are CRS 34-32.5-116, Parent 4, Parent G, and Rule 3.1.9, Parent 1. Mike, just let me know where we're all about at the time. So I'm just going to go through the kind of get to the high end that the application demonstrated that they're going to take care of the topsoil. It'll be monitored. Anything single will be monitored for suitability. They're going to test it for nutrients, and we'll go into borrower reclamation. There was some concerns about whether this would be reclaimed within a reclamation permit area. So of course, it'll be all in our jurisdiction to ensure it gets claimed, and the exhibits in F1 and F2 show that those areas are also could be under the reclamation plan. Similar issues with the borrower reclamation that the applicant provided all the information required. Getting the stormwater, the control, concerned about whether the stormwater is adequately managed. The important thing here is that to get the stormwater routed around because of the steep slopes, keep it from eroding the soil, much less getting infiltrated water that might cause instability. So the CMC plans to hydroseed the slopes and use tackifier on the steep slopes, and so there are plans in place to get that vegetation established and stabilize the slopes. So again, we believe that the applicant provided all of that information adequate to demonstrate that they'll meet those requirements. And as I alluded to earlier, stormwater controls that we've got through the adequacy review process, we've got a lot more detailed design than what we typically have for construction material sites, and hydraulic analysis has been reviewed by the division, and there are sufficient engineering plans for all the virgin channels, and so we believe that's been adequately addressed as well. Reclamation cost estimate, there are concerns about material being imported from outside, and simplistic cost estimates. We went through this quite a bit. The division has a pretty thorough cost estimate that we believe is sufficient. And so there's enough information in the application to get where we need to go. The sediment funds are included as part of that bond calculation, and we believe again the applicant provided all the information required. And then the tree exclusion, this is the last issue, that basically we're not looking at restoration, we're looking at trying to get the best chance for getting vegetation reestablished and getting stable slopes. We believe the application demonstrates that goal. So quick questions before I go into the recommendations. So closing summary, the objective brought forth 5 general categories of concerns. There's geotechnical, reclamation concerns, stormwater, bond estimate adequacy, tree exclusion. So based on the review performed by staff, the division recommends that the board find amendment 4 permit M-1977-211 IP Corps meets the requirements of the IP rule. And furthermore, having met the requirements of the IP rule, staff recommends the board approve amendment for the IP Corps permit M-1977-211 over the objections raised. That's all I have.
Thank you, and thank you for being mindful about the time we have.
Madam Chair, there's some questions from 220.
Okay, we have some questions from 220.
Can you stop sharing your screen, please?
We're going to stop sharing the screen so we can see folks.
I have a quick question.
Can you just do a brief introduction of who's speaking?
What was that?
Sorry, Forrest, we can't see everyone quite yet. Can you just introduce who's speaking?
I can't understand you.
Ask him to introduce himself.
Can everyone introduce yourself before you speak in case we can't see your name on the screen?
Forrest?
Yeah, I still didn't hear what you said.
We see you now, Forrest. I was just asking if people could introduce themselves, but we're good. What's your question?
My question is, much of the quarry was disturbed pre-law, I was just curious, how did Pikeview take on responsibility of the reclamation for the entire quarry? And at what point did that occur?
Good question. My view, and I don't have the full history back to, the turn of the last century, but most of the mining has progressed in a downward fashion. So what was disturbed, the current footprint really hasn't changed since the 1950s. They've just gotten deeper. So that way it still falls under our jurisdiction. There's no, I guess, pre-law disturbance that hasn't been redisturbed after the permit was granted. So that's, I guess, how it falls under that.
Okay, I guess that was my question, is whether that had been redisturbed. So apparently it was then.
Room 220, I think there was a question.
Can you hear us?
Yeah.
They chose not to ask the question anymore, so we're good.
Okay, thank you. Any other questions currently for the division? Just to have the objector,
We'll switch out.
are they switching out?
Yeah, we'll
Okay.
switch out.
I don't know, I was gonna kind of ask that question in tandem here to see sort of where we are in terms of times and breaks and things that make sense. Maybe what we'll do, if it's okay with folks, I'm gonna chat with Russ and Cammie just on what we're doing with timing while we get people switched out of the room, and just see if we're doing lunch, if we're doing a working lunch, if we're hearing from the inspector, so that we can be efficient with time, keep people fed.
Nell, this is Karen Utterback Norman. Can you hear me?
Yes.
Can you ask the presenters not to move their head around, but talk into the microphone? You know, we lose a lot when they move their head around. Either move the microphone with their head or talk right into the microphone.
Speak into the mic. I will remind people. Thank you, Karen. We appreciate the feedback.
The next.
Are you?
No, there we go.
Okay, can everyone hear me? Jill, can you hear me? Yeah. Okay, so for those of you in 220 and on the call, we kind of want to do a pseudo working lunch, but we also realize you probably need some time to go get whatever it is you'd like to eat. So could we be back and seated in front of our computers and present at 11:50? So that gives you 20 minutes, knowing that there's a good chance we're still going to be eating lunch, still getting things going, but we want to give us time to keep things moving along. Is that agreeable?
That works.
Is that not agreeable to anyone?
Sounds good.
Okay, so 11:50 back here, it is okay to still be eating. Thank you.
I want to do it for you too.
Glenda second.
All right, welcome back, everyone. I think I see most people here. All right, we are going to have a presentation for the objector, correct? And we're keeping this to about 90 minutes, correct?
Yes.
Without board questions, don't count. And Chuck's going to keep the time for us, and we'll try to give you a heads up if you're getting really close. We want to make sure you make some key points, so you're not run out of time.
Thank you very much. Good morning again. My name is Steve Mullick, and I do represent Warren Dean, who is the objector. It's my pleasure to represent him. He's a great corporate citizen. And we both want to say we appreciate having the opportunity to appear before you today. Appearing before the MLRB is rare for me, so I appreciate this opportunity. Done it once or twice before. We also very much appreciate the amount of time you've given us to make our presentation and explain our concerns, and they're legitimate. We're really here today because this is, in our opinion, a very significant action that you're going to take. It will have long-term significant impacts on Colorado Springs and our community. We had also suggested it also is a very serious decision from the board's standpoint, from the board's perspective in making policy. So what we have to talk about is serious. We're here to oppose adoption of amendment number 4, which proposes to replace the currently adopted amendment number 3, an amendment reclamation plan that's been in place since 2013, and a promise from the Continental Materials to perform that. For our presentation, I'm going to start by providing you with a little bit of history and a little bit of an overview of the issues that we have. The history, I think, is important to the perspective. Then we're going to call 3 witnesses who have great expertise in reclamation and engineering of large projects, such as geotechnical engineering, and also an engineer whose sole work these days is basically doing cost estimates, especially for large jobs. But I think we need to start with asking the question, why are we at this hearing? As I know you know, first and foremost, there's already a reclamation plan that's in place. It's been in place since 2013, and it was the result of substantial investigation and engineering work that was done after a very critical and catastrophic landslide in late 2008 and 2009. There were numerous investigations that were run as a result of that. They all concluded that the landslide was caused in substantial part by the operator violating specific restrictions in their permit, restrictions that were put in place to for safety reasons, in anticipation of what would happen if those were violated. That ended with a cease and desist order that was entered and a fine being entered. And most importantly, the reason I'm telling you this history is that investigation said now, or that action with the board then said, you need to come back with a reclamation plan which is designed and specifically put together to make a stable site, make this safe. And that's a challenge because this isn't your average mine site. As I think you heard this morning from Mr. Kazir. This site is inherently unstable. It's had slides every decade, 1980, 1990, 2000s, the 2009, 8 and 9 slide, and then again in 2015. So this is an inherently dangerous site, meriting caution and meriting careful attention to what's going to happen there. And this 2013 reclamation plan was issued as a result of that, with the mission being how do we make the site stable and how do we make it safe. That was an action taken by a prior board, and that Amendment 3, the current reclamation plan, was proposed by Continental Materials. So they asked for it. It was also what would be appropriate at the time. So why are we here today? That's because there was a bond that was posted at that time that was $4.2 million. That's notwithstanding the fact that the estimated cost of reclamation for amendment number 3 were almost $22 million. So the bond that was posted was actually only 20% of the bond that was required by your rules, and a bond sufficient to do the reclamation. That was set for a hearing. When the staff determined that that was a problem, it was set for a hearing. And I understand at that hearing that there wasn't a contest as to the almost $22 million cost estimates. But Continental asked for permission to submit a revised reclamation plan, a cheaper plan, and only posted a bond of $50 million at that time. You were all, I think, aware of that. And so why we're here today is to visit about whether or not you should accept a new reclamation plan brought to you, not because it's a safer, better plan, but because it's going to save money. Nothing wrong with saving money, but when you trade that off for safety, it doesn't work. We're here to tell you that you should be opposing and not adopting amendment number 4. And there are a number of reasons that I'm going to go real briefly through, and then I'm going to give you a little more detail on it. First of all, this will provide a less safe site. It will not stabilize the slopes. And this is going to present to you amendment 4 is a plan that is less safe, and at a time where safety should be the optimum. Since all the staff study on this, the purpose, long-term use of this property has changed from just wildlife habitat to recreation, with this ultimately destined to be a bike park, theoretically a world-class bike park in Colorado Springs. So the focus on end use has changed, and with that, safety is more and more important, and especially safety of the site itself. Secondly, it's a site plan that's likely to fail. All indications are this is an unstable site. There will be future slides in the future. And if you have a failure, it is scary and it will be expensive to repair. Next, it's going to be hard to revegetate because under Amendment 4, your ultimate slopes are much steeper, almost twice as steep as under Amendment 3. That makes successful revegetation a true challenge. And it also requires import more fill. With Amendment 3, you knock down the high walls and you get the fill you need for that. You don't have to import it. With Amendment 4, because you leave them up, you have to import. And significantly, by importing, having to find that much material, roughly 2.3 million tons of material, you're going to create a new scar, probably in the Barrow area, the lower Barrow area. And that seems like a ridiculous plan. And last, we don't think this is in compliance with your policy. One, because rules in your policy, because it doesn't stabilize the slope. But more importantly, it reduces the factors of safety and reduces the factors of safety below the minimum. So with that, I'm going to kind of go quickly through our issues and try to kind of summarize those. We break them down into 2 major issues. The first one is that the proposed plan is less safe and it's not going to provide stable walls. The second is we believe your bond amount will be tremendously insufficient. You don't have actual cost estimates, and the estimates you have omit work that needs to be done. First, when we talk about Rule 3.1.5(3), and what that says is if you don't eliminate your high walls, they have to be stabilized. You shall stabilize them. So the presumption is you take down unstable walls, but if you want to leave them up, you have to stabilize them. Amendment 4, we do not believe will do that. Currently recognized Amendment 3 that was again adopted by a prior board recognizes the inherently dangerous nature of this site, the high steep slopes, and it takes them down. So they're not going to occur in the future. I analogize that to we've got an avalanche danger right now. What do you do for avalanche danger? You knock it down. Well, that's what Amendment 3 does, and that's what was recommended as required from the study. The plan is adopted by the current plan that you're being asked to discard was adopted after just tons of study, thorough engineering again as to what was really required to stabilize those walls. Recognizes them. Amendment 3 recognizes them, takes them down, and it's probably most importantly a very straight, simple, forward reclamation plan, kind of Reclamation 101. In contrast, and I think you have to look at this because what you're being asked today to do is discard one plan that's been on the books since 2013 and adopt a new one. So you have to contrast these. Let's look at the proposed one. Amendment 4 doesn't propose to take those high walls down, but instead proposes to leave them up and buttress it, kind of support it in the future.
Mr. Milliken, I apologize for interrupting. Do you have a PowerPoint that you are all looking at, or are you?
Yes, and I'm sorry, it doesn't appear before me, so.
Yeah, if you could share the screen, then everyone on Zoom could see it as well.
Thank you, Jill. I didn't realize that the screen, because I can see one screen on this and one video, but not the other. Thank you.
Thank you very much. I'm sorry.
Sorry. Can everybody hear me at least? No?
I can hear you, yes.
Oh, yes. On the computer.
Thank you. I apologize for that. I'm going to try. Do I appear okay in there? Okay.
Yep.
So I'll pick up. I should have said at the beginning, I've got my mask. I'm terrified of coronavirus a little bit, but I'm more terrified of this technology and doing remote hearing, so bear with me, please. So as I was saying, we got to contrast Amendment 3 to Amendment 4. Amendment 4 does not propose to take down the high walls, but leave them up and try to build a buttress wall to stabilize them and hold them up, but using much less fill material. The problem with that is it's an engineering and construction challenge, and one that's likely to fail for two major reasons. One, you're fighting Mother Nature, and we've all seen historically that fighting Mother Nature is usually a losing battle, talking Army Corps of Engineers. And also, Colorado Geologic Survey and others predict that there are future slides coming. It's going to happen. So we're trying to build a wall to stop future slides. Now I'm not advancing. Okay. Okay, here we go. This is just a picture of one area of this the quarry that I threw in here because it shows how unstable this material is. And the proposal under Amendment 4 is slap stuff up against it, try to make that not move in the future. A challenge. The new plan, because of that, because this is now an engineering challenge and a construction challenge, you have to use only structural fill. That's quality fill that can be compacted and provides the stability. It's not all of the fill that you normally would have. In Amendment 3, because you're taking the unstable stuff down, you don't have that same issue. And then you have to properly compact that at 1 foot intervals to get the right strength that you need to do that. It's a challenge, construction and engineering challenge. And these are not, this isn't a debatable topic. This is acknowledged by your staff. It's also acknowledged by the applicant. But the point is, with Amendment 3, you got a simple construction. Amendment 4, you got a real serious challenge to do it right and only use quality materials. And you're starting now with 200 feet of fill in the bottom already. And this is a picture taken from an inspection report December 15th of 2019. And again, you've got to use only quality fill. That is not quality fill. You can't have objects greater than 12 inches. You see there's construction debris, curb and gutter. Doesn't look like it's compacted. And this will be the toe of the new slope you're building on. Concerns us. Sorry, slides aren't advancing. There we go. Oh boy. Okay. So at the end of the day, if you were allow this construction project to go forward, adopt Amendment 4, you're going to have steeper slopes at the end of the day, which is bad. They're going to be much more difficult to successfully revegetate, and they're going to be less safe. And if they come down, more expensive to repair. As I said a minute ago, and then because of the import required for Amendment 4, you're really allowing creation of a new scar, 2.3 million tons. And even the applicant doesn't really say they can stabilize this. Well, they say they can mitigate it and they can make it more safe, but there's no guarantee here. And predictions, you'll have more slides. This is rule 6.5.3. For this type of a project, you also have to have minimal safety factors. Those are set by your staff and approved by the board, but they vary based on, one, the certainty of the soil or rock strength that you're using, and we're going to talk in detail about that. A lot of concern saying that maybe you should have a greater factor of safety. And then also depending on the consequences associated with a failure. And here, the consequences of a failure, if this comes down, is maybe people getting killed. This is a recreational site in the future. We don't think that rule is met. And now, because this site is being used for recreation, the focus really has to be on the stability and safety of the site, not off-site, which has been the focus generally. The site has to be stable because it's now used for recreation. Importantly, Amendment 4 fails to meet your criteria because it doesn't meet the minimum 1.5 factor of safety required by MLRB rules and board policy. We will show you that. In addition, and I think this is a critical point, instead of making the site safer, it makes it less safe. The factors of safety get reduced by adopting Amendment 4 over what they are with Amendment 3 by 43% on the average. I'm going to show you this chart, and our experts will go through it with you. These are the left column is the various axes where you kind of tested it. In the center is the required board minimum factor of safety, 1.5. Amendment 4 has 1.93. That one squeaks by barely. But then on the Y, Y, and ZZ axis is only 1.41 or 1.44. Fails the test. And then importantly, if you look at the next column, that's what's currently in your records for the factors of safety for your currently adopted Amendment 3 reclamation plan. 3.16, 2.39, 2.85, all far exceeded 1.5. A very safe plan. Again, if you adopt Amendment 4, you'll reduce the factors of safety by, on the average, 43%. Shouldn't be allowed. This quarry is moving today. It's still moving. You've heard that. They're monitoring it. That's scary. And when you're trying to build up material against a moving target to hold it up and stabilize it, that's a challenge you probably shouldn't undertake. And I don't think CDR wants that responsibility. Our second major area of concern is on the insufficiency of the bond that's proposed for Amendment 4. We don't believe your cost estimates are accurate or meet the requirements of the rule. First of all, Rule 4.2.1 indicates that when you're setting this, the financial warranties have to be based on actual current costs for fulfilling the requirements of the reclamation plan. Actual current costs. We don't believe you have those. And then secondly, within the cost estimates, first, those actual costs, we're going to call Dan Bear, who's a professional engineer that does cost estimates all the time. He works in the field. He has the data. That's his job. He's going to show you that the unit costs applied were not accurate. They're understated. And then perhaps even more importantly, there's some tasks not even costed, not even listed, that are absolutely required if you want to get this Amendment 4 done. Those combined to be a lot of money, as we'll show you. And probably most significantly in those costs that are not included, there's a big assumption that all of this structural fill material can be obtained on site. That's probably wrong, and we'll show you why. And if so, then you've got an additional cost of finding and acquiring 2.3 million yards of critical fill, that's structural fill. That cost alone is huge. And I want to just remind you of a point I made a minute ago. With Amendment 3, it dirt balances basically. You do not have to import fill because you're getting it by taking down the unstable high walls. So you don't have this import problem. And there has been a claim, it's been a little bit of a moving target by the applicant, that they can get all of that fill they need on site from this lower borrow area. Well, that lower borrow area, the city council for Colorado Springs approved acquiring it recently. And in the deal with the city of Colorado Springs, it was fairly very clearly, the point was made by that city council that you only get to take fill from this site that's consistent with a city-approved reclamation plan or grading plan for their bike park, but you don't get 2.3 million tons of material there, cubic yards of material. Secondly, the bond requires it when you set it, that it be sufficient to allow the reclamation to be completed by the office, by the MLRB, not by the applicant. In other words, when you set a bond, you're protecting the state. So if the state has to go in and do that reclamation, there'll be sufficient money in that bond. And we're going to show you that this rule is not meant by the bond that's proposed. You will not have enough money. And as you're considering this big issue today, I think it's appropriate to say, proceed with caution. I think that's what you should do. That's what we think you should do. You've got replete in the history of your files that this site is inherently dangerous. It's had multiple slides, it's had multiple problems. Everything says be cautious with what you adopt today. Colorado Geological Survey, after they did this study, after the 08 science, they said this: it's not a question, it's not so much a matter of if, but when the unstable blocks will fall. It's going to happen again. That's your experts at the state level on geotechnical things. They're saying be cautious. This is not your standard site. It's dangerous. I think you also need to be cautious because this is a dangerous situation with recreation to be used. And if it comes down, it's going to be extremely expensive to repair and reclaim. Much more difficult than if you've already taken the steep step down. If you're trying to hold it up and then there's some failure, it's a mess. There have been repeated failures both with this mine and with this operator. And that part of the history, I think it's appropriate to remember that. There was a violation of the permit imposed for safety reasons before, and the wall came tumbling down. And now they're proposing to get into a very sophisticated, detailed, challenging construction project requiring careful monitoring and supervision. You don't have that need in amendment number 3 that's currently approved. Bond has to be sufficient to protect the state, not just the applicant. And in their proposal, they have a 3% contingency, and Dan Bear will talk to you about that. 3% contingency is ludicrous for something with this history, with this unstable, this size of a job, with the uncertainties that are there with regard to where you're going to get the fill. You need a real contingency to cover the state. And I'm just going to kind of wrap up my intro by saying the issue before you today isn't whether we support mining in Colorado. Our statutes do, you do, and that's not inappropriate. But the question is, the mining has occurred. We're on the way out now. And the real question before you is whether we have responsible mining. We require our mining operators to live up to their promises. This promise was made in 2013. They now want to substitute something new. I think it is appropriate to say you should rarely approve an amendment to a reclamation plan after the mining has already occurred and while they're in the process of exiting. The standard for proof that's a better plan or should be adopted should be very, very high. If you don't, it really looks like bait and switch. I promise when I need the permit to do what's right to make this site safe and stable. But now that I'm done, I'm going to give you another plan that I think maybe works. And obviously the motivation here, the reason we're here is because it saves them at least $7 million on the bond. And there's nothing wrong with saving money, but you don't do it by substituting a less safe plan that we don't think meets your rules. We're going to now present witnesses. If you have any questions of me, I'd be happy to take them, and along the way, our witnesses as well. But we're going to provide some detail. You're probably more than ready to hear from someone that has some expertise right now. And so if that's okay with you, I'll call our first witness, who is Carl Mount. We'll have to switch PowerPoint slides at this point in time. Carl has got more than 40 years of experience in permitting and mining and reclamation. He's a reclamation expert. He, in fact, worked here at the division for 22 years, 16 of which he was a supervisor. He also has international experience with hard rock mines. He's a consultant. He's truly an expert on reclamation, and he'll address you now. Carl?
the right one?
Yes.
That's correct. On the, no, on this one. So up and down. Yep. Mhm.
And it's not doing it. Doesn't advance the slides. Do I need to share this screen? Share. Press Facebook.
I was just, I think it's, I think it
It
is.
is being shared currently.
Yeah. Okay, so.
Oh, it's right in line.
Right.
Got it.
Sorry about that.
Okay. Away we go. I'm Carl Mount. We're here to ask that the board deny Amendment 4 proposed by the CMC. So there's my resume, pretty much. I've worked, someone called me a slow learner because of this, but I've worked approximately 40 years at this point in time. In mine and reclamation, starting out with when I went to school in 1978 and coming up to this point in time now. Worked for 22 years with the RMS, both in coal and minerals sections. 16 of them as a senior reg spec in the minerals program for the northern half of the state. And I retired in 2008, went to 5 years in a private company, and I've been an independent consultant since then. Mostly working on large metal mines, things like Climax, Henderson mines in Arizona, Peru, Chile, and Guatemala. During that time, by the way, I should probably mention that I've done, I've reviewed probably hundreds of these types of applications and done hundreds of on-site inspections at mines. So I'm relatively experienced. This is an overview of the Pike Quarry here, taken in 2019. As you can see, the quarry, you can see Pikes Peak on the left in the background. You can see suburbs of Colorado Springs in the foreground, and Pike Peak Quarry, which is located just northwest of Colorado Springs, right there in the middle. Note on this slide too, and maybe I can point it out with this arrow. This area down here is the lower borrow area that was proposed by the operator to use for fill material. Put in that hole there, hold up for these walls back in here. A lot of that area, if Colorado Springs buys it, and we've heard that they're in negotiations, maybe I've already signed a contract, that area.
Excuse me, I'm sorry to interrupt. Can you speak up, please?
All right. That area becomes not available for fill material. Let me show you an overview aerial. Here's an overview aerial of the quarry itself. You'll note that west is up in this slide because it shows the quarry better. That way is north. You'll see the scarp line at the top of the slide. Note that there are some scarps up above that denoted scarp line of material that has already slipped that's within the granite above the quarry. The top of the high wall was approximately there. That's the top of the Manitou limestone and the underlying Saguache sandstone, both of which have stringers in them of clay, some up to 4 inches thick, that have caused slides in the past. That's the slide area from the slides of 2008, 2009, and 2015. Area H is approximately there, but it actually is a little further to the west because the slide, when it slid in 2008 on December 2nd, actually entered Area H. There were two people operating equipment at the time in Area H, and they had to abandon their equipment. Luckily, they were not killed. They had to abandon their equipment and climb out over the rocks and boulders that defined Area H on the east side to escape their now ruined mine. That's the processing area. As you can see, where a processing area should be right at the loadout to the mine. There's the lower borrow area, but keep in mind that this lower borrow area actually extends much further down from this slide and to the east, most of which will not be available because Colorado Springs is buying the property. So I'm going to go through some history. Oh, and there's the access road, in case you're curious about that. I'm going to go through some history. You've probably had it up to your neck in history at this point. I'm going to go skip over just the main points. There were many rock slides in the 70s through the 2000s. In 1986, MSHA did an inspection report that stated right at the end, said if the final west quarry wall is excavated in the steeply dipping limestone beds as currently practiced, the eventual total failure of the entire west wall can be expected. That was told the operator in 1986 by MSHA, the safety organization. Nevertheless, continued destabilization by mining occurred at the toe of the slope. And in fact, Amendment 1, approved in 1994, and TR 11, approved in 2001, allowed deeper mining at the toe with no more than 25% of the toe exposed at any one time. This was not followed. The no more than 25% of the toe exposed at any one time was not followed. And on December 2nd, 2008, the west high wall of the quarry catastrophically failed. That is a picture of, those up there, that is a picture of the quarry after the December 2nd, 2008 slide taken from one of the division's inspection reports, pardon me. You see that arrow that points up to what the CGS defined as the south hanging block, which I'll show you soon. But that arrow goes over all the rubbleized portion that was caused by the slide. And this slide extends, as you can see, from the cliffs on the left, clear over to the edge of the slide on the right. That was a massive slide, about 2.5 million tons of material. There were hanging blocks. There was a scarp above where the in the granite, it slid down some 30 to 50 feet. There were upper scarps as well, as you can see on the right upper part of there. Those scarps, you need to pay attention to those because those scarps continue to grow as material slides off the bottom here and fails to provide any more buttressing to hold that material up. Also note, one thing you should note, pay careful attention to the furthest left scarp red arrow. Fix that in your mind because I'm going to show you a slide later that shows that that scarp has gotten bigger since the 2015 slides. South and north hanging blocks is identified by CGS. Area H, which the slide overrode, the initial slide overrode, partially. So in response to that, the board in 2009 issued a notice of violation cease and desist order, clearly finding the operator at fault, and the board ordered the operator to cease and desist from any further mining that they could process material that was already mined on the site. The board also ordered that the operator shall provide an amendment to the permit to revise the mining and reclamation plan by May 13, 2010. That didn't happen, but for very good reason. It finally happened because the operator begged for more time to prepare Amendment 3, and the board rightly let them do that. So the operator could study this slide, put in monitoring, and gather data so they could come up with a real, genuine workable Reclamation 101 type plan to actually stabilize this area as required by the rules and regs. So that took 3.5 years of study and monitoring the site and preparation of this. The division took 9 months to actually review Amendment 3 because of several problems with Amendment 3 that the operator had. One of which was that the operator wanted to push all the material from the top when they were unloading the upper granite. And you can see, finally, this Amendment 3 included layback of the upper granite. And that does many things. It makes reclamation so gravity is your friend. It makes it so you take the extra weight off of those already toppling blocks that are slowly coming down one after the other. And as they come down, they fail to buttress the other blocks up there. And one by one, they keep sliding down and coming down. That upper area was a bulldozer push to a loading area. They proposed just pushing it over the side. And the division at the time said, no, that's unacceptable. We don't want you just pushing material in place because it does not provide for a good engineered and quality buttress to hold up all those other blocks that are sliding down. So the operator, unlike what they're about to tell you, in Amendment 3, changed their plan to say, okay, we're not going to push it in place. We're going to push it to a loading area. We're going to put it in trucks and loaders. We're going to truck it around the slide. And we're going to put it into the area of each hole. Thus using a bottom-up construction of the buttress, which is the correct way to do it. Amendment 3 then takes the stuff off the top, trucks it around the site, builds the buttress from the bottom up, an effective buttress, and in Exhibit 6.5, though there were no specific requirements in Amendment 3 except a informal method of directing water around the fill, but Ben Siegmiller, the operator's own consultant who wrote Amendment 6.5, said, and I quote, surface runoff water should be diverted from the quarry and not allowed to enter the final slopes. A slope with marginal stability could fail catastrophically if runoff water were to enter it. Dr. Siegmiller had about 40 years in the business. So I would say he's a fairly credible consultant. So going back again, this is far after the December 2nd, 2008 slide. So subsequent slides happened because that material was taken away from buttressing this other material that was in place. Subsequent slides happened in September of 2009 and in May of 2015, I believe. And that's what the quarry looked like after those slides. If you'll recall that furthest left red arrow showing the scarps, note how that scarp on the far left side above what we consider now a still hanging block in the limestone and sandstone material, where those left cliffs are, that scarp has, here, go back to that one, and now look where the scarp is now. It's widened appreciably since the 2015 slide. The operator does not address this in Amendment 4 at all. And in fact, the division asked a question about it. The operator said, oh, well, GG prime in the exponent report doesn't really address it, so we're not going to read it. The division went, okay. So note that these further slides are not from mining, but from lack of buttressing. I've gone over that a lot. Note the scarp to the far left. Yep. That's still a hanging block there. And here are the cross sections that people have been referring to. You can see XX prime, YY prime. YY prime is especially important because if you look up at the very top of that, those are hanging blocks that are going to come down eventually because of the rampart range faults and splays thereof. The CGS requested that the division included in Amendment 3 excavation and monitoring and mapping of those splays. Amendment 4 ignores them. Does no longer require mapping of those splays. Doesn't do it. So you can also see, I'm going to show you a direct picture of that is the hanging block. And you'll notice right on the center of the picture, there's the scar above it. The material to the right is all slid already, so it's no longer buttressing that. You can see almost a conchoidal, if I can show it, can you see that cursor arrow? You can see this conchoidal fracture down, goes that way on this. This is still a hanging block in the limestone and Sawa sandstone that, not a matter of if, but when that comes down. Extremely dangerous. The operator doesn't address it at all. And if it comes down, if you approve it and it comes down while people are using that site for recreation, you could kill somebody. They would, they're very lucky not to have killed people so far with this. 2 operators almost got it, but they escaped. Good. I'm glad they did. In summary, board is here to consider Amendment 4. It's a much lower quality plan. It does not meet even the minimum requirements of the law under 34, 32.5, 116, 4G and I, and the rules that stem from that, 3.1.5, 2, and 3, and the board policy that Steve outlined and Craig Vaughn will get to and tell you about. Board policy on factors of safety that were adopted by the board, written policy, in around 2018, sometime June 2018. I'm not sure exactly when. But that policy requires a greater than 1.5 factor of safety. I mean, if I were to summarize it, all the plans that I've looked at, this plan has so many inconsistencies, internal inconsistencies, of telling you one thing in the introductory letter and then another thing once you get back into say, Exhibit D or Exhibit 6.5, or, I mean, I could go on and on. But it's basically not a good long-term reclamation plan. The slopes are too steep, 2.25 to 1 vertical. Horizontal vertical slopes are extremely hard to, and I've had a lot of experience doing that too. Very hard to get equipment on, very hard to access if something goes wrong, very expensive to deal with. The Amendment 3 slopes of 3.7 horizontal and 1 vertical are extremely easy to stabilize. The technology exists. It's easy to get tractors and equipment crosswise on the slope without rolling them over. And it's very easy to revegetate and it's stabilized from an erosional standpoint as well. So with that, I'm going to turn this over to Craig Vaughn and he will dive deep into the engineering. If you have any questions at all, I would love to answer.
We're going to do questions and then also an opportunity for cross-examination. So we'll go with questions first.
Nell, did you want questions now?
Sure. Yeah. Okay. Is that Lauren?
Yep. This is Lauren Duncan. I have a question about the safety factors that were previously presented. Can you go into how those were calculated and I guess just how those were calculated to note that difference between the plans?
Actually, those the safety factors from Amendment 3, if I recall correctly, were calculated by calculated within the Sieg-Miller International Report, Exhibit 6.5 of Amendment 3, and checked by the division at the time and found to be okay. The safety factors from Amendment 4 were calculated by Zach Trujillo, the Division of Reclamation, Mining, and Safety, assuming that the fill material, and Craig can speak to this better than I can, but from what I know, they're calculated using what they termed as mine fill instead of mine waste. And mine waste would be more consistent material from, say, the granite slopes above the quarry high wall, or from blasting out the limestone. Very consistent, known type of material, as opposed to material that was hauled in, say, by people accepting any kind of fill from anywhere in Colorado Springs, or by that stuff that you already saw in the bottom of Area H. So those were calculated, the factors of safety were calculated by Zach Tribune, and we accepted them.
Okay, thank you for the clarification. And then regarding some of the hanging blocks that you mentioned and showed the aerials of, did you feel that AM3 better addresses exactly that one? Yeah, some of these hanging blocks.
So I'm not sure Amendment 3, there's so much happened since Amendment 3 was approved in 2013. Keep in mind that since Amendment 3 was approved in 2013, that the 2008, 2009 slides had already happened, but the 2015 slides had not.
Mm-hmm.
This material that you've seen in the slide body and those two big blocks of rock, maybe I can use there, those big blocks of rock, all this material here, all this upper material here slid in 2015. So Amendment 3 was already approved before that slid. So there's a lot of things that are hard to deal with Amendment 3. You know, I mean, the quantities aren't going to be what you would expect them to. But Amendment 3, yes, did deal with it as the quarry appeared in 2013. After 2015, Amendment 3 will still work. It's a much simpler plan. And it would still work against this particular hanging block of material.
Yeah.
I would not.
Yeah, I guess I'd like to.
It would work against the granite blocks as well.
Right, I think I should rephrase the question. So based on the geology here, the fault lines running through, obviously this is a dynamic system. You know, this is notoriously difficult geology to work in and stabilize. So I guess the better question is, did you feel that AM3 better addresses the potential for movement or better addresses this more dynamic system than AM4 does?
Yes, and for several reasons. One of the main reasons is that on that YY prime that you see in this slide, the YY prime cross section, it removes a lot of that granite material up at the top there.
Okay.
So of course, and that clearly goes right along with Rule 3.1.53, which in part requires high walls to be, unstable high walls to be either removed or they shall be stabilized. Well, if you remove them, you don't have to stabilize them as much. And Amendment 3 requires the operator to remove a lot of that granite material. If you see on this slide, it's that right cross section, right underneath YY prime.
Mm-hmm. Okay. Okay. Well, thank you.
On the left, it would also partially serve to stabilize that hanging block that you see in that slide, and also the granite walls up there.
Okay.
Any other questions?
I know that there's some questions in room 220, and just as a term of process, I'm also going to give an opportunity for cross-examination from the operator and from the division. So I just don't know if it's a question from 220 or if it's the operator with questions or if it matters, but go ahead, 220.
Hold on a second, I gotta pull the distance.
Do I have to stop sharing my screen?
Yes,
Yeah,
please,
then
that
we
would be
can see
great.
everyone.
I'm not exactly sure.
And
Just scroll that over and bring it down, and it should, oh, actually go up to the top there where it says.
Way up to the top.
Wait, the very top, the green thing, yep, and then just hit this share thingy. The green button. Here, you know what, I'll do it.
Get there from here to there, there, that.
Okay, well, that's
That one?
very good. Let's do this now. Here.
Ah, that's good. Okay.
Right.
Hold on just a sec, let me.
Sure.
Okay, there we go. Jerry, can you hear me?
Yeah, we can hear you. We have a representative from the operator who would like to speak.
Yep, so I just have a couple questions on cross, Mr. Mount. So Scott Anderson, appearing on behalf of
I can't hear
Are
you.
you able to speak up at all or closer to the mic?
Where's the?
The mic is where the TV's at. I'll try to bring it.
Okay. Yeah, we can't hear you.
My head will look gigantic, but is that better?
Looks great, thank you.
Okay, great. So just a couple clarifying questions, Mr. Mount. And one thing, I know we're going to talk about bonding, but just to take advantage of the fact you reviewed hundreds of permits. As part of that, did you have the chance to review reclamation bonds as part of those permits?
I did not review the bond for this permit, but I was.
Well, that was not my question. I asked whether you reviewed bonds as part of the other permits that you had reviewed when you were working for the division.
As a brand new minted senior reclamation specialist in 1992, I was the guy who said, if you don't have an adequate bond, then don't even bother to go inspect the site, and required all of my team members and myself to go through bond training, bond calculation training. I did my bond calculation training starting in 1988, June of 1988, with coal section. Saw that that was applicable to minerals, and when I rejoined the minerals section as a supervisor, I did indeed calculate bonds in 1992. I calculated the bond on the Asarco mine. I calculated the bond on the Climax mine, or helped calculate it. I calculated hundreds of bonds on various gravel pits. I have never calculated a bond on a quarry that slid this badly, because I've never seen one where the operator is so screwed up their resource as this one has.
Great. So I'll take that as a yes. The training that was that done by the Office of Surface Mining on the bond calculation process?
No, that was actually done, it's a long history if you want to know it.
No, that's all right. I
Times
just wanted to know, I just wanted to know whether OSM did the training on that. I do want to clear up one bit of confusion about the borrow area. You identified an area that's being conveyed to the city of Colorado Springs, but just to confirm from your review of the proposed amendment, you recognize that all the fill material will come from within the permit area, and there's no requirement to take fill material from the borrow area, that property that's being conveyed to the city of Colorado Springs. Is that correct?
That is not correct, because in my opinion, that taking that, so here's another thing. Taking that material from in the quarry site by just putting a few random numbers on the map does not, in my opinion, demonstrate that that material can come from inside.
Look, Mr. I understand what we're doing here.
I need one at a time, please.
I really would just like an answer to the question that under the permit amendment 4 as drafted, the expectation is that all the fill material comes from within the permit area and not from that property. Not whether you think that's a good idea, but is that what permit amendment 4 says?
It is what permit amendment 4 says, but it's not demonstrated that the permit area has enough borrow material.
Okay, fine.
Clearly not.
Question for you. Last question for you. Permit amendment 3, the existing reclamation plan, anticipates much more mining and much more extraction of materials from the permit area. And now we've stopped mining earlier. Is it true that to do permit amendment 3 as drafted, there would need to be more mining at this site?
I have no idea. That would be up to the operator.
Okay, thank you. I'm done. Thank you very much.
Not seeing anyone else in room 220 that looks like they intend to speak. Anyone from the division for cross-examination? I think I see not heads no, Michael Cunningham, yeah, correct? Okay. Okay. Yes, Tim.
Tim Mock, question here. And Mr. Mann, I don't know if it's something you can answer, but at some point, for both parties perhaps, we've made mention to the future of at least part of this site, the Borough area being used for recreation. It sounds like some type of a mountain bike park. Can somebody describe to me what those threats are? Can these walls come down far enough to reach that area? What is the exact risk? And then has any of this information been shared with the city of Colorado Springs, which I believe is going to operate it or develop this site? Have they expressed any concerns?
I am not the person to answer that because I was at none of the Colorado Springs hearings.
As far as this is really risk to the borough area from slides.
It's not the borough, it's the whole floor. Not the borough.
Yeah, true.
I don't know the answer to that. I'm sorry. Any other questions?
Okay.
All right, with that, I'd like to introduce Craig Vaughn. He's engineer type, and John will, or excuse me, Steve will introduce him. Do that.
Yeah.
Engineer, anyone probably.
Which presentation are you using?
Yeah, run that by the chair here.
Wiping down or what?
Ms. Milliken is wanting to respond while we're doing a swap out here.
Yeah, I'll try to answer your question.
Speak in the microphone.
Oh, yes. So Mr. Milliken's going to respond to Mr. Mock's question while we're wiping down the table.
I was at the city council hearing, so I'm generally aware. I think you're going to maybe hear from this, from someone from Colorado Springs, but there are two things that are going to happen. One is the city of Colorado Springs will be purchasing what they call it the buffer area, which is kind of the lower borough area. But they're also going to be receiving potentially in the future a donation of this quarry, for which the plan is to make this quarry a bike park. So your question, could something come down in the quarry and hurt someone? We think the answer to that is clearly yes. Does that answer your question, sir?
That answers part of my question. I was just curious if Colorado Springs was concerned about the safety of the area and if any of your concerns have been expressed to them or shared with them.
I can't speak for Colorado Springs. They will be here. I think they should be, but I don't speak for them. So let me just introduce real briefly, if there are no other questions for Mr. Mount, Craig Vaughn. Craig is a professional engineer with over 35 years of engineering experience with geotechnical projects. He's a principal of Caesars Inc., which is a well-established engineering firm in Centennial, Colorado. He has both his engineering degree, undergraduate, if you will, and a master's of geotechnical engineering from University of Kansas. He's the past president of the Colorado Association of Geotechnical Engineers. He's been involved with numerous projects. I won't list those. His resume was in your materials, but he's clearly an expert on geotechnical engineering. Great.
Thanks, Steve. First, a couple of apologies. My wife told me not to get a haircut when this whole thing started, and so I haven't. So be careful what you ask for. You just may get it. I'm usually a little more clean shorn, so I apologize about that. Secondly, a lot of my presentation actually has some redundancy in it. Tim did a great job earlier this morning of emphasizing some of the engineering principles that I'm going to go over. And in the interest of time, I may move through some things rather quickly, but certainly you have the opportunity to ask questions. I have been described as a practical engineer, so I try not to get too overly technical, and I'll attempt to do that today. As was clearly stated, this is a huge engineering project. This is not your normal reclamation project, and I appreciate the attention that it's getting right now. An engineering project of this magnitude requires basically 4 major elements.
Sir,
yes.
can you go ahead and share your screen?
No, I'm sorry.
Just click that little button.
That is. really
It's the green,
important.
it's the green button.
Yep, I see it. Get the cursor on it.
That's the problem, right?
We can see the PowerPoint
You
presentation.
can see it? Okay.
Yeah, perfect.
Right, if you want
Yeah.
to do that first.
So it looks like you're good.
You can't see the PowerPoint?
And I'm sorry, I missed your last name. I just want to make sure when I address you, what is your last name?
My last name is Vaughn.
Vaughn, thank you.
Yeah. Okay, so, again, thanks for the opportunity. This is a huge engineering project. I'm sure Mr. Schnabel and CMC can attest to the fact that there's been a tremendous amount of engineering already put into the various versions of reclamation amendments on this project. So that's not unrecognized at this point in time. And amendment number 3, which they're currently obligated to, is a good example of a lot of engineering that's already been performed. The elements of an engineering project basically are goal establishment, development of plans and specifications, ultimately the construction, and during construction and post-construction, the monitoring. And Tim talked a little bit about that earlier. I'll talk about it briefly as well. So the fundamentals of slope stabilization, this happens to be cross-section YY. There's nothing special about it other than it's about in the middle of the quarry. It's been referenced in some of the other presentations, but the fundamentals of good slope stabilization basically involve about 3 fundamental things. The first thing is we try to remove load from the top of the slope. I mean, that's a gravity force that tends to want to make a slope come downhill. So a good thing to do is remove material from the top of the slope. Usually that material is placed in the form of a buttress, and I'm simulating that with these layers that I'm building at the bottom. This would be the development of a weighted buttress placed as structural fill, high quality structural fill, that basically provides a support to keep that slope from moving horizontally. You can see as I've advanced the slide, the cut material is gone. I've removed a bunch of load from the top of the slope. The slope is flatter. An additional feature that's added here, I'll show it for the people in the room, maybe. I can't do that either. The vulnerabilities at the top of the slope where we have geologic discontinuities, we have tension cracks, and we have those scarps. Those are removed typically as part of the removal of that load at the top of the slide. That material is moved downhill, typically easier than moving material uphill, and is placed as a structural material at the base of the slope. This infamous area H, this is not to scale, so I don't know if this is the exact dimension of area H. I'm told it may be as much as 200 feet deep. We'll talk about that a little bit. It's been mentioned in a couple previous presentations, but I want to point out it is the foundational element of that buttress. So the placement of that structure, of that material under Amendment 4 is very important because it supports that buttress. A little technical difficulty here. Oh, I'm missing some photographs here from my presentation. The specifications, as Tim alluded to, are really important from a compaction perspective. We've got to place that material as good quality structural fill. It needs to be placed in 1-foot lifts. It needs to be compacted to a specified density. The specifications in the plan actually say ASTM D698, that's called a standard proctor from a geotechnical engineering perspective. That's how you place earthen materials that are generally clayey in nature. But a lot of the material that the applicant, I believe, intends to place is rock fill. And that material needs to be placed by method specification. So it's really important that we make that designation. I need to stop here because I have some really important slides that are just not showing up here. Can we reload? Oh, she's not here.
Yeah, you had your thumb drive in
Yeah,
there.
I have my thumb drive actually with me, but they loaded it. But, yeah, when this is reload. Apologize about that. These are some important slides, so. Yes, that one. Mine is just, there we go. Maybe we have to unshare the one that's. Make sure it's red too. Yes. Okay. Yeah. I can see the other slide. So we're good. Okay. There. I'll just scroll up and then take a- Trying to find out where we can make sure we can share it. Right. Okay.
That's not the right one.
Yeah.
No. No, I'm sorry. Okay. The one that's in blue, I can see it behind the.
And then back over here. Citizens. Yep. And then hit.
All right. Well, are you guys seeing that? Sorry about that.
Everybody good on Zoom? Can you see that?
Zoom.
Yes, we can.
Thank you.
Okay, so this is where I was, talking about area H. That slope works. That slope that I just showed you there, where we removed material from the head of the slope and we built a structural fill buttress, is a good slope. It unloads the head, it remediates those causes of future vulnerabilities that could cause slides in the future. I think it has the tendency to build a faster buttress than bringing material from a downslope import location. It's way flatter, and that's one of the reasons the factors of safety are about twice in this particular Amendment 3 version as the slopes in Amendment 4. The slopes are so much flatter, and it exceeds the factor of safety, obviously, that the board requires of 1.5 in excess of 2 in these particular cases. Again, a slide of the material in area H. You can see, I don't know how you would really describe that material as far as structural fill, but it looks like it's got clay material, it's got construction debris, curb and gutter. I don't think it's been placed in horizontal lifts and probably hasn't been compacted. It's difficult to tell, but I think you can tell just from the photograph that the quality of the material is questionable. This is a cross section also from YY of Amendment 4. And probably the main things to point out here are you don't see that unloading of the upper portions of the slope have occurred. So some of those vulnerabilities still exist. The slope is much steeper. So therein lies one reason why the factors of safety are about half of what they are in Amendment number 3. This particular cross section doesn't show to scale area H, but that lower wedge of fill is approximately where area H is located. And again, the condition of the placement of that fill is really critical to the long-term performance, holding up the remainder of that structural fill that's shown facing that slope. So basically, you're just surfacing a relatively unstable slope with structural fill. We talked a lot actually about factors of safety, and there was a question that came in from a remote location about factors of safety. For those that don't really know what factor of safety is, it's really just a one is the equilibrium of the forces causing a slope to move downhill against the resulting forces keeping it from moving downhill. So when you have a factor of safety of 1, you're just exactly in balance. The reason we specify 1.3 or 1.5 is because we don't always know the exact topography of that slope. What is the exact geometry of the slope? And oftentimes on a slope of this magnitude, we don't know the quality of the fill material that's going to be placed with a high degree of accuracy. So the more variability that you have in your design, the higher the factor of safety. You can see these are, this is information from the Trujillo letter. And you can see 2 of the cross sections have calculated factors of safety that are less than the required 1.5. Those were calculated by DRMS. The Amendment number 3 factors of safety, as Steve pointed out, are in excess of 2 and approximately 40% higher than what you're going to get in Amendment number 4. I would like to point out, this is a quote directly from the applicant's Exhibit D mining plan, and it says the design will increase the safety factors of the backfill slopes, which I don't believe is true, and it will reduce the risk of future slides. I don't know that the reduction of risk is the objective. I think stabilization should be the desired objective, and certainly the data doesn't indicate that the factors of safety have been increased, they've been radically decreased. So Tim talked in his presentations about the importance of the material that would be used in placing a structural fill. In the analysis that was performed by Norwest and by Stantec and by DRMS, it appears that they use these top 2 categories. They used either clay and mine fill or landslide rubble and mine waste rock to perform their stability analysis. The reality is I believe they're going to get a lot of donor material from offsite, and we don't know what that material is actually going to consist of at this point in time. If you look at those pictures from area H, and that's representative, they're going to have material that's less strong as the material that was modeled that yielded a 1.4. So I would be concerned that you would ultimately have a factor of safety even lower than a 1.4 if we use donor material from a variety of sources. So if we were to go with Amendment 4 to construct it, as I'm sure the applicant would like it to be constructed, where are we going to get that quality material? It appears that they're site constrained, they're limited as far as where they can get material on site. The document that I have indicates that import material will be utilized in constructing the slope. There are some specifications for general fill to be used as structural fill. But general fill is not very well defined. What is defined is what's not general fill. So deleterious material, hazardous material, those kinds of things are not acceptable. But the general fill is loosely defined as basically cohesive material with less than a liquid limit of 40. Also says a PI less than 65. That's got to be a typo because that's not possible. PI can't be lower or can't be higher than the liquid limit. Again, I spoke briefly before my technical interruption about earth fill and rock fill. The plans as presented by the applicant are not very specific about when would we apply a rock fill compaction spec and when would we apply a earth fill compaction specification. Clearly, it has to be compacted, it has to be controlled, it has to be monitored, and I would recommend that it has to be done on a full-time basis. The engineer's presence would be on site continuously to assist with determining whether the fill was being placed properly and at suitable quality. 1-foot lifts are specified, and that's fantastic. It needs to be 1 foot. You could go with possibly a 2-foot lift. The standard in the industry is usually max particle size about 2/3 of the lift thickness up to about 2 feet. So in some cases, they might be able to go with a little bit thicker lift, but if they're using the clayey materials like I saw in that photograph, 1-foot lifts tested with standard Proctor type moisture density testing would be appropriate. One test for 5,000 cubic yards, absolutely not enough. Just to give you an idea of what that is, if we were to fill Broncos Field a 1-foot lift, that wouldn't be enough to demand a test. Put the second lift in, still not enough to demand a lift. After the third 1-foot lift, 1 test. So in my opinion, that's not very frequent testing, particularly for an embankment as critical as this embankment is. So as far as the specifications and construction, I mentioned that this is an important aspect of an engineered project. I think there's insufficient detail in the plan. I've been speaking about that ad nauseum, about how there needs to be more specifics in the plan. There needs to be definition as to what is acceptable material as opposed to what's not acceptable material. It lacks verification as to where is the borrow, where is this material going to come from, what is its quality. We know that it's highly irregular. You're expecting to get material from various locations on site, or worse yet, from various locations around Colorado Springs. 1 test every 100,000 cubic yards is insufficient to determine whether it's got adequate strength for the slope. Again, you're talking hundreds and thousands of truckloads before you would take a test to determine whether it's quality material. Placement of the fill, if they use compaction for rock fill, they need to develop a method specification. It's alluded to in the plan that they would test by method specification techniques, but typically that's done in advance of starting construction. Plan is developed, so many roller passes with a vibratory roller of some sort, of some weight. They allude to passing with certain types of equipment, but typically the development of the spec is done in advance, and that hasn't been done yet. I've already talked about the test method 698. The plan talks about qualifying material utilizing visual observation by the operators. I don't think that the equipment operators, the truck drivers, the people spreading the lifts and placing the materials should be relied on as your quality control plan. I think they need to have a more defined quality control plan that involves the engineer, particularly on a project of this importance. Monitoring. Tim talked a little bit about monitoring earlier in his presentation. I really appreciate the fact that he did because it's really important. The site is already instrumented with a number of prisms so that we can tell how much is that site moving. We've been told, actually it was published in the paper, that the site is currently moving at about 1/10 of a foot per month. If it takes 5 years to build this, 10 years to build this, it's going to move 5 or 10 feet potentially, maybe more. Has that been incorporated into the stability calculations for the completed project? If it doesn't fall prior to the time that we complete it. Hold on.
Oh, yep.
Did I go good?
Thank you very much.
So anyway, the prism monitoring is really important. We know that the site has been monitored. Tim shared prism data dating back to, I believe it was 2010, and then that stopped. But the prisms have been in place since 2010, and I'd like to know that what's been the behavior of the slope since 2010, and I'd like an assurance that the engineers have taken that in, the movements into consideration as they determine these slope stability calculations and the analysis. I'm told that the information has been requested, but it has not been provided at this point in time. It is for safety purposes for the operators, I understand that, but given the nature of this engineered project, you would think that this was something that we would all want to know as we design the Pikeview reclamation. Right now, I told you the factor of safety is this equilibrium between forces. Right now, given that the site is moving 1/10 of a foot per month, factor of safety is currently less than 1 because it's moving. Okay, so the forces that are there to hold it back are not enough to keep it from continuing to move. So the factor of safety today is less than 1. So in summary, current design, in my opinion, you could not hand this design and plans and specifications to another contractor and say, give me an estimate, how much would it cost me to build this? There's a lot of discussion, there's a lot of narrative, there's a lot of text that talks about the plan, but I don't believe it's the detail that would be required to build. I don't think you could get an accurate cost estimate from another contractor based on the information contained in the mining plan as it exists right now. It violates the fundamental slope stabilization concepts that I talked about at the very beginning of my presentation, unloading the top, buttressing the toe, building a stable, well-compacted, well-controlled slope. It does not adequately remove the dangerous hanging blocks, has a potential to disturb a much larger area, expanding the reclamation needs. And unrealistically, I believe, relies on massive quantities of donor fill. And I think this is something that the applicant will need to address, is how much donor fill is it going to take to build this slope. We believe it's somewhere on the order of 2.3 million cubic yards. It's a lot of material to expect people to just drive up and dump at Pikeview and expect it to be of high quality, let alone just bring it in the first place and give it away for free. I believe Amendment 3 is easier to construct, and it certainly requires less quality control testing to a great extent because the slopes are so much flatter. Again, depending on how much import fill is required, I think it could take over 10 years to accumulate the amount of material necessary to build it. My copy of the March version of Exhibit D from the mining plan says 5 years. But I think it'll be at least twice that. Quality control plan is just a concept. It's not accurately defined. I don't believe that the plan ever achieves full stabilization as stated in the overview. It reduces the risk of future movement, but it doesn't ever say will stabilize the slope. The steep slopes already as calculated by DRMS based on materials that are probably better quality than what you saw in the Area H photograph are less than the required 1.5 factor of safety. I think that's huge. It's really important. And as a professional engineer, I certainly couldn't endorse Amendment 4 over Amendment 3. I think Amendment 3 is a far better plan, particularly given the end use of the property. Questions?
General questions for Mr. Vaughn?
Can you go ahead and stop sharing? It's
Yes.
the red one up there, or the top. I know, you can get that thing to work.
Kind of red there in the middle.
Yeah, that's the red.
Oh, I'm looking at the screen in front of me.
Right there, yep.
Okay, sorry about that.
Any questions before we do cross-examination?
No questions.
No questions. Okay.
I had a quick clarifying question.
Sure.
In your summary slide, you said it disturbed a larger area that needs to be reclaimed. Can you quickly summarize that? I think I may have missed that in your presentation.
Sure. So when I say that, I'm making that statement based on the applicant's indication that they're intending to use a considerable portion of that lower quarry area as borrow material for fill to construct their slope. And so if they do that, they will be having to rip and remove a considerable amount of material that's not currently, I mean, it's within the permit boundaries, but it's not within currently mined area. So that's what I mean by that. Does that answer your question?
Yes, thank you.
You bet.
Does the operator wish to cross-examine Mr. Vaughn?
Nothing from 220.
Nothing from 220. Does the division? Nothing from the division? Okay, and no further questions? Thank you.
All right, I'm so sorry about that technical difficulty.
Oh, no, that's fine. Thanks for speaking up.
Our final witness is Dan Bear. He's a professional engineer as well with 43 years of experience, split mostly almost 50-50 between government work and private sector work. He's an engineer with Matrix Design Group, which is a very well-established and well thought of engineering firm in Colorado Springs. I've worked with them a bit over the years. Dan's job requires that he cost down and large projects involving a lot of dirt work, and he does that as a daily living. He's going to talk about the adequacy of the bond. He's appearing remotely, I hope.
Yes, he is. It's right here.
I am here. If you're ready, I can share my screen.
Please do.
Yes, please.
All right, you should see our cover sheet there.
Can everybody hear?
I just want to confirm that everyone's good on volume and can see the slide if someone can let me know.
Audio okay?
Yeah, it looks good.
All right, great.
Thank you.
Well, I was prepared to say good morning, but it's good afternoon. So Steve mentioned a little bit about Matrix Design Group. We are a multidisciplinary firm, consulting firm, and had the opportunity to involve our construction administration group and our landscape architecture group to help evaluate the proposed bond amount. We've also been involved in several projects that are relevant to this project. We're currently the lead consultant for the U.S. Air Force Academy Visitor Center and I-25 interchange, a $280 million project. And as part of that team, we're responsible for finding funding, and we have a contractor on board as part of that team who was also consulted about what the cost might be to reclaim this quarry. My experience, as Steve mentioned, has been over a 43-year career. Many projects require the kinds of work that are represented in this reclamation project: earthwork, stabilization, revegetation, restoration. And some recent projects we've done up and down Fountain Creek were exactly in that kind of mold. We've also do drainage basin planning studies that require cost estimating. And I was one of the lead authors of the Fountain Creek Watershed Design Manual, which addresses guidance for design and restoration of sites once they're disturbed. So our key role was to assess the proposed total bond amount. And of course, that would require compliance with Rule 4.2.1, as Steve has already mentioned. Article 1 of that rule states that all financial warranties shall be set and maintained at a level which reflects the actual current cost of fulfilling the requirements of the reclamation plan. And Article 4 states the amount of the financial warranty shall be sufficient to assure the completion of the reclamation plan of affected lands if the office has to complete such reclamation due to forfeiture. And as Steve noted, that is more of a budget number rather than what you might get from a contractor who says what his cost is going to be to complete the plan. You have to consider other contingencies that might arise. So of course, a review of the Amendment 4 of the permit and the adequacy reviews that came after that application, and the cost estimate that was completed by the division on March 5th of this year was a major document that we reviewed. Some of the key factors that affect what the total bond amount might require are availability of the materials, where is it coming from, how much, the suitability of the materials, what's it made of, what's its quality, the completeness of the construction cost task list, application of appropriate construction unit costs, and reclamation plan uncertainties. What kind of contingency do you need to include to make sure you have enough funds? And I'll talk in more detail about all those. So the process we followed was to use the divisions format. There were several task items defined to identify direct costs. And then there were indirect and administrative costs in that cost estimate. We extracted quantities and unit costs from their cost forms to duplicate the total bond amount, identified tasks not included in that estimate. We researched unit costs based on regional project experience and contractor input. And we use the Association for the Advancement of Cost Engineering guidelines for determining what cost factors we use for contingency on our projects. And then based on all that, we calculated a bond amount using our added tasks and revised unit costs. And I would emphasize that we did not do an independent evaluation of quantities or conditions on the site. We used those quantities that were in the cost estimate prepared by the division. So sources we used for the unit costs included the Colorado Department of Transportation. They publish an annual cost data book. The contractor for the $280 million Air Force Academy project was also consulted. We have experience with over 5 miles of restoration projects in the Fountain Creek watershed. We developed the Monument Creek Flood Restoration Master Plan, which is the watershed that the quarry is located within. And then the Denver Urban Drainage and Flood Control District cost tables are a standard reference for projects up and down the Front Range. I also contacted management at the Chimney Hollow Dam, which is a $485 million project just getting underway, to compare what costs they're using with our costs on this project. This is a detailed breakdown that duplicates the division's cost worksheets. The white rows represent tasks that we did not make a revision, either in the amount or the unit cost, is reflected by the difference on the right side of no difference. The yellow rows indicate those tasks where we would recommend increasing the unit cost. And then the green rows represent additional tasks that we believe would be necessary to complete the project as proposed. And based on those revisions, the direct cost we believe would increase by over $10 million. To get into those in a little more detail, these direct costs included these 7 items that we added just to be represent what that might include. The most significant added cost was a nominal cost of $1 a yard to process imported material to complete the fill volume. And we realize that that's an uncertain volume, but that's based on the best information we had available. That would mean that this would account for what Craig was talking about, the uncertainty of what that fill material is composed of, and it might require some mixing with on-site materials. We adjusted 13 of the 23 unit costs, and the most significant of that was this task item 4E20, based on the recommendation of our contractor that we consulted with. That was a significant increase in the possible cost of the project. All these resulted in about a $6.5 million increase in direct costs. So to address the issue of how you determine a contingency, following this AACEI guidelines, they classify projects by the level of detail of design and how far along the project is in the design process. The less information you have, the more uncertainty, the higher the contingency can be, maybe as high as 100%. We have designated this project as a class 3, which is appropriate for budgeting and funding. That provides guidance on the range of contingency being from 20 to 50%. And we have determined that 20% is probably most appropriate. You can see here that even with the most detailed level of design, 100% with a high level of understanding of what the project involves, a 15% contingency could be appropriate, and the 3% is the absolute minimum that would be recommended here. So as you can tell from Carl and Craig's presentation, there's a number of questionable plan and cost elements that need to be addressed. Adequacy Review 1 states that up to 240.5 acres may be needed to get the excavated material required, but the cost estimate only includes 139.1 acres. The source and quantity of fill material to be imported is unknown. We've assumed the 2.345 million cubic yards that was stated in the original permit application, but that number is questionable. As Craig stated, this is a huge amount of material and would require about 150 20-ton trucks per workday for a period of 5 years continuously. But depending on the source of materials available on the site, this quantity could even be increased. Importing material at no cost is unrealistically assumed in the plan. Most projects are designed so that the material on the individual site that is in cut and fill are roughly equal, and projects are not intended to either import or export material, which is very expensive. So finding enough material to satisfy the requirements of the project would be very difficult. Again, the unsuitability of the material to be imported is not known and may require mixing with unspecified on-site material. The planned recreational use proposed could require that the grading plan be revised, and it could affect the earthwork volumes. In addition, characteristics of the on-site materials are in question. The quantity of rippable material, assumed to be 363,000 cubic yards, available has not been verified. Therefore, blasting of additional material could be required instead. The depth of the overburden material available from the lower Barrow area, assumed to be 915,000 cubic yards, has not been verified. The amount of material to be imported could be increased based on the availability of this material. Additional testing could provide needed information to better understand these site conditions. Other uncertainties as we reviewed the plan included the design specifications, as Craig referred to. The required fill material gradation is not adequately defined. There needs to be some clarification of how the observation and testing methods will be applied. Frequency of materials testing is too low, and the proposed soil amendments may not be adequate to enrich the soils adequately to provide for plant growth. So when you bring together those direct costs that I was talking about, including the added tasks and the unit cost adjustments, with the indirect costs that were identified in the division's plan, cost estimate for the total bond amount, we get a value of over $30 million with an increase of $16,800,000. We believe that the $30 million could be on the low side due to the application of a 20% contingency and the uncertainties in the project, and the possible addition of $18,700,000 to import 2.345 million cubic yards of material. So in summary, you could end up with a significant bond shortage. If you adopt the $13,390,000 bond amount, there's a risk of a $16,800,000 shortfall should the division be required to reclaim the site. The plan unrealistically assumes that imported material will be delivered to the site at no cost. Whatever material is required to bring to the site is likely to cost and increase the amount required to complete the project. In addition, that material needs to be available when it's needed. So considering that unknown factor, there could be a significant increase in the cost of the project. Again, Rule 4.2.1 requires that the warranties be based on actual cost and that they be sufficient to cover the cost of the project if the office has to complete such reclamation due to forfeiture. So with that, I'll turn it back over to Steve Mulliken.
First of all, I realize we're out of time, so that's our last witness, and we'll just hold off until our turn. No questions.
Yep. Questions?
I have one.
Sure, John.
Just, I didn't see it reflected anywhere in any of the material. Is this plan, and I've noticed this last witness has got knowledge of this. Is this plan reflected the new stormwater drainage program in Colorado Springs? Because the way I see it, this runs directly into Monument Creek, but then also Calvin Creek, which then comes into the Arkansas, comes right by my house. So I'm concerned. We've had problems in the past.
Dan, did you hear the question?
I really could not hear that.
Does this, anywhere in this plan, did you see whether the new stormwater plans that Colorado Springs has adopted was reflected in the drainage plan here on this site? I've driven by there 6 months or a year ago, and it looks to me like it's run over the road several times. So I have some concerns because, you know, I started the Lower Arkansas Valley District, so you guys want to screw us up down there, and you're still doing it. So Anyway, I just didn't see it in any of the material.
Yeah, most of the site is actually outside the city limits, so I'm not sure what jurisdiction they would have there. It's in the El Paso County, but El Paso County also may have some standards that need to be complied with.
But it comes very quickly into the city of Colorado Springs, so then they would have jurisdiction.
It does.
Anyway, I'm just curious.
We can try to get you that answer. I don't know off the top of my head that in their cost estimates have factored in the new requirements, because I know they're more stringent. City of Colorado Springs is trying to get out of trouble, you know.
They didn't have any, so that was a low bar.
Sir.
Cross-examination from the operator. 220. For unmuting.
Thank you very much. Mr. Bear, could you put back up the breakdown exhibit that you had that showed the unit cost calculated by the division and your unit cost?
Yes, just a second here.
All right. And I will say this is the first time we've seen that chart. It was not presented as an exhibit, so it's kind of new to us. But I do have a couple questions about that.
Having trouble getting back to that.
All right, well, puts me at a bit of a disadvantage because what I have is a projection that you did, that Mr. Mulligan presented to the city of Colorado Springs a couple weeks ago. And the numbers are different on what you presented to the city of Colorado Springs versus what you presented today. And so while you're looking for that, I'll ask a couple conceptual questions because I think it will go to the point, but my numbers aren't going to be completely accurate because I don't have the new numbers that I've never seen until 5 minutes ago in front of me. But generally, do you know how Mr. Kazir calculated the unit cost that he used when he calculated the bond amount?
Yes, there was a breakdown of equipment used, labor hours, distances of haul across the site, a very detailed breakdown, and then assigned cost per hour of equipment and all of that to come up with his unit costs.
Okay, and are you familiar with the Office of Surface Mining's handbook on calculating reclamation bonds? Did you look at that as part of this process?
No, but the process for calculating cost estimates is very similar project to project. It's based on the quantities, the appropriate unit costs, contingencies, other cost factors that were included in the division's estimate.
Yeah, but this is your first mining project, right?
I have not typically worked on mining projects, but I believe the process is very similar to many projects I've worked on.
Okay. And part of the reason I'm asking that is you don't have any reason to believe that what Mr. Kazir did is inconsistent with standard practice at the division or the guidelines prepared by the Office of Surface Mining, correct?
We came at this from the standpoint of regional experience with how projects are done, the cost of doing revegetation, the cost of moving earthwork in the region. If you had to hire a contractor, what would he tell you the costs would be? That's how we came at our estimate.
All right. Yeah. So again, that didn't answer my question, but I'm getting used to that by now. I just had one question about the contingency in the OSM guidebook. And I will say your contingency that you presented to the city of Colorado Springs, and again, Mr. Mulligan did the presenting, but it was your work. You were proposing a 30% contingency there. Now you've dropped it down to about 15. You seem to acknowledge that 3 was within the range, but the OSM handbook actually specifies that a contingency for this type of reclamation bond would be between 3% to 5%. So my question is whether there's any reason for you to diverge from kind of the standard industry practice on calculating that contingency.
Well, that's what we're saying, that this is standard practice within civil engineering. We use those guidelines. They're adopted broadly, and just the level of uncertainty in the project would require a higher contingency.
All right. Last question on unit cost. And again, I apologize to the board. I don't have the numbers that were presented to you in front of me. But the unit costs are really pretty dramatically different. And I'm going to use your Colorado Springs numbers because that's what I have. But for example, drilling and blasting granite for backfill, Mr. Gazier calculated about $1.40 a cubic yard. You came in, at least for what you told City of Colorado Springs, at $11. The cost of riprapping granite for backfill came in at 39 cents. You came in at $8, almost a 2,000% difference. Why is there such a huge difference between how the division always calculates its reclamation bonds and the unit costs that you're generating on this project?
Yeah, this has been a process. Those were intermediate cost estimates. We've done additional research. We've decided to be less conservative in this approach to the costs that we present to the board today. So there are acceptable ranges of unit costs. There isn't one number that is acceptable or accurate.
Okay, but it is a big difference. The last question for you, just going back to that, kind of sharpening your pencil in the interim. I mean, it is true that you went to the City of Colorado Springs City Council and represented to them that the cost of reclamation bond of this is going to be $57.4 million, correct? I mean, that wasn't just an interim step. You presented that in a public forum as a representation to a governmental body, correct?
That was where we were at that time, and we still believe that there's enough uncertainty in the project that those costs could be much higher than our current estimate.
All right, I have no further questions. Thank you.
Thank you. Questions from the division? Yes? We're unmuting.
I was trying to bring my screen back up, but it would not allow me to share. Okay, I can bring it up if we need to.
Again, Jeff Fugate on behalf of the division. Let me know if you are not able to hear me. I don't have any questions with this witness. I do just want to lodge a similar objection to the use of the various slides in the PowerPoint presentation. Like the company, the division had not seen any of those numbers presented, although we tried to scramble to write them down. This was the first we've seen any of them. So it puts us in a very difficult position of trying to figure out how and why they came up with a different calculation than the division. So just for the record, just lodging an objection to the introduction of those numbers.
Did everyone hear that okay?
Yeah, or Chuck, or now, one of you guys said we are going to request all the PowerPoints after this meeting.
Sure, we're going to request copies of all of the PowerPoints after this meeting. Okay.
And both for the division and the operator, we will note that the objections that the information in this last PowerPoint has been shared or served on either of you before this presentation. And just for the sake of clarity, Scott and Jeff, was the objection mainly to that comparison chart with the numbers, the detailed breakdown?
Oh, I'm sorry. I thought they were already unmuted.
Again, you're muted if you're talking, we're unmuting you.
They're not. Who is it that needs to be? Yeah, it was already unmuted. They can talk whenever.
All right, Jeff, you get it here on behalf of the division. I think our objection is not just to the one comparison slide, it's to any of the slides that utilized new numbers, numbers that were not previously disclosed or provided to the division in advance of the hearing. Again, I don't have a copy of that presentation, so I don't know how many slides that is, but any of them that included new numbers or information, I object to.
Okay, thanks, Jeff. And Scott, was similar to that, or?
Okay.
Yes.
Any more questions from anyone? No. Thank you. So it looks like we have a president, yes, you're gonna switch out.
That's the last one.
Yeah, that's the last one from
Yes.
Mr. Dean's presentation. And then we'll have a 60 minutes for presentation by CMC. And switch out the rooms here. So let's give ourselves 10 minutes. We're asking for 10 minutes. So exactly at 2 o'clock, please. Thank you.
Yeah. So, how you get your.
Okay.
All right, welcome back, everyone. 2 o'clock, so we are going to do presentation for 60 minutes. We have Continental Materials.
Yeah, just fix that one.
Just a reminder to please introduce yourself when you're speaking, and please, I know it's difficult when you're looking at your slides and kind of trying to talk to the slides, but trying to get your voice into the microphone as directly as possible so that we can hear and understand.
My name is Jerry Schnabel. I'm here representing Continental Materials Corporation for the Whitefield Quarry in Colorado Springs, Colorado. I've been a civil engineer for the past 40 years plus. All of that experience has been in the operating and management of construction materials and mining. I'm here today to follow up with our application for amendment number 4 on the Whitefield Quarry. We came to this board in 2019, roughly in June, and asked to be considered for an amendment to our reclamation plan based on what the current conditions at Pikeview are. Following the hearing, we posted our $15 million bond. We said we would bring in an application in August. We did exactly what we said we would do. We submitted it to the DRMS. Staff has been reviewing it for the past 6 months. And we're here today to ask the board to approve amendment 4 for four very specific reasons that we'll discuss later. Why even have an amendment 4? As you've heard numerous testimonies, and I've appeared in front of this board regarding this Pikeview slide, 2008, 9, and 15. It was described this morning as a dynamic quarry. I think that's accurate. Some of the comments made, I think, hurt me personally, but we're going to stay professional. The order of magnitude of this slide is uncommon. That dictates that we be careful and diligent in our process. Safety is the overriding factor, then stability. Aesthetics and the others come later. Safety has always been our priority since this slide happened. The CEO and I have discussed it numerous times. Each conversation ends with no one gets hurt. I'm very proud of the fact, despite what you heard this morning, in the last 14 years that I've been in charge of both the mine plan design and the operation of that quarry, no one's been hurt. We've not had any accidents. I'm very proud of that. We intend to continue that to the completion of this project. The last amendment in 2013 was based on the information we had at the time and the site conditions as of 7 years ago. Being a dynamic site with a slide, this site has changed dramatically in the last 13 years. It's also changed in the last 7 years. Amendment 4 takes into consideration the current condition of what's going on at Pikeview. Some of our information comes to us in annual lots. Every year we look at this, and every year we gain more and more knowledge of what's going on the mountain. You see some changes in the mountain, you see some changes in the geology. We also see changes in the economics. A decision was made to close Pikeview and mining. Once that decision was made by the CMC Corporation, it dictates that we do not remove about 5 million tons of limestone that was called for in Amendment 3. You saw this morning the hanging scarps, and they showed that as a bad thing because they've broken up. That's actually a good thing. Not one person this morning talked about how they would deal with those large limestone scarps. We've dealt with them. The fissure they showed you on the south end of the quarry is one of the first cracks I stepped across 13 years ago. I've known it's been there for 13 years and I've dealt with it. We'll continue to deal with these things. Currently, we want to close this mine, leave the limestone in the toe. One of the biggest conditions that have changed is that limestone remains in position. Mobilized, gravity fed it down into the toe, and it absolutely is the best and safest means of constructing this toe. Over the last 7 years from amendment number 3, the data we've gathered has been actual data from the survey monitoring system that we implemented in 2009. At that time, it was a very experimental instrument, limited in what it could do as far as data transmission and gathering. but it is proven to be absolutely reliable, dead accurate, and it's the same as having a survey crew up there full time. It's absolutely proven. Using that information, especially what we gained over the last 3 years with this massive amount of limestone movement and rubblization, we're here today to implement a plan that has been engineered through Stantec. You heard a lot of names about the past, a lot of engineering firms, all very reputable professionals. I think in Stantec, I'd like to point out that we have one consistent line. All costs has been with this project for 10 years or more. He went from Norwest to Stantec through an acquisition. We also have Bruce Humphreys. We have a team in place that's been with us for a number of years. We rely on their expertise. We don't take just their decisions. We cross it with the RMS and others. We've talked to 5 or 6 contractors. So we think we've brought to the board Amendment 4 in a very concise plan. We talked about 4 reasons to switch to Amendment 4. I disagree with the experts you heard from this morning or this afternoon. Our primary reason, number 1, is safety. Number 2 is the stability. Number 3 is the speed of simplicity. And number 4 is the aesthetics. All 4 come into play. You saw the engineered goals, and we're achieving these 4 in Amendment 4 that will be far, far better than anything in Amendment 3. Starting with safety. They claim that Amendment 3 would be safer. That's not true. Hauling loaded trucks down steep grades is not as safe as grading lower areas with scrapers, trucks, and moving that material horizontally into the tow. Plan 4 is a much safer plan to operate and implement. I said at the beginning that I'm in charge of both the design phase and the constructability of this project. You can't have design and operations separate from each other and deem it safe. You have to combine the 2. Amendment 4 we talked about as being faster. Amendment 3, what the experts this morning failed to realize is that when you're working top and bottom in a quarry like this, you cannot have vertical alignment of those crews. They have to be either offset from each other or one stops operating altogether. In Amendment number 4, we basically have people working from the bottom up to a certain point, and then unlike they demonstrated this morning, at a point somewhere up on the mountain towards the top of the limestone, we will then go back into the granites and remove those high walls. So the speed is actually cut in half because we can work the crew full time. We don't have to worry about staggered starts and stops. Amendment 4 is frankly, as a constructible project, much, much simpler. We're taking materials from our buffer properties, loading it into either scrapers or trucks, depending what the contractor we choose would use, and moving it into an area that would start out somewhere between 2,000 feet long and 1,000 feet wide. It's a tremendous, safe working platform, very capable of compacting that dirt. We've already proven that through the backfill of Area H. We put 2 million tons in there. We know it works. Simpler. There are 10 contractors, there's 1 contractor out there that can move dirt compared to 1 contractor that does mine reclamation. Blasting and drilling rock at the top of this quarry is not the simplest way to do this. We have opened up our contractors list to 6 different qualified contractors, each of which are immensely qualified to do this project. I think the big advantage is they have experience in mine and in civil projects that you saw this morning. The 4th advantage, and this is where the city will talk later, the 4th advantage of Amendment 4 is the aesthetics and end use. A lot was said this morning about the high walls. You have 2 choices with high walls, remove them or stabilize them. We're going to do both. We're going to remove part of the high walls and shape back to a natural looking top, and we're going to buttress the bottom. That ensures that we don't get movement. And I think it's important to point out that the granites up on top have not moved. Some of the scarps that they showed you were road cuts from the very, very beginning going back to the 50s or 60s. So the scarps up there aren't as dramatic as they would have indicated. We do know from our instrumentation that the granite behind the limestone has not moved in the last 13 years. The Amendment 4 reduces that high wall, which in Amendment 3 would be 470 feet tall from top to bottom. Yeah, the gradual slope at the bottom is minor. Under Amendment 3, we raised that fill up to only exposing about 100 feet of high wall at the top. That's a tremendous advantage. The other part is the overall high wall exposed is reduced from 15.5 acres to 1.8. There will only be 2 acres of the granite left as a high wall even exposed. And that will be cut back to competent rock and left as a natural looking outcrop. That's the aesthetic part. We'll learn later from the city, that gives the city confidence that this will be useful as a bike park. It'll be safe. Our contracts with the city indicate that if it's not approved, stable, and ready to release, they don't accept it. We wouldn't want them to. The last thing I'd like to talk about is how we got here. I've been in front of this board for the last 13 years. This amendment has been vetted through our consultants. You've heard Exponent, Siege Miller. Paul Koss has been with me on this project for the last 10 years. Paul is a unique engineer in the fact that he is willing to put his boots on, climb up to the top of Pikeview with me, and see firsthand what's going on. That's a very important differential in how we resolve this. Since Amendment 4 was submitted, we've not only had Stantec involved in this, we've gone through, that is the attorney terms. We've gone through a scrubbing from DRMS. Tim Kazir is a very professional engineer, very thorough. I have a lot of regard for him, and a lot of the things that he brought to us, we've incorporated. When they did their separate stability analysis, Paul did his, Tim did his entirely separate from each other. And they both came back to the same answer. Amendment 4 will be stable. It will be safe. That gives me a lot of confidence going forward. There's still one more check, and that's the monitoring system. Their opinions have to be double checked and proven out by our surveying system. And if it doesn't stabilize this, we'll know about it. We'll know about it in the first 90 feet of fill, and we'll correct it from there. I'm confident that the survey system will back up what Tim and Paul have already calculated. And then we get to the third layer that we're here today. I appreciate the public input. We've gotten 150 questions from Mr. Dean and his consultants. Some of them I think are misunderstandings on their part. There is enough dirt on site to finish this project. We have filtered the water continually from the Waldo Canyon fire forward. We have a very good stormwater system in place and have for years. It's been tested under the worst conditions possible. And it's proven that we can control the ash and the runoff from the worst fires in El Paso County's history. It'll work going forward. We have never released any dirty water to the city and will not do that in the future. That's the importance of having this third-party review. But after going through all of these triangulated reviews, I'm still here today to say that Amendment 4 is by far a much better plan. It's safer, it's faster, it's simpler, and at the end of the day, the slope will be stable and useful. And that's why I'd ask you to approve that today without conditions so that we can get started on the reclamation and finish this project in a timely fashion. I think it's good for all parties involved, the city of Colorado Springs, El Paso County, state DRMS, and certainly Continental Materials Company. Thank you for your time.
We'll stop there for questions.
Any questions?
Nothing here.
And I guess just ask if there's any cross-examination from anyone in addition to questions.
Oh, hold on.
I'm not seeing.
No questions.
No questions. Okay, thank you.
Very good. Thank you. So next, hopefully joining us by Zoom, will be Britt Haley. Britt is the City of Colorado Springs Parks Department Trails, Open Space, and Parks Program Manager. We also have by Zoom Justin Spring, who's the Senior Project Manager of Conservation Acquisition for the Conservation Fund. They're both going to talk about the city's transaction. So to me, it might make sense just to let them both, they just have statements to make, ask them both questions rather than break them up because it's kind of a related set of presentations, but obviously defer to you on that. So do we have, Britt, are you with us?
Yes, can you hear me?
We can.
Great. Well, thank you for that introduction. My name is Britt Haley, and I'm with the City of Colorado Springs Parks Department as the program manager for the Trails, Open Space, and Parks program, which is a dedicated sales tax program to support purchasing open space, stewarding our open space, trails, and parks. And I appreciate the opportunity to share our unique vision for the property that's owned by Continental Materials as part of our open space system, and then also for a kind of unique separate opportunity with the Pikeview Quarry site itself as a potential future mountain bike park. You know, the City of Colorado Springs has had an open space program since 1997, and it dedicates 1 cent on every $10 of purchases in the state or in the City of Colorado Springs to a special fund for parks, open space, and trails. And that generates about $9.5 million per year for the program. We have an amazing opportunity here, and I wanted to emphasize that it's got two pieces to it, one of which is the open space acquisitions I'm going to talk about next. And then at the end of reclamation, also potential for a donation to make a potential future mountain bike park. Our open space program has just over 340 acres of candidate open space property under contract with Continental Materials and the Conservation Fund, who is serving as our conservation finance partner on this important transaction. The contracts are contingent on approval as recommended by your staff of permit amendment number 4. The properties are the Black Canyon, or as you know them, the Snyder Quarry, and then the Pikeview Quarry frontage property, which is 148 acres, which buffers the actual Pikeview Quarry site itself from the residential neighborhoods that are to the east of that quarry site. Both of these properties have been identified as important candidate open space areas in our park system master plan process by the public. And most recently, that was updated in 2014. And I'm happy to report that our city council, which consists of 9 members, has unanimously approved these open space acquisitions. I think it's important to tell you why these properties are special to the city. One of the top goals that citizens have consistently identified in our park planning processes is the need to protect and also connect the properties that form our western mountain backdrop to the city. It makes our city unique to have an uninterrupted mountain backdrop that's formed by open space. And all of the property that is to the west of that mountain backdrop is Pike National Forest property. And what that means is that every time we make an acquisition of this nature on the western mountain backdrop, we amplify the open space attributes that we are purchasing exponentially in terms of uninterrupted wildlife habitat and the potential for public access. Similarly, the Black Canyon or Snyder Quarry property is top quality open space in its own right. It features the beautiful Williams Canyon to the west, and to its north is also the Pike National Forest property. But importantly, that's the Waldo Canyon area that burned so horribly in June of 2012. Now, 8 years later, the United States Forest Service is conducting its Reimagine Waldo planning process to determine how to reopen that Waldo Canyon Trail area to public recreation. But unfortunately, the trailhead that used to serve that area off of State Highway 24 has been closed due to legitimate safety concerns, and that significantly limits the options for public access back into that area. What's unique about the Black Canyon Quarry property is that if it could provide the trailhead access and serve that purpose to the public as well as its open space qualities, it becomes then a regional open space asset that beautifully solves that challenge. So those are the open space acquisition components. But to bring the city's opportunity up to 440 acres in total, Continental Materials proposes to work with the city during reclamation and then to donate the reclaimed 100 acres at the Pikeview Quarry to the city for our long-held desire to be able to develop a mountain bike park. In fact, we often say a world-class mountain bike park. Our citizens, a lot like most communities, are absolutely crazy about the sport of mountain biking. And we keep hearing continuously that our citizens would really like a park dedicated to that purpose for all skill levels, whether it's your expert thrill seeker or if it is the beginner. And we would love to see this come to fruition. We view this proposal as a pretty fascinating opportunity in terms of a public end use for a reclaimed quarry, if based on the reclamation and working together with us to make that happen. However, because of all of the public use that we would envision for that potential final use of the 100 acres, as you consider the amendment request in front of you, we want you to understand that final use. I'm willing to venture a guess that you've not had such a transformative recreational end use proposed in past reclamation amendment hearings, and therefore really appreciate this opportunity today to present that idea and to thank you for your consideration of the amendment and also for your service on the board. That concludes my remarks.
Should we have Justin go ahead?
Sure, and then we'll do questions for both after that. Thank you. Go ahead, Justin.
Great. Can you hear me okay?
Yes.
Excellent. As you heard, my name is Justin Spring. I'm a senior project manager for the Conservation Fund. The Conservation Fund is a national conservation organization. We are headquartered in Arlington, Virginia. We have an office here in Boulder and have been active in Colorado since the 1980s. Nationwide, we have protected over 8 million acres of land and water. About 250,000 of those acres are here in Colorado. We are perhaps best known for helping to protect the Greenland Ranch in southern Douglas County along South I-25. We are unique among conservation groups in that we have a dual mission in helping our partners to protect properties with both environmental and economic outcomes. At the invitation of the City of Colorado Springs, the Conservation Fund is helping the city to acquire the Pikeview Buffer property from Continental Materials. We do have a contract to purchase the 148 acres, and we plan to convey the property to the city over time for future open space use. Continental Materials has been working in good faith to make this transaction happen. The buffer property is located east and north of the quarry and provides a key trail connection to the adjoining Blodgett open space. The Pikeview Quarry is a key component of a larger vision to protect a statewide goal around the Front Range mountain backdrop that also pertains here in Colorado Springs, as you heard from Britt about the Mountain Shadows open space. So it's a key cog in a much larger regional vision or statewide vision if you think about the backdrop running from Fort Collins to Pueblo. My understanding is that the desired reclamation amendment will provide for recreation as a potential future use. This would allow the city to integrate the property into a significant network of parks, open space, and trails. It may also allow the city and the community to eventually create a world-class bike park. Thank you.
Thank you. Any questions? 220. Okay, 220 I know has a question. Can you unmute them, Candy?
Yep. It'll let me. There we go. Oh, almost. Come on.
We're still trying to unmute you.
There it goes. Sometimes it just doesn't want to.
Can they unmute themselves? No.
If you pound on it really hard, sometimes.
Yeah, I know, like, I sit here and I'll do it for a minute.
Can you click on the icon up in the picture?
Oh,
let's see here.
Upper right-hand corner.
See on his screen, there you go.
Just wants to bite me.
That's Jared.
There we
There you
go.
go.
Okay, you guys are unmuted.
I think they are.
Thank you for your testimony today. I assume you're still on. I had just a couple of questions that I'd like to.
Jerry, can you talk a little louder, maybe step up closer to the TV if possible? Sorry.
Is this any better?
Yes, it is, thank you.
Sure, thank you. Britt, there has been some discussion in the hearing so far about what we call the lower borrow area. You refer to it, I think, in your contract as the area around Pikeview Quarry, the buffer properties. And the question is, in the materials have been filed by Continental Materials, where the questions have come up, where are you going to get the fill that is needed? Initially, there was an indication that with some of that it was unidentified for 2.3 million yards, but in more recent ones, they indicated that they could take it all from that lower borrow area. So my question is, isn't it true that when the city council approved the acquisition of that property, that it put a condition on it that the Continental Materials could not take whatever they needed or wanted? They could only take what was approved through a grading plan approved by the city of Colorado Springs, consistent with the long-term bike park plan.
Thank you for that question. I think there are two components here to talk about. And one of them is the city council presentation talked about an area in the acquisition area that was called the fill dirt removal agreement area. And that area is about a 7 to 10 acre area that our city staff, our senior landscape architect here in the Parks Department, has been working with Stantec Engineering to identify the grading plan for that property that would allow borrow material to come over and potentially enhance ultimately the outcome for both either the mountain bike site and the acquisition area. However, there is another area that is in the mine permit area right now, and I think that's the area that you were speaking to. That did not garner any discussion at the city council meeting.
The fill agreement that you indicated is still in process, and so there's no right under that agreement right now for Continental Materials to take material. It requires the city approval. Is that correct?
I think, let me characterize it as I understand it, and we'll see if we're on the same page, Mr. Mulliken, but it's my understanding that with regard to that area, the city would need to be the one to submit a grading plan and be in total control of that particular aspect of the fill dirt removal agreement. So at a future date, the city would submit that and be the one that's responsible for it.
And that area you indicated would be limited to 7 to 10 acres?
That's correct.
Okay. And during the city council discussions on this, it's true, is it not, that the city council members expressed concerns that they didn't want to be perceived as approving or endorsing Amendment 4 over Amendment 3 because they had no expertise and they were looking to the state to exercise that judgment for them?
Yes, I think you said that eloquently. This board and its staff are the ones with the expertise to determine the outcome here. What our purpose is to help them understand what we have at stake in terms of the open space acquisitions and the final potential mountain bike park donation property. So we want to keep those things separate, but it's also important to understand the final use and how they're dependent on each other.
In the total, thank you for that. In the total acreage being acquired by the city around Pikeview, is there any area that you think Continental Materials has absolutely free reign to pull material from, or is that all subject to your discretion, you, the city?
Well, currently, because they own the 148 acres and they own the 100 acres, assuming that they could work it out with the state's requirements, they could take any of that And we know that the alternative to open space is residential development across that 148 acres, which could mean that that entire site gets scraped completely for that purpose. So we believe that right now they're in a spot with total discretion. If the city purchases the 148 acres with the help of the Conservation Fund, then it's only the 7 to 10 acre area where we believe that we would be, having that impact on previously undisturbed area. Certainly there's disturbed area around their offices and on the site, and that area we expect would contribute to the fill that would ultimately be built up for this mountain bike park use at the end.
Just so it's clear, the city council did approve acquisition of that 148 acres, but did condition that on any removal of fill would be subject to the city's approved grading plan. That is correct, is it not?
That particular discussion was limited, however, to that fill dirt removal agreement, which was the 7 to 10 acres. I just want to be very clear because it's a complicated situation for sure.
No further questions. Thank you.
Thank you. Any other questions? Anything from the division? No?
All right. So if we could authorize Corey Christensen, you can see Corey up there. There you go. So Corey Christensen is going to share his screen for us for our presentation that Mr. Koss is going to go through. And while that's coming up, I will just allow Mr. Koss to introduce himself and then get started on this presentation.
Sounds good. My name is Paul Koss. I'm a senior geological engineer with Stantec. I have about 24 years of experience in the natural resources industry. Essentially, all of those are in the mining industry, doing mine development or mine reclamation. And as you know, mine development, when you develop a new mine, you do that with reclamation in mind. So I have vast experience in mine reclamation, and these sites include aggregate mines, coal mines, metal mines. I'm a licensed PE in Colorado and several states and provinces. And I have a Bachelor of Science in Geological Engineering from Colorado School of Mines. As far as Project Lakeview, I've been working on the project for nearly 10 years. I came in after the 0809 slide happened. We were brought in to evaluate the reclamation plan and evaluate the cost of it. And then we went from there, we developed Amendment 3. We provided owner's engineering services during the operational period, and then we prepared Amendment 4. And specifically on—
Can you talk into the mic?
Okay.
Can you please talk into the mic so we can hear you?
Okay.
Thank you.
I'll talk into that. So specifically for Pikeview, I am and was the project manager and the project engineer. I am the engineer of record for Amendment 3 and the engineer of record for Amendment 4. And with that in mind, I want to say that Amendment 4 is vastly superior and should be approved and implemented. You've heard about it being potentially bike park. As far as safety goes, I'll be there on day 1 when it opens. I've got a green trail, maybe blue trail. Not that good, but I will be there because the site will be safe. Before we get into the other details, Corey, can you pull up slide 7 to talk about where the fill areas come from? So you're going to see the permit boundary in a blue line. So Continental Materials is authorized to remove material from anywhere within that blue line. That's your discretion or your jurisdiction. The 7 to 10 acres that Britt was talking about are outside of that blue line to the north, actually. So that 7 to 10 acres that Britt mentioned requires a city grading plan to be permitted, and that requires city approval. But to be clear, we do not need to get any of that material. All the material required for this reclamation project can come within this blue line that you see right here. So carrying on with, so I'm going to take it back, go back a little bit and go through the fundamentals of factor safety. So factor safety is simply a ratio of the resisting force to the driving force on the slope. It's the brakes to the accelerator. So the driving force is the material, the weight of the material, gravity, high on the hill. The resisting force is actually friction between particles, and it's the weight of the material low on the hill. So if your factor of safety is above 1, the resisting force is higher, you have a stable slope. If your factor of safety is below 1, your driving force is greater, you have an unstable slope. When those are equal, you have equilibrium. It's a very delicate balance. And really, that's where we are right now. Before you heard that the factor of safety is below 1, the slide is settling on its own weight. Maybe it's at 0.9, or maybe it's 1.0 or 1.1. Those are all roughly about the same, but it's very close to 1. So also the factor of safety is, once you get above 1, it's stable. It's a yes or no question. There's no, it's kind of stable. It's anything above 1 is stable. So 1.3 is stable, 1.5 is stable, 2 stable, 10 is stable. As you get to a higher and higher numbers, all you're doing is over designing that slope, and you're wasting money because you're moving material that does not need to be moved. You see in front of you the MLRB standards for factor of safety. And I really like how you did this because it compares and quantifies the 2 most critical components. On the vertical, you have what you know about the site. That's your geologic risk. So when I say risk, I mean geologic risk. When you put in a borehole, you know exactly what's there. You know how thick the materials are, where the fractures are, you know everything about it. If you go over 10 feet, it's going to be slightly different. That's geologic risk. And the way you compensate for geologic risk is you over-design things slightly. You put in these factors of safety. Because you know that right here we have these conditions. This driving and these resisting forces have this balance. When we place fill at the bottom, some of the materials can be this, some's going to be a little bit of that. They're not going to be identical. It's impossible for it to be identical. So those slight variations are the geologic risk. That's why you have this factor of safety to compensate for it. On the horizontal, you have critical and non-critical structures. And critical structures are things like residences, pipelines, tailings dams, regular dams, buildings, heap leach pads, things that if it fails, there's a huge consequence. There's a real expensive, there's environmental damage, people potentially could die. We really don't have that here. This is a slope that is simply being backfilled, graded, and vegetated. And that's really it. So I mean, I would actually argue that we have, based on the data that we have, we would be in the upper right corner designed to 1.25 static, 1.10 static. I could really argue that. That's really where I believe we should be. However, to be conservative and to avoid arguing whether it's critical or non-critical, how much information we have or don't have, we went with the highest numbers there, 1.5 static, 1.3 pseudostatic. Remember, static is just the weight of the slope there, and then pseudostatic is when you include a seismic component to it. So carrying on to what we designed and how we designed the slope. The Pike Peak reclamation starts and ends with stability. We started our design by putting in 3 cross sections. You've seen those already. We started with the drilling data that was done during the slide investigation. We created these cross sections. And then we started adding the backfill component. And we adjusted that backfill until we reached the targets of 1.5 static, 1.3 pseudostatic. That took a few iterations, of course. Then we took it into our mining software, created a 3-dimensional surface that had those criteria, 2.25 to 1 overall slope. That took a little going back and forth as well. Because first they would put in there and there'd be a high wall on the high wall, and then we need to create that back. Or there'd be this or that. So when we started with that slope, we went to the northern and southern extent of the landslide, drew a line straight up and down and said, everything in here needs to be 2.25 to 1. And then we started transitioning the slope outside of it. So these factors of safety that you're seeing, these are what we calculated, and DRMS actually duplicated these numbers. As you can see, they actually exceed the 1.5, 1.3. So we go on to the next slide. You can see the numbers that the opposition actually used, that 1.4 and 1.41 and 1.44. Actually, before I get into that, the main thing I want to point out, all these numbers are greater than 1. all these numbers say that this slope is stable. And it's actually quite stable. So what those numbers on the far right mean, it's actually, we know that we're going to have a mixture of materials that come in and a mixture of borrow areas. So some of the materials can be waste rock, some of it's going to be mining fill. And that number, those numbers on the right are actually the weakest material that we could think of that could potentially be used on this slope. And as you can see, it's still very stable. There's really nothing that would be or could be put up there that is weaker than that. So those would be the lower bound. And when you're doing a sensitivity analysis, you don't design to your actual factors of safety. You design, you want it, you're saying, this is the absolute worst case scenario. Is it still stable? And yes, it's still stable. Carrying on, so there's been talk about our backfill plan. So I want to clarify that this is an engineered slope, but it does not need to be engineered fill. In a mine reclamation project, all you need is to place material at the bottom. You need a lot of weight to increase that resisting force. That's all we need. We are compacting the material because it actually gets pre-consolidated and avoids that settlement. Kind of like Mr. Kazir said, when you stack a bunch of pieces of paper, the crumbled up ones on the bottom will smooth out. All we're doing is smoothing those out as we're building the slope up. And this is not an unusual project for a mine reclamation. It's simply all we're doing is picking up material, hauling it, dumping it, and compacting it. But really, in mine reclamation, you don't need to compact it. Corey, next slide. Next one after that. So we talked about, we are going to monitor the slope. That's actually a key component to it. There's going to be continuous monitoring from the prison system. There'll be daily monitoring from the operators. There'll be monthly monitoring from an engineer, that's me, and the monthly monitoring from a drone. So the prison system will be every 15 minutes. It takes a reading from all those prisons, and then those are recorded. And we can see if anything is moving. The daily inspections are from the operators. MSHA requires that they have the safe work conditions. So they have to be out there, look at the slope and say, okay, before we start working, are there any signs of instability? If there are, they have to address them. MSHA requires that. And then on the monthly inspections, I'll be out there also looking for any signs of instability. And I mean, signs of instability are cracks, bulges, seeps, oversteeping areas. There's a classic list of signs of instability. We'll look for all of those. So I'll be all over the slope, crawling around, looking for those. We'll also have a drone inspection, and it'll take the surface, so we'll be able to compare the two surfaces. And we'll compare those and see, all right, is there any movement that wasn't recorded by the prisons for whatever reason, and isn't visible. The other thing is it has an aerial photo looking straight down. So you can look at it and look for signs, things that may not be visible from the ground. So carry on, Corey. So this is the, you can see the quarry area, and I want to restate that all the fill is available on site. So we actually have 4 barrow areas. The upper barrow area is actually granite that we hauled down and or dozed down. Basically, once we get the fill high enough, it can be brought down safely because we have a buttress there. And that would all be waste rock material, that higher strength material. And then actually the north barrow area where the shop is on the north end, and then the lower barrow areas, those are actually all mine rock as well. So the vast majority of the material we plan to excavate and use for the backfill is mine rock, because we can see what's there. It's limestone that was placed during the operation many, many years ago. It's actually oversteeping slopes that need to be laid back. So we're going to lay them back to 3-to-1, take a bit more material, and then revegetate them. We're going to use that material, place it in lifts to create the slope. Corey. So we kind of talked about the review. This actually received a very thorough review. Tim did a very good job in addressing the questions, and Mr. Dean actually had a lot of questions and comments as well. And we actually, I appreciate that, because What it did is it clarified a lot of the details. It made it a much more robust permit, something very specific for CMC to follow. On the point of that slide. Go on. So earlier I said that Amendment 4 is better than Amendment 3. The opposition has said that 3 is better than 4. Here is why Amendment 4 is better. Really, the new plan is bottom up. We're going to bring material in, standard construction, place it, spread it, compact it, and keep going up. The 23 plan actually brings material from the top down. Some will be placed in that bottom up manner after it's hauled down the hill, but a lot will actually doze down as well. It's actually a lot easier, and it's traditional mining practice to actually just doze material down the slope. The current plan does not require any testing. It only has compaction spec. Our new plan has confirmation testing. If something does not pass the testing, it'll be recompacted until it passes that spec. As Jerry mentioned earlier, the haul direction. In the current plan, you're hauling all that material from the top down, and that's less safe. The haul trucks are really designed to be hauling from a pit, lining up and going uphill. If there's a malfunction, you want gravity stopping the truck, not picking up speed. So it's safer for the operators. And the grading timeline, we have a lower volume that we need to move, so we can do that more quickly. It's also, we can work from here, place it there. We can actually have multiple operations going at the same time. We can actually speed that up if we really needed to. Whereas in the 2013 plan, you can only have one operation going at one time. You can only be big enough here because you can't be working below them, and you have a very long haul route. And so it actually takes a long time to actually implement. And the opposition has said that the 2013 plan is simple. It is not. It may look simple in cross section, but when you actually try to implement, it is a very, very complex plan. And actually, it would be very difficult. The current plan is very simple. Like I said, it has multiple operations, standard processes. Just pick it up, haul it, dump it. The next few are really getting the visibility, but it also gets the high wall. And the current plan has 70 feet higher in elevation. That is all high wall that will be visible to the city of Colorado Springs forever. It'll be benched and revegetated benches, but they are 30-foot benches with some trees on them. So you will be able to see those forever. The current plan is 70 feet lower, but we also have only 100 vertical feet of high wall. And that's that granite slope. It looks vertical now, but it's actually going to be laid back at a 1-to-1 slope into a stable configuration. Whereas on the current plan, we have 470 vertical feet of high wall that will be there forever. Both plans are stable. They talked about, well, one's has a higher factor of safety. That plan is over-designed, it moves more material than it needs to. Both have the same revegetation plan, and they talk about one plan being less expensive. We want to save money on this plan. Well, you know how we're doing that? The current plan has a 2.5 million cubic yard surplus. That's the money that was being saved. Why should we have to remove 2.5 million cubic yards of material? The intent of that is all the limestone that's on the side of the face there. That's the material that was going to be processed and sold. So to implement the 2013 plan, it requires reopening the mine, processing the material, and then selling it. So you don't have all the surplus material. So next we're going to go on to kind of comparing what our current plan is to industry standards. So really the industry standard for a slope of mine wall, mine slope is 1.3 static, and 1.0 to 1.1 pseudostatic. We're above 1.5 and above 1.3, so we see those standards. Lift thicknesses, 10 to 30 feet. On a waste rock pile, they can be as 50 or even 100 feet. They're not compacted at all. We're going to place a material in 1-foot lifts, and it's going to be compacted. It greatly exceeds industry standard. Slope gradients for reclamation, 2 to 1 is about as steep as you go. They mentioned that you can't go up and down to 2 1/4 to 1. That is completely false. You're using bulldozers to create the slope into the final grading. They can go up it, they can back up it, and they can go down it. And that is really the criteria for whether something is easy to construct or difficult to construct. If a bulldozer can back up it. Because if you can't go up it, then you have to go all the way around and it makes long travel times. With a 2 1/4 one, a bulldozer can easily go up. Revegetation, we include grasses, trees, and shrubs. Normally, trees and shrubs are not included in a reclamation plan. And then construction, normally when you have a mine project, you simply just goes downhill. It's placed loosely at angle repose. There's literally no compaction. There's hardly even any lifts. Instead, we're placing this material in 1 foot lifts, provide compaction. We're committed to testing to 90% standard Proctor every 5,000 cubic yards. They said that's not enough testing. Well, that is 740 tests throughout the life of the project. So that's actually a lot of testing, and there's actually no requirement in mining industry to test compaction. Similarly, moisture conditioning, we're going to make sure we're at the optimal moisture content, and if we fail the test, we're going to recompact it. Let's carry it on. So I'm going to walk you through a little bit through the 2013 reclamation plan. And so you can see up at the upper end of the slide, all the contours are really close together. That is all the high wall that is remaining up there. That's the 470 vertical feet. The lower slope is your 4-to-1 slope. So all the material must be moved from the top to the bottom. You need to start way at the tippy top, start mining the bench down. In the meantime, you're trying to mine the limestone from down below, and then adjacent to that, you're placing your fill. So you have 3 different operations, and it really becomes a shell game of how you remove that limestone without causing another slope failure. So the CGS says that there's pending failures. They really imply, they wrote that in the 80s, that was really intended for future mining. So Amendment 3 requires future mining, and that's where you're most likely to have a future failure. Amendment 4 has no more mining, unlikely to have future failure. Let's go on to the next slide. We highlight the high wall that remains, and it's kind of an oblique view. So you can see that the darker blue is the blue color, that's the high wall that remains, and the green is more the vegetated slope. So again, that high wall will be there forever under Amendment 3. On the current plan, you can see that there's very little high wall that remains. There's just a little bit where the contours get really close together at the upper slope. It's all laid back at 1-to-1, so it's stable and granite. And the lower slope is at 2 1/4-to-1 to easily be revegetated. On the next slide, you have the same view as on the previous plan, but that's all the high wall that remains. It's lower in elevation, there's less of it. And the next slide actually compares the two. So look at all that high wall that could be there under this plan. And that's why this plan is better. It has much less high wall that remains, it's much less visible. And frankly, it's stable. Both are stable. Next, we're going to go on to stormwater. Well, next is the seed mix. So we talked about the seed mix briefly. Here's the seed mix. All these species are adapted to this climate, these conditions. So we know they'll grow. They've been proven to grow at sites throughout the West, throughout Colorado and the Front Range. There's not really a question if that'll happen. Right, next slide, Corey. So we're going to talk about topsoil. So you can see that the 2 orange piles there are our current topsoil stockpiles. We have about half the topsoil on site that we need. The rest of the material will be actually generated using soil on site mixed with organic material to create a growth medium. As you're aware, this is very common in pre-loss sites. Every mine I've worked on that has any decent history has a topsoil deficiency. And this is exactly what they do. They use the material on site, they bring in organics, and then they create a growth medium. And it works the same as topsoil. I've seen it in many mines throughout the West. I've seen it on spring reclamation projects up in Boulder County. You add organics, you add your seed, and it grows. Because you have soil that's suitable, you have organics, and you have a seed mix suitable to the site. And I've seen this work on 2-to-1 slopes, steeper than 2-to-1. And so there's really not a question about it. But we've also increased the bond to compensate for vegetation failures as a contingency. Corey? So there's been talk about the bond, and I think one of the big differences we have between our calculation and what the RMS did is that unit cost. We didn't pick unit costs. We broke it down to, we need to move this much material, this much distance, using these equipment, these operator rates, this fuel consumption. We broke it down to a very detailed cost estimate and then calculated the total cost. And then you divide by the volumes to get a unit cost. We didn't pick a unit cost out of a handbook. That's a much lesser process. This process is very robust. It's based on industry standards. It's how we've done many projects. And I think the fact that our numbers and the RMS's numbers are very similar suggests that this bond is adequate. So next slide shows the RMS's bond at $13 million. We expected them to come in a little higher. They pretty much always do. They expect that because it's going to the state. We want to make sure that everything is covered. So going Corey.
Do we need to go back to the map that shows the water facilities?
I don't think the water facilities in. But let me talk briefly about the stormwater management system. So I designed many stormwater management systems with mines, and I use the same fundamental process that I use at other mines, and everyone uses at pretty much any mine. We limited the slope distances to 100 vertical feet. We're routing the water north and south off the landslide to riprap armored channels around the sides. We designed it for the 100-year 24-hour storm event. We have ditches at the top of the quarry that will route those 4 drainages into those. Actually, those are the start of those riprap armored channels. Routes water around the landslide, and that basically getting the water off as quick as possible prevents water from infiltrating, and it conveys it off the rock pile in a safe manner and into the existing stormwater management plan. So it's very, very routine. It follows mining industry standards.
So, Mr. Kleinman, how are we on the time? We must be pretty darn close.
Yeah, just 10 minutes.
10 minutes, right. I just have one question to follow up on the reclamation bond piece. In the Dan Bear calculation, there was a processing cost and some other costs, which could you explain why that's not necessarily why those missed costs were missed?
Yes, so this, as I mentioned, all we need is weight there. We don't need to process the material. All we need to do is pick up the material and place it. That's all we need to do. We don't need to process it. We don't need to screen it or mix it or anything like that. That's all those little differences in material. One, it's going to get dumped and then it's going to get dosed. So that's going to mix in the material that you have. But the factor of safety that I started with, remember that geologic risk, that compensates for load of this material and load of that material. And it allows for that, because even if it was built with all the weaker material, it is still a stable slope. But so we do not need to process the material in any sort of manner. And I guess the other part was the unit cost is when you're pulling from CDOT. CDOT's, they move a lot of dirt, right? But it's a linear project over many, many miles. We're moving 3.7 million cubic yards all within a half a mile of it. So picking up, and what does mining do best? It moves dirt. So, and I think that's really what is being missed by the opposition civil engineers, that this is a mining project. It's going to use mining equipment, mining standards, and mining technology. And mining is very good at picking up dirt and moving it very, very, very efficiently. I really think that's the main basis in unit cost.
Any questions? John has a question.
So what you're saying now is
I have a question.
Karen, I'll take you
Go
out.
ahead, John.
Okay, thank you. So what you're saying is you have all the material you need right now on site.
Yes,
So all this topsoil that we need and all that. That's a misnomer.
correct. The topsoil has already been made. The organic material has already been brought on site and mixed in with the soil. So the topsoil is there. And all the material, so we need 3.7 million cubic yards of fill to buttress this. All of that material is available on the lower slopes inside our permanent boundary.
And just to follow up on the stormwater thing, are you taking consideration the stormwater that comes down that one main drainage? And you're gonna have to do something with it. I mean, the street that it might come off your site could affect the flow on downstream. I mean, I guess are you following what Colorado Springs has as a stormwater plan?
We followed mining industry standards. And
I mean, you live in Colorado Springs. I guess I'm worried about that a little bit.
well, it's,
You know, we can do mine energy standards, but that may not help downstream. That's all I guess I'm asking that question.
well, it
I
actually
think I'm
flows,
correct.
it flows into a sediment pond. It will actually be there permanent, be there for perpetuity, even afterwards. So that actually helps reduce the flows that would be discharged to Colorado Springs. Also, since it is a riprap armored channel, it's actually large riprap. Remember, it's 24-inch. There's going to be a lot of energy dissipation that occurs as it comes down the slope into this pond, into the ponds.
We'll go with Karen and then we'll go with room 220.
She just said something though. Can you stop sharing your screen or have?
Karen, if you're talking, we just need to stop sharing the screen and then we can see you and unmute
Yeah,
you. There you go.
okay. All right.
Go ahead.
Okay, I can't get the video to come on right now. It's just, we're not coming on. Okay, I don't know if this gentleman has the ability to make this comment or not, and if he doesn't, I understand. If you find that the costs exceed what your budget shows, what is the company's position? Are they going to say, well, we paid this amount, we budgeted this amount in agreement with the division, and that's what we paid our bond on, and if X amount done and we've spent all the money and we're going to walk away and it's your responsibility to clean up the rest of it? Is that what the position the company is going to take if the cost should exceed the bond amount that is presently being held?
I think Jerry wants to answer that question.
Again, this is Jerry Schnabel, the representative of Continental Materials Company. And I would reinforce that the very rules and regulations we're here with DRMS do not release us as the operating entity from any reclamation liabilities until it's completed. So if we reach this $15 million number, and part of what I like about Plan 4 is if for whatever reason something doesn't stabilize, we can add to the tow. If you go up on top, you have to start cutting from the top down. The company's prepared to finish this project at our cost. We use the $15 million mark as a bond cost, not as what our project costs are going to be. And we, by law, your own laws, we have to see this through to completion. Even if a bonding company stepped in and took this over, we would still be liable for the cost at the end of the day. Does that clear that up?
Yes, thank you very much.
Thank you.
Thank you. Let's unmute 220.
Or try to. They might have to do it. I don't, oh, there it goes.
Oh, you're good.
They're good.
Can you hear it?
Come as close as you can.
Go ahead.
Mr. Koss, in your calculations of where the fill is going to come from, Have you done any core sampling or done anything specific to identify where that fill material comes from and what it will constitute?
We've done geologic mapping, but we've not done any drilling. We have dug some test pits to see what the material is at below the surface, but still not at a significant depth. But I've been on site for 10 years, and we know what material is out there. Jerry's been out there longer. We know the geologic mapping that was done. We know that the material is there and that it can be easily excavated and simply hauled up to the site.
I could not understand a lot of what you said, but I interpreted your statement to be no, you do not have any detailed core samplings or any real plan as to where that material comes from.
No, we have a very detailed plan. It's in the application. We show the exact contours of how that material is pulled out. And like I said, we've done mapping and done some test pits.
But not in detail to show that you really have the quantities you need or what that material consists of. Can you tell me whether or not Area H will remain as it is, or does it get further excavated?
Area H will continue to be backfilled. And then Area H has been being backfilled as part of the reclamation processes for 7, 8 years now. And it will continue, it's almost completely full. So the next stage of the reclamation is to start building that buttress and building slope above there.
And Area H is the base of the slope. So you've filled about 200 feet so far. Is that an accurate estimate?
Maybe not quite 200 feet, but Area H was the pit. It's not the base of the landslide. It's just a pit that was there.
And how deep is that pit?
I thought it was about 110 feet.
Okay, so that's been filled 110 feet. It'll stay as it is. Am I
Yes.
correct with that? Okay. And you haven't provided any data as to compaction of that material to the state. Is that also correct?
That is correct. As I mentioned, the industry standard, there is no need to compact. It's consolidating on its own rate and will continue to do so.
You also have not shared any of the PRISM data, the monitoring data with the state staff or with Mr. Dean. Is that also correct?
Yes, that is correct. As I think the staff mentioned and as Jerry mentioned, we collected the data for very different purposes. And it's very difficult to extract data for a different purpose and provide it. We have committed to providing those reports to some monthly monitoring reports going forward to the state, and those will be put on the laserfiche.
So if this gets approved, the first time the state staff, the first time the board would see any of that data would be after this is approved. Is that correct?
I know that Mr. Kazir has seen the data while he's been on site.
Well, I think he testified that that data he thought was only for safety of employees, and he really has not reviewed it.
Well, he's seen it, but he hasn't.
Okay, he hasn't reviewed it. You suggested that maybe there was over-designing of safety in your Amendment 4. Did I understand your testimony correctly?
No, I'm saying Amendment 4 is appropriately designed.
So is it your opinion that Amendment 3, which was significantly more safe, was over-designed?
I never said Amendment 3 was significantly more safe. It has a higher factor of safety. But as I mentioned, stable is stable. Just because it has a higher factor of safety doesn't mean that it's more safe. But it does have a higher factor of safety because of that surplus of 2.5 million cubic yards that must be.
It's true, is it not, though, that Continental Materials, its predecessor Transit Mix, endorsed Amendment 3 and said that was an appropriate factor of safety that was needed at that time. Isn't that correct?
Yes, and the key word is at that time. Those conditions no longer apply because that plan assumes you were continued mining of that 2.5 million cubic yards. It's very common in the mining industry when a mine shuts down early, they have to go back and put in a new reclamation plan based on those conditions at that exact moment. That's exactly what happened here.
you're certainly not suggesting to the board, are you, that the site has become much more stable and therefore we need less of a factor of safety? That's not your testimony, is it?
I'm saying that the factor of safety is appropriate. Really, in both cases, the factor of safety.
You're saying that the factor of safety under Amendment 4, in your opinion, meets the minimum. That's what you're saying.
It exceeds the minimum. It exceeds the most conservative factor of safety established by DRMS and the board. So.
But you admit that it's significantly less safe as far as factors of safety than Amendment 4 that's on the books today. That's correct, is it not?
No, that's not correct. It's not less safe.
The factors of safety are not reduced with Amendment 4. Are you denying that?
No, the factors of safety are lower, but it's not less safe.
Okay.
Factor of safety is simply a ratio, and like I said at the start of this, it's simply a ratio of driving to resisting force. And when you get to a certain point, you over design.
No further.
Mr. Milliken, I just want to remind you that you are using rebuttal time here, and I also I thought that at the beginning, Mr. Sorry, I have my notes, Paul, did a good job explaining factor of safety, so I feel like we've covered that topic, definition. Do you have further questions in room 220?
No.
Just want to make sure we have enough time here. Looks like Michael Cunningham, any questions from that room? No? Anyone else have questions? Thank you. Okay, are you guys concluded here?
Yes, we are.
Sounds good. So next we'll have rebuttal by the division. We currently have 30 minutes slated for that. We need to switch the rooms out efficiently. Mr. Mock, would you like to return at 3:15 or 3:20?
Maybe 3:20, those best 10 minutes.
All right, we will see everyone at 3:20. Thank you. Okay, 3:21. Back. So we are starting off with a rebuttal by the division so that everyone is aware. The division still has 30 minutes left in their rebuttal. The objectors had 18 minutes left in their rebuttal time of an original 30, and the applicant has 21 minutes left of an original 30. So have at it, and remember to speak into the microphone.
Thank you. Michael Cunningham, Senior Environmental Protection Specialist with the division. Thank you, members of the board. I know we've had a full day of testimony here. You've heard from expert witnesses on all sides, and I just would like to take this opportunity to address some of the points, some of which were I found to be quite misleading from the testimony that you heard from some of the expert witnesses that testified on behalf of the objector. I'm just going to kind of run down some of these issues here, but I'm happy to answer any questions along the way. If you guys have some, please feel free to interrupt me. You heard that under amendment number 4, we were going to have difficulty in a number of different areas executing the reclamation plan. It was stated that this is going to be a much harder site to reclaim. I would offer that the slopes that are proposed for reclamation and the revegetation techniques that have been proposed are commensurate with many of the large quarries that we have along the Front Range. Without a doubt, there is some added difficulty to establishing vegetation, but it is by no means insurmountable. And as Tim showed the board earlier today on some of our slides, the operator has performed reclamation out there. It's been successful in the areas where they have revegetated, so they know what they're up against out there, and I believe they're ready for that challenge. In acknowledging that they would have a harder time, we did adjust some things with the financial warranty calculation with respect to revegetation. And one of those things in particular was the failure rate that we chose. So we always assign a failure rate, knowing that oftentimes we have very difficult conditions in the state of Colorado that our operators are facing. We have a 25% failure rate on the revegetation plan under amendment number 3, and we bumped that up by 10% to 35% under this amendment number 4 for the failure rate to account for some added difficulty out there. So I just wanted the board to be aware of that change in the bond calculation. We heard testimony today about the differences between amendment number 3 and amendment number 4 with respect to their complexity and the operator's ability to actually achieve this. When we heard from Mr. Carl Mount earlier in his testimony that amendment 3 was a better plan, it was a simpler plan. It was a plan that was vetted more than amendment number 4. I simply couldn't disagree with that more. I think that the work that Tim has done under this plan, the level of adequacy review and attention that we've given to this site is commensurate with the conditions out there. We take this seriously. We are aware of the history of slides, and we don't intend to come before this board for a release until we're satisfied that the site's been fully reclaimed and that it's stable. To just give an example of some of those differences, and I know that Paul, when he had his presentation up, he had a slide that said we had 4 adequacy review letters on this particular review, which is correct. Now, an adequacy review letter, or the numbers of those that we issue when we're reviewing permit, is not necessarily a measure of complexity, but I do think you can look at that and gauge a level of review that goes into something. So for comparison, on amendment number 3, we issued 1 adequacy letter and we had 1 response, and that was it, and we approved it after that. In my 12 years with the division, reviewing hundreds of applications, doing many adequacy reviews myself, it is very rare on a 112 quarry operation that's experienced a major slope failure to have 1 round of adequacy issues. I can't speak to what occurred at that time, as I was not involved in it, but I would have expected more rounds of discussion and questions when we're formulating a plan to deal with a major slide, which was required by this board in an order. That was the purpose of amendment number 3. So I think the level of review that we have done on amendment number 4 far exceeds the existing plan that we currently have to date.
There's also been discussions about the availability of borrow material, that's on site. You heard testimony from the operator that all of this material is on site. The area that was in question by the city of Colorado Springs, where there may be some conditions, that is outside of our permit boundary. The objector testified that, by utilizing these borrow areas, we might be creating a larger scar, which is an accurate statement, but I would point out that everything within the permit boundary is designated as affected area, which means that it's available for the operator to affect as it relates to the mine site, whether that is an area that they wish to mine or an area that they wish to utilize to help them achieve reclamation, which was what would occur under amendment number 4 if the board approves that today. I would further point out too that regardless of any conditions that may be imposed by the city, if the state were to have to assume liability of this site and go out and perform reclamation, we would have the ability to obtain that material from anywhere within the permit boundary. With respect to some of the changes that may be coming down the pipe from this agreement with the city of Colorado Springs, this is really no different than any other mining operation where you are trying to push forth a plan that's going to have multiple approvals with different government agencies. It is nearly impossible to run those processes simultaneously. So an operator will start with the state or the county or the city. We'll have to run that through to conclusion, which has been done on our process. And then oftentimes, based on other government approvals, they may have to come back to the state and make the necessary revisions in our permit. So we will be monitoring that closely. If something comes up that needs an adjustment, we will be working with them on the appropriate revision, whether that's a technical revision or an amendment. Earlier, there was testimony from Mr. Carl Mount that we should limit, if you will, the number of amendments that an operator puts forth. My read of the act and rules shows no limitations on the number of amendments or technical revisions that an operator can pursue during the life of the mine. In fact, the majority of the permitting work that we do out of the office relates to revisions on permitted mine sites. Changes are necessary all the time, and this is just another iteration in the life of the Pikeview Quarry. You heard that, we should proceed with caution, and I agree. And I believe that we have proceeded with caution through the course of our review. There was discussion about the prison monitoring system that is out there, and I think there's just a few points that I'd like to clarify with the board for your understanding. The prison monitoring system came into place after the 2008 slide. Your testimony that it was put into place in 2010. So we had 3 years of continuous monitoring at the Pikeview Quarry before we approved amendment number 3 in 2012. That data was not submitted, nor was it asked for under amendment number 3. There was no basis, there was no discussion on incorporating that to demonstrate that the plan proposed under amendment number 3 was sound. Now that has been raised as an objecting issue, and we do agree that if we have a requirement for an operator to monitor a slope where we've had slides, that should be publicly available information. So that is why there's now a commitment, and we will be receiving that information and reviewing it as we move forward. It was also stated that the operator refused to provide us this information. That's false. We did ask for the information in one of our adequacy review letters, and in subsequent conversations with the operators, we came to an agreement that this information was going to be most useful from this point moving forward. We're not before the board today asking for release of this permit. We're not before the board today saying that the site is in a stable configuration. Years down the road, when this is all buttoned up, that is when that monitoring data is going to be most useful. It's going to inform us as to whether or not amendment number 4, if approved, was successfully executed. It's not going to be, to ask for that data and have it in the public record at this point in time going back would not have been a useful exercise. So we came to that agreement with the operator. Just wanted to point that out, that it was not a refusal from your part.
Mr. Cunningham, Tim Mock here, if I could just interrupt with a question on this point here. When you mentioned that the PRISM data is a commitment, is that a commitment or is it a condition of the amendment?
Well, It's a,
Could you characterize how that works?
it's a permit condition in that they have in writing through the course of our adequacy review committed to providing us with this data. So failure to do so could be an enforceable action. So we intend to make sure that that is submitted at the agreed upon schedule. We'll be reviewing that. And if there's any lapses on that, we'll take the appropriate corrective actions with the operator.
And I guess just to maybe simplify it a bit, would you characterize it the same as how you will monitor, revegetation, how you monitor, slope stability, that there's kind of all these benchmarks in place? You're using a data point to say this was successful.
I would say that's an accurate.
And that's why you're saying, you're not asking them to, tell us about the revegetation from 3 years ago, because that's kind of not what they're doing right now. And so you're wanting to use this for the useful purpose of what we're trying to get to the end goal.
That's right.
Okay.
Hey, Michael, do you mind moving the camera so we can actually see you?
I can switch seats. Let me do that real quickly here.
Right, we love it. You guys switch.
Sorry, Michael, I should have noted that.
Thank you.
Unless you're done, I don't want to make you go through it. You're finished.
Okay, my apologies. I think
That's helpful. There's like a voice coming out of nowhere.
I'd also like to address that there's been a lot of discussion on the factor of safety, and I don't want to put too fine of a point on this, but information was presented to the board earlier that was incorrect and quite frankly misleading. And so I want to address that in part. I have Zach Trujillo up here, who Tim introduced earlier, and he was a part of the review of the stability analysis, so he can speak to this a little bit more. But there was a statement that was made, which the stability analysis did not meet our factor of safety. That is incorrect. It absolutely met the minimum factor of safety. The numbers that were presented on the slide were pulled from Mr. Trujillo's memo, where he was requesting clarification. We did receive clarification in the fourth adequacy review letter that cleared that up. And so we have a different set of numbers, final numbers for the factor of safety that we went with, not the ones that were presented by the objector. Zach will address that in a little bit more detail here in just a second. And he's also going to speak a little bit to the board about our bond calculation and how we do that. So this is something that we routinely do. All of our staff receives the appropriate amount of training in conducting bond calculations, and not just bond calculations as it relates to construction projects or other things, but highly site specific for mining operations. This is what we do regularly. The state of Colorado program has received widespread recognition for our bonding program, and we're quite proud of the work that we do there. So Zach will speak just a little bit to that, about how we do that. But what I want to tell the board is that I'm very confident in the bond calculation that Mr. Tim Kazir performed. I have the highest confidence in that. I cannot speak to the other figures that were put forth by the objecting party, as I've seen no supporting documentation for that. Didn't have a chance to review any of those numbers, but I stand behind the 41-page bond calculation that Tim put forth. And those were the points that I wanted to address. And with that, I'm going to hand this off to Zach to talk about those points. Zach,
can we switch screens?
You guys can stay in chairs and stroll if you want. It makes it easier instead of popping back.
Thank you.
Zach with the division. I was part of the engineering team that reviewed the stability analysis in part with Tim. I have a bachelor's degree in geotechnical engineering from the University of Colorado, and I've been doing related engineering reviews for the division for the past 8 to 9 years. So part of my task was to evaluate essentially the geotechnical aspect of Stantec's submissions, part of Amendment 4, reviewing essentially what they did in their slope stability analysis. Part of my review was asking them for additional information so that the division can create their own to kind of see what we come to in comparison to what they've come to. They provided that information. Part of that information was including a different material property that was supplied with Amendment 4. So that is what I used. I used both what was applied to Amendment 4 in terms of the material properties to construct the slope, and then also the additional, I guess, the information that was provided that was requested. So part of that is I ran a factor safety slope stability analysis with both what was submitted with the Amendment 4 and what was submitted with the supplemental information. What has been provided on the objectors, which they claim did not meet the minimum criteria, was that of the supplemental information, which isn't what is being used in the construction of this reclaimed slope. So the difference is that they call it a waste rock versus mine fill. The mine fill will give you the lower factor of safety if that is the material used. Part of my adequacy was I asked them to clarify which material would be used. They clarified that the waste rock would be the representative material that would be used to construct the fill, which relates to the higher factors of safety. And as Paul Koss kind of said it, they similarly match what was provided to us in Stantec. And they are, and I want to also include that, they are above both for static and pseudostatic situations, above the criterion of what the board requires and also engineering practices. Yeah, and so I can also go into the bond calculation. It seems like there's an argument in terms of which price to use, and it seems it comes down to me that it's a unit cost issue. And I can tell you how the division finds its unit cost. We pull our unit costs from published material that is created by a third party. RS means handbook guides, which basically do a nationwide survey that come together and find a unit cost, which is then applied to a standard engineering practice in terms of calculating bonds. There's also, we use another party called Equipment Watch, which is, again, more specific to the equipment used in reclamation for mine sites, such as bulldozers, haul trucks, and whatever, that find that operator cost and the ownership costs associated with those. Those all come into play in terms of creating these unit costs. So really, we look at more of a national-wide survey system to apply those numbers to get an accurate representation of what the numbers should reflect in how we go about our reclamation activities or bond calculations. And as we all have mentioned, Tim Kazir is a professional engineer. I have faith in whatever he performed. I did do an oversight review of that in addition, and we kind of discussed some other items that we did address in the bond calculation, and I'm pretty confident that is sufficient.
Thank you, Zach. And just to add on there to the factor of safety discussion, there's been this assertion that more is better. A higher number is what we should be shooting for at this particular site. The board adopted a factor of safety policy for a reason. And so that is, we had a consistent application of factors of safety across all of our different operators. So if we found ourselves in a position where somebody came in with a stability analysis, they met the factor of safety, but then we kicked it back to them and said, thank you, Jeff. We kicked it back to them and said, well, you can do better. You can come up with a higher number. So please revise this. That would be essentially moving the ball on our operators. So that was the purpose of the factor of safety policy that's been adopted by the board. They have met those minimum requirements, and we believe that was proposed under amendment number 4 will result in a stable site. That's all I have for the board. Thank you.
Thank you. It looks like, Tim, did you want to speak?
This is Tim Kazir with the division. I just want to expand a little bit on the factor of safety because there's a lot of misinterpretation, perhaps, or misinformation that is being presented by the objector that a higher factor of safety is more safe. factor of safety is not a measure of safety, it's just the terminology used to measure that ratio that Paul was talking about of resisting forces versus driving forces. So when we established that minimum factor of safety, that accounts for all the unknowns that Paul talked about as far as geologic uncertainties and whatnot. So because if you move the factor of safety from 1.5 to even 10, that doesn't make it more safe. That just means you put extra effort into something that really doesn't need to be done. It's over-engineered or over-designed. And on another note related to some of the discussion on testing and compaction and whatnot, I think I just heard Russ saying before we finished here that give it 4 different engineers the same problem, they're going to come up with 4 different answers, and it's like you hit the nail on the head there. So the objectors engineer, they're all very well qualified, got a lot of experience, but their experience is not mining. It's in other public works type of projects. My experience for 25 years has been in mining, and mining is a little bit different. We're not putting asphalt down. We're not putting bridges down on this compacted material. We're not building structures. So the concern over differential settlement that you get on a highway, where you get little divots and drops where you see, you drive along the highway and you see the sign that says damage road ahead. That's not a concern that we're worried about. We're worried about making sure that the mass gets put there to buttress that slope. And so saying that we need more tests or whatnot, it just doesn't add up from our experience. I've got a DMO that we're also testing that one of those compaction tests every 5,000 cubic yards, and that's holding cyanide leach material. So it doesn't necessarily follow because of the differing backgrounds and the different engineers making a presentation on that. So on that.
Thank you. Any questions for Tim?
I've got one.
For Tim, go ahead.
Tim Mock here. Appreciate the information here. I've got a question about this point about knowing where the fill material comes from. And is that something that we usually ask for up front, or is that part of the requirements? And I understand that the applicant is getting it on site right now. And so that would be what I'm assuming we used in our bond calculations. How does that all play out necessarily?
This is a little unique for this particular site because they're currently getting material from off-site that we, as I mentioned earlier, was approved in TR19. Where this factors in is the bond calculation, as the objectors parties on the bond calculation mentioned. It would be expensive to import this material. Right now, there's an agreement with various construction sites and whatnot around the Colorado Springs area that Castle is getting, or Continental Material is getting the material. When we have to estimate the bond for our cost, it gets really complicated if we have to determine where extra fill would come from, and okay, so there's a haul distance from wherever that is, and a unit cost of material, and so that can be extremely expensive. So one of the adequacy issues was to identify a source of material that we could bond for. So that's when I think it was on our 3rd adequacy review, we were drilling down on this, and they identified the extra borrow site on site within the permit boundary. So that material is then available. We've got a much shorter haul distance, and it factors into our bond calculations much easier without having to go out and get 3 different quotes from people. This is a lot of material that depending on whether we're 5, 10, 15 years down the road, may not even be there. So it simplifies our approach to our bond calculation considerably, having that material on site. That being said, that's what our bond calculation is assuming, but the plan that they're going forward is perhaps different from that. So that borrow material may not even be used in the final reclamation. That's only available or planned for if the state were to take over the reclamation plan and need to get material that's guaranteed essentially.
I've got one more. Mr. Cunningham, you had mentioned Colorado's performance on bond calculations. I'm not necessarily familiar with the national recognition that we've gotten, but this is kind of one of my questions was if you could characterize what our performance looks like in terms of making sure that we adequately have estimated bonds. And I imagine that's kind of what this national recognition gets into.
Well, I'm gonna have to step that back. I don't know that I have that specific information, but from other folks in our program that work more intimately with the CERCES program, which is what it's called. It's our in-house proprietary software that we use. I know to that point, I know that we have had other states approach us, other Western states, and I believe Montana was one of those where we had worked with them to help them develop a similar program based on what we had developed in-house many years before I started here. So that program that we developed, we've enhanced many times over the years, and in working with other Western states, and again, that's sort of above my pay grade in terms of coordinating with the other states, but it's become aware that we had a very robust program for calculating these financial warranties. So that would be one example where that was an acknowledgement that we had a very good, robust program, and we were able to share that with a neighboring state.
Mr. Mock, this is Russ Means with the division. I also try to speak up a little bit louder in that one. Also, we have a couple of, this is Russ Means with the division. To add on to Michael's characterization stuff, we've worked with the Office of Surface Mining and stuff for a number of years on the CERCES program. And that's where the national recognition kind of comes in. And we actually have a couple of federal agencies that are pushing really hard for us to be able to share that so that we're all on the same page as far as doing bond calculations and stuff on federal lands. So,
Go ahead, Jim.
Just a quick question. So really what you're saying is that the city of Colorado Springs is not really our concern. Our concern is to do what we're supposed to do and with the project. And then if they do something with Colorado Springs, they're on their own, right?
Well, from our perspective, we've got the permit and we work with the permittee. We acknowledge that. Yeah, I think that's a fair statement. Yes.
Any other questions on Zoom or other rooms?
Not anything yet. Let's see. I don't see anything from Jared.
Nothing. I guess just that comment that John just asked about Colorado Springs is really that you can't always do these projects, multiple times. This is the process right now. This is what they're doing with the permit right now with mine land, DRMS. They may go to the city, they may go to the county, there may be other things, they may learn something within that. That learning may kick them back here, could.
Absolutely.
Yeah.
And, as we testified in front of the board last year when we were talking about the deficient financial warranty that we held, we committed to staying on top of this site. And so I'll reiterate that we are going to be there regularly. We're going to be inspecting this at an increased frequency, which I think we've informed the board on. We intend to be out there checking on the operator. If we run into any issues that require a revision of the plan, we'll work with them on that. And quite frankly, I'd be surprised if we didn't at least have to address something through a technical revision before it's over.
Yeah, I just always think that's an important thing to keep in mind, especially, we've all been in this room all day, and sometimes it kind of feels like you're in this silo and it just feels so final. And then just to remember that there's lots of tentacles out there, and there's lots of other opportunities for input and for feedback and for things like that, and that, everyone's available to, have more discussions.
Absolutely.
Okay, anything else on the rebuttal by the division? We're good here?
That concludes our statements. Thank you.
Hold on just a minute, guys. Let me see. I got it.
Tammy's checking, making sure with no messages.
No questions for Darren?
No questions. Okay. Thank you, gentlemen. Swapping out the rooms. Next, we are going to have rebuttal by Mr. Dean, who I believe we have 18 minutes. Are we still on 18 minutes from them? Correct? So we'll do that. Is everyone in the room and on Zoom kind of feeling like we can just hang out and switch the rooms out? Do we need to have a formal break time?
No.
Deny.
You keep thinking, okay?
Do not yield my time.
Okay, go ahead.
Yes, we're ready.
Thank you very much. We'll try to be very brief. I asked Craig Vaughn, who's a geotechnical engineer, to offer a little bit of rebuttal testimony, and then call him out for just a few minutes.
Great. Appreciate that opportunity. With regards to the factor of safety, I hope Mr. Trujillo and others did not misinterpret that we're challenging the factor of safety as calculated. I think it's critical, and I tried to illustrate it in the slide, that the difference between the factor of safety that was calculated in the 1.4 range was a material that's described as mine fill. And mine fill is a clayey material, probably similar to what you saw in area H. And I think it's appropriate to apply that for a lower quality material in that calculation. That's a stability analysis that has to assume a particular type of material. We don't know what the material will be like ultimately. We talk about a cut fill.
I'm sorry, I don't mean to cut you off.
That's all right.
For one, can you bring the microphone closer to you?
Yes.
And did you introduce yourself when you stepped back down?
I'm sorry, I'm Craig Vaughn.
Thank you.
Again, geotechnical engineer with Warren Dean's group. So again, I think that factor of safety, the 1.5 criteria, I think is appropriate to adhere to. I totally disagree that anything greater than a 1.0 is okay, that's going to be fine. And I don't think that we should just accept that, well, this is just a mine, we can accept lower factors of safety. Your own criteria stipulates that for critical structures, potential risk to human health is one of the factors. It's not just dams and roads and other things like this that warrant higher factors of safety. This property is going to be utilized by humans, and I hope that happens. I mean, I'd love to see that property used that way, but it needs to be done safely, and I don't think a 1.1 or 1.2 is a realistic factor of safety for this particular project. There was a comment about the material placed in area H. Tim mentioned the area H material was, or maybe it was Paul, doesn't really matter. A couple hundred feet of material has been placed in area H. We have a memo from Tim that says if Amendment 4 is approved, that material they would need to provide records documenting that had been placed as structural fill. And so they could produce that memo if it was required, but that contradicts some of the rebuttal response that I just heard, I think, from the DRMS. Exhibit D in the mining plan specifically has a section that talks about import fill. And it talks about the applicant's commitment to bring in material from offsite donated from sources around the Colorado Springs area. And so I'm hearing this discussion of, hey, we've got enough material on site. The site balances from a cut fill perspective. The geotechnical consultant for the applicant indicated that we've provided the documents that show where we're going to get it, where the quantities are, how we're, what the quality of that material will be. But I haven't seen any of that in any kind of formal plan. And I'm not saying that it can't be obtained, but I don't believe it exists at this point in time. And I think as the board, I think you should take that into serious consideration, that we're going to build this embankment from material that we have not qualified yet or quantified for that matter. So I think it's really important to recognize that cut fill balance doesn't exist, and that's a critical element of an engineered project. There was a discussion about the PRISM data and the monitoring, and I don't think that should be glossed over. I don't understand why all this very accurate information is available, why it hasn't been, if it's useful information, why doesn't everybody have it? Why aren't we using it to illustrate what a great plan we have in Amendment 4? It seems like it's a secret, but it's good stuff, but you don't need to know what it is. And if I insulted somebody by implying that it wasn't provided to us, I apologize for that, but you would think it would be openly volunteered if it was good news, if it was useful information that would help us create a safe Amendment 4 project. And for whatever reason, that information is kind of behind closed doors. And I'm sure it would be really valuable. And I'd like to know that Stantec did a stability analysis for Amendment 4's geometry based on the data, the geometry of that slope as it exists right now, as opposed to a year ago or whenever they did their last stability analysis, because it may have moved. I guess last, the density testing that Paul Koss mentioned, he suggested that 740 tests would be more than adequate for a project of this size, and I completely disagree with the one test for every 5,000 cubic yards. I did the math, and it works out that whatever he said, 741 tests for 3.5 million cubic yards of fill, that adds up. But I expect a high degree of variability in the material on this site. If he's going to test 741 times, to me that implies that you're going to be putting a clayey material on the site. You can't test rocky material. Use a method specification to test rock. And that gets back to factor of safety. The type of material that is stated that would exceed the MLRB's requirements is waste rock, not mine fill. Waste rock is a rockier material, mine fill is a clayier material. The tests that would be performed on a 1-foot lift are performed on clayier, finer grained materials. So there seems to be this disagreement in which material will actually be used to construct this embankment. And I think it's going to be a hodgepodge of different things. But I think as a board, it's critical that you know, where is this material going to come from? The cut fill balance, if it exists on site, just demonstrate it. Show us where it is and show us what the quality is. I do this for a living. We do it for folks all the time. And it doesn't matter if it's a mine or if it's a dam or if it's a tunnel. You want to know where your material is going to come from so you can accurately qualify it and quantify it. and establish an appropriate factor of safety. The factor of safety should be built into a project, and it should be higher. The more unknowns there are in a project, the higher that factor of safety should be. We've got a steep slope. We've got a lot of variable material. I saw some curb and gutter in a hole. You know, I don't know how that got there, but is there an assurance that no more of that material is going to come on site, or is it stated that that's going to be acceptable material? I don't know what classification that debris falls into. But I wouldn't allow it on my project. So I'll yield to my time to Carl.
How much time do I have left? Okay, good. So I wanted to refer to these tables. I don't know if you can see them. I'm wondering if we can get them up on the screen.
Probably not, but what I could do is.
They were in
we
tall
can-
classes.
I'm sorry?
They were in tall classes.
Oh, okay, yes, I can do that. That I can do.
Well, you. Paul's, was remotely, Cammy.
Yeah.
Oh, yeah, it was.
It was Corey Christensen. If you have those slides, if you could share those. Corey's muted currently. If you could unmute Corey, I believe
Got
he
it.
showed those. And can you just tell me what page number was on
They
those?
were in the board exhibits, page 74 and 75.
In the board exhibit. I'm just wondering what
I don't know.
slideshow.
I don't know where they were.
They're in the packet.
Corey's in there.
Excuse me, could you repeat the board page numbers? I can use those numbers. That'll be sufficient.
74 and 75 of the board packet.
74 and 75.
If you give me just 1 second, we'll have those.
While they're looking that up, I can go over with you a couple of things. Just to move this along. One is the monitoring data, which everybody's been talking about, but nobody's producing, and nobody can look at it because, you know, it was only for safety, but not really for the plan. Well, gee, in a division of minerals and geology at the time, from GMG, inspection, a composite inspection, inspections conducted on 12/5 and 11 of 2008, and on 2/10 of 2008 was submit, and I quote from this inspection report of 2009, submit a technical revision by 4309 detailing a plan to monitor movement of the slide area, overhanging limestone tension cracks, and areas immediately north and south of the slide. The revision must include methodology, reporting requirements, and implementation dates. Never included reporting requirements. The division didn't follow up. Just wanted you to know. The other thing that I can start on this. There we go. Good. Grading direction, top down. Not exactly. From the 2013 plan, and I quote from page D4. At the start of each phase, bulldozers will push excavated material downhill to a safe loading area for haul trucks. The haul trucks will transport the material required to fill Area H and material to be processed and sold. The Area H material will either be end dumped into Area H or pushed in with bulldozers. Fine, great. Push to a load area, come around, just like I said in my presentation. They're saying, no, it's top down. And they're saying in the 2020 amendment, bottom up. I can quote from page D12 in the 2020 amendment that it's not exactly bottom up construction, because it says, and this was the exact thing that TC Waite wrote in a memo in 2012, I believe, stating that you cannot push materials in place with the top of the buttress. It doesn't work that way. You must compact them as you go up to have a good engineered buttress. But the Amendment 4 on page D12 says under section 5.8, granite materials that are pushed by dozer from the top of the quarry will be downhill pushed to move bulk general fill granite. Once the material is generally located to its final position, downhill push. A second dozer push will distribute the granite parallel to the quarry face in an appropriate lift thickness. There is nothing that in that statement that you're going to be able to enforce on. And I think it's a dangerous statement to let sit in Amendment 4 if you approve it. Once the loose fill is watered, compaction efforts will complete the placement in a level fashion that is cross-hill and horizontal. Anyway, let's move on. I think that's a dangerous statement to leave, and I think it's dangerous to approve Amendment 4 with those types of statements in there. Craig has covered compaction, the hull direction, downhill in the 2013 plan, yes, push it around, uphill in the 2020 amendment. So what? Miners do that all the time. Gravity is your friend, gravity isn't your friend. Okay, I don't think it matters as far as safety. One of the things I do think that matters is the division calculation for bond had the haul trucks going 42 miles an hour average speed downhill for Amendment 4. Check the feet per section, or the feet per second, or the feet per minute calculation on that. It's kind of odd. Constructability, we'll have to agree to disagree. Simple in the 2013 plan because all you got to do is haul it around and dump it, leave it. You got 3.7 horizontal and 1 vertical slopes, no problem. Don't need all this fancy engineering. High wall remaining, no big deal as far as I can tell. The slopes in either case will be constructed in solid granite with high factors of safety at approximately 1-to-1 overall slopes, benched very much like all the quarries up and down the Front Range. Stability, Craig has already covered that. Revegetation plan, very similar. I don't think it matters one way or the other. Can we move on to the next slide, please? So in this reclamation plan, they compare industry standards with a 2020 amendment. I think that's sort of a false comparison, false logic. Industry standards should indeed inform the board and the legislature in creating the law and redoing the rules and regulations if that's appropriate. I think that's a good thing to use industry standards for, and also perhaps for policy. But as far as comparing Amendment 4 to industry standards, it's sort of a who cares, because what the Amendment 4 has to meet is the law, the Mine and Reclamation Act for construction materials, the rules and regulations promulgated therefore, and board policies, if any exist, that are applicable. Seismic factor safety, I didn't address that, but I'm not going to. Lift thickness, is 10 to 30 feet industry standard really for an engineered buttress wall? Is that really the industry standard? Because I've heard from every engineer I've talked to that you cannot get adequate compaction with lifts of over 1 foot to 18 inches in thickness. You can't get compaction throughout the whole lift. So 10 to 30 feet, to me, industry standard, maybe for non-critical structures. Don't know. Slope gradient. Industry standard doesn't matter again. What matters is Amendment 3 has much shallower, more easily protected, erosion-resistant slopes of 3.7 horizontal, 1 vertical or less steep. Very easy, very proven. Won't add a bunch of sediment to the watershed. Revegetation, I've already told you about. Construction method, I've already told you about. This is not correct. It goes downhill on industry standards, not necessarily. Place in lifts on 2020 amendment, not necessarily. Remember, the very top part of that is going to be pushed downhill, spread out to the sides in appropriate thickness lifts, whatever that means. 50 feet, 100, I don't know. High wall removal, none. Doesn't, again, this doesn't matter. Your law, your rules and regs require removal of unstable high walls or buttressing for stability. Stabilizing those high walls shall be stabilized. That's what it says. Not, we think it'll reduce the risks. And all the rest of this stuff on compaction testing, I'm not going to cover. I'm done. Thank you. Thank you very much.
Thank you again for sharing those slides, Corey.
That's all we have on rebuttal. Thank you very much.
Thank you. All right, we will switch out the room and hear from Continental Materials.
We get bigger too.
Huh? What did you say?
We get dinner too.
You might. Pizza? In a box? Calzone's perfect. That was crazy. How much time do we have left?
21 plus 30 plus deliberation.
So you watching downstairs? Is that how you're doing?
I could use a cup of coffee.
Okay.
No, my dad's watching.
Gotcha.
He just texts me.
See, why don't you do this at home? Is that the?
Well, by the way, Jenny thinks you're fantastic. For texting me. Yeah, well, both of you and your sister. She's like, we're paying them for this, right? I'm like, absolutely.
Well, it's good to know I have a job next summer.
Let's not break your Christmas time.
Sherry, I was just gonna say, just logistically, if you guys are kind of all talking at once, we figured this out earlier, you just want to spin that camera so it kind of catches the whole table. You guys are kind of sitting in and out.
Makes it easier, then you're not kind of trying to jump back and
And
forth.
then you realize some of our transitions.
We had one at our office. We had someone sit in the middle. It had like a little Zoom camera. So we didn't have anything mechanical. We just had a person. That's when you learn.
Yeah, I wasn't gonna do that. Exactly.
We're only going to have one witness by Zoom in rebuttal. Paul and Jerry are available if you guys have questions for them, but they're not going to do more testifying.
Yeah, I'll let you kind of lead who's talking and going there.
Perfect.
Let it run.
Your microphone's not on, right?
All right, this is the rebuttal from Continental Materials. I'll remind you that you have 21 minutes and let you introduce anyone else who's speaking.
Okay.
Please speak directly into the mic as close as you can.
And introduce yourself, please.
And introduce yourself.
Good afternoon, everyone. Scott Anderson, counsel for Continental Materials Corporation. Thanks for the opportunity to kind of bring the closure to the rebuttal session here. We're only going to have one witness. Bruce Humphreys will testify by Zoom during our rebuttal piece. Mr. Cost and Mr. Schnabel are here. If there are questions, on anything that's come up, they're here available to you to answer questions, but we're not going to have them do any more testifying at this point. So Bruce Humphreys, are you out there in the Zoom world for us?
Yes, he is.
Yes, I am.
Excellent. So Bruce, can you introduce yourself to the board and talk a little bit about your education and career experience?
Sure. I assume everybody can hear me okay?
Yes. Yes.
Okay. Yes, my name is Bruce Humphreys, and I would like to thank the board for allowing me to have this opportunity to testify today on behalf of Continental Materials. In terms of my experience, I have an MS in range ecology from CSU. I have about 40 plus years of experience in the mining industry doing reclamation and permitting. 11 of those years I was with Trapper Mine, most of which as a senior environmental engineer. And my responsibilities include permitting, site reclamation, and compliance. I worked for Shell Exploration Production for a short period of time on oil shale until they canceled the project as a consultant. And that was after my tenure with the DRMS. I worked 18 years of the DRMS as a minerals program supervisor. I was responsible for implementing and drafting rules based on new legislation that was passed by the state legislature. I supervised Carl Mount, among other persons, and he was a senior environmental protection specialist at the time. I've been working as a private consultant for 13 years after my retirement from the state, which includes prospecting, NOIs, hard rock mining, 110 and 112 operations, sand and gravel or aggregate mining operations, 112, 110 operations, and 111. I've been a consultant for Castle Concrete since about 2017, not 1917, 2017. And I've done annual reports, various technical revisions and minor amendments. And that's sort of my background.
Right, and could you also describe to the board your involvement in the development of the construction material regulations?
Yes, there were been various changes to the regulations, starting back in around the time I came to the state. When I first came there, bonding was just based on so many dollars per acre. That changed shortly after some issues. And that instigated then the use of the OSM bond calculation program to help us calculate bonds that were specific to each mining operation. For example, when Senate Bill 181 was passed, it was a year-long effort to change the hard rock mining regulations to deal with groundwater quality. I also worked on the regulations to split out the hard rock mining industry from the construction material industry. So I drafted those regulations. I brought those to the board when they were ripe for approval by the board. I was responsible, along with the AG's office, putting together the statement of basis and purpose. And that's been my involvement in terms of regulations or other minor regulations along the way.
Thank you for that. And as part of your role for Continental Materials working on the Pikeview Quarry, have you had a chance to look at the permit application for this Fourth Amendment to the permit?
I did. I was involved tangentially. I was asked to evaluate the reclamation plan in terms of the vegetation, also the monitoring program for vegetation, and to give some recommendations on composting to increase the viability of the material that was going to be used as a plant growth medium.
And when you were working for the division, did you have the opportunity to review permit amendments and reclamation plans in addition?
I'm sorry, could you say that again?
When you were working for the division, was it part of your duties to routinely review reclamation plans?
Yes, I did. Basically, when there was an issue where we had objections of that type of a nature or serious issues that were unique to a certain operation, then the staff would counsel with me and we'd discuss the issues and come up with solutions and present those to the operator. We'd work with the operator to resolve whatever issues might happen. One of the things we had to do, or I had to do, is that when we did have an issue coming before the board, I would meet with the staff, go over the entire presentation to the board to make sure we had an application that was sound, satisfy the requirements of the rules, and was right for the board to consider.
And so the last question from me, based on your professional experience, have you had the chance to form an opinion regarding whether Continental Materials has met the statutory requirements for the approval of this permit?
Yes, the only portions that I didn't review, because I don't have training as a geotechnical engineer, were the items related to that issue, but I did review everything else, all the other sections, and to me it looked like it was a good, sound proposal to set before the board.
I have no further questions for Mr. Humphries.
Does that conclude your?
It does,
remote?
yes. That is, sorry.
That's okay.
We're done.
Thank you.
Again, we're available for questions if there's things that we didn't feel the need to put in additional.
Thank you.
Just, reading the material, that there was a discussion on the timing on how long it would take to complete this project, and I've seen 2 years mentioned, and can you elaborate on what your thinking is and where we're going to end up and what it's going to be? It sounds like since you have everything on site to be accomplished, I'm not sure. Sure.
Sorry, John, can you repeat the question there?
Okay.
If you'd like, I'm happy to, since I got my nose right on this.
Thanks.
I'm talking about timing of the completion of the project.
Okay.
With regard to the number 4 proposal, just give me a little bit of a background on what you think the best timing is. And I've seen 2 years mentioned, and as long as 5.
Yeah. So there's a 5-year term, and Paul Koss will tackle me if I get this wrong, but the idea is that really the dirt moving will take about 2 years, and again with sourcing it on site, and then it's revegetation and just tracking vegetation after that. But most of the dirt work will be done within 2 years, give or take.
Any other questions?
Yeah, this is Lauren Duncan. Could you speak a little bit to the concerns about compaction and material quality? Sounds like that is kind of a major hangup in terms of understanding the stability of this reclamation project.
Yeah, I'm going to stop practicing mine engineering without a license now and bring Paul to talk about that.
Thanks.
Good afternoon again, Paul Koss with Stantec. Yeah, so as I mentioned before, compaction really is not required for a structure of this type. And so when I mention those industry standards, I'm referring to mine reclamation. Not just mine reclamation, I'm referring to mine reclamation of slopes that have landslide component. So what we've done in the past on other sites in New Mexico, working in Texas, we're working in Washington, we're working in California. There's landslides in all those areas, and all we do is remove material. We adjust that balance of the driving to the resisting force. On none of those projects, and some of these landslides are much larger, but none of those projects we have a compaction requirement. So really, in my opinion, in the mining industry and my experience throughout several sites, even with landslides, there's no compaction required. You're doing that to increase that settlement so that you get a slope that you're not, because if you don't put in the compaction, you're going to have settlement, you're going to have differential settlement, which can cause some cracking. Superficial, and someone could interpret that as a slope movement. We want to avoid that, so we're compacting it. And really, it's going to be, really we're going to demonstrate early on with the method spec works. So we have a method spec in there that will be 2 times or more with a front end loader or a dozer. That's actually how the material and area age is placed. And then it'll continue to be done that way. But as we bring up the list for Amendment 4, it's we're actually going to increase, do the testing that's required. We're going to work with a local contractor who does compaction testing, and they're going to make sure that it is done to those exact specifications following its team standards. Is there a second question there, Lauren?
You might want to ask her again.
Lauren, was there a second question that I missed?
No, I appreciate you discussing the compaction process, or how that relates rather to the reclamation there. I have a related question. Again, I think one of the outstanding issues is the material and where you're going to get it from. I've heard a few different things about it's coming from on site, and then that was just used for the bond calculation. So if you could just clarify where it's coming from and how you're going to ensure that it meets what you need it to meet to do your efforts and your reclamation.
Yes, thank you for that question. Actually, I meant to talk about that as well. Yeah, so the material, all the material can come from on site. That's what our plan does. And part of that was for the bond requirement, but also to demonstrate to the RMS that the material is there. And we are working with the city. They're looking to develop that north property as potentially a bike park. And that's the 7 to 10 acres. We're looking to get upwards of 2 million cubic yards from that to take that project. And we are going to test that material before we bring it on site, so we know exactly what the material strength properties are. So any large project that has, we're going to import material, we are going to test the material before it comes on site. And in our reviews, we're actually I'm going to go back and look at the stability model and make sure that everything's good. And then so there's going to be material coming from probably that buffer property. If for some reason the plant falls through and it gets built as a subdivision, you have several hundred foundations that need to be done, material that needs to go somewhere. It's all going to come to us. So more than likely, you're going to have a lot of material, maybe a third of the project coming from that buffer property. But regardless, we're going to test it before it comes in. Continental is intending to continue importing material from other projects. The way that is going to work, it has worked, is they have a conversation with the developer first. They don't want just some guy who's out digging a hole for a tree. They want bigger projects. And the reason these contractors are willing to get rid of it, they have to over-excavate for a foundation or whatever it is. They know from their plans that they're going to have 50,000 cubic yards. So we're going to say, okay, you have 50,000 cubic yards. What material is it? Does it meet our needs? And just so you know, we're not allowing any traps. If you bring anything out of toilets and drywalls and other junk like that, we're going to turn you around. We're going to be done. You're going to have to take it somewhere else. They want to bring it to us because it's a shorter haul. In construction materials, haul distance is everything. That equals money. So if they can haul it to Pikeview, save money and dump it there. And sometimes there's a tipping fee. They actually pay to dump the material there. So, and that's still cheaper than hauling it across town to the landfill or wherever. So that material is, they have those negotiations. When the material is brought on site, the scale house operator looks at it and says, yeah, this looks like the material we expected. They may go on it. And then he gets up there and he dumps, and the on-site foreman looks at it and says, yeah, this is the material we expected. You're good to go. But if there's a bunch of junk in there, he has a front end loader right there. You can scoop it up, put it back in the truck, send it away. So we'll only allow decent material to come on site. And as I mentioned, all we're really looking for is material that meets that weight criteria. We are going to place it in compacted lifts, but we're really just looking for the weight to increase that resisting force.
John.
Thank you.
Is the material we saw in the hole there, is that acceptable material?
Sure, Jerry.
Let me bring that picture out. I don't know if we can or not.
I'm trying to remember what part of the presentation it was.
Well, I'll ask this question. Remember that picture? There was a corrugated pipe. I'm sorry.
Can you introduce yourself?
Introduce yourself. My name is Jerry Schnabel with Continental Materials Company. I'm sorry.
Thank you.
But if you looked at that picture, to the left side was a standpipe with corrugated metal. That is part of the retention pond. We do use concrete rubble to encapsulate French drains underneath that. That rubble you saw was the area that we talked about. We take in raw water from the flooding and all that behind us. It gathers in those ponds. We go back in and dig that out and dispose of it. That is not the structural fill we're talking about. That picture is highly misrepresenting what we're doing. It's there simply to allow the water to go down into those trench drains and out through a series of 4 other retention ponds that have similar type of sediment. That's the silty materials we do not incorporate into our fills. It's hauled off and disposed of outside.
Any other questions? Okay, thank you. All right, it is 4:30. We have 3 10-minute closings each. starting with the division. So if everyone's feeling okay, if you need to take a break, please do so while the room gets changed.
Okay. No, you don't get 10 minutes. 30.
Let the record note that Tim's request was denied one more time.
And here she comes again. Don't go too far, sweetie. We're gonna be doing just 10-minute increments.
Okay, yeah, I'm just waiting up there.
Let me guess what you won't be doing on Friday.
We're tonight.
Right?
No.
Oh.
That's a Summit County resident for you.
I know, right? It's been a very long day.
Oh. Oh. All right, we're good. We are good to go. So this is 10 minutes. You have 10 minutes for closing statement by the division. And if you guys end up wanting to stay in that seat, just turn those screens so you can see each other.
Sure, I think it's just gonna be me testifying,
Okay.
or me doing closing. So, go ahead and start. Okay. Again, Jeff Hugate here on behalf of the division. Again, just a short closing. I appreciate everyone's time and patience with this process. You've heard a lot of testimony today, so I'll be short. I do want to bring back to objectors' introductory remarks. They concluded some of their introductions with the
the statement that the board should proceed with caution here. And that's exactly what the division was doing throughout this whole review process, as they do with all of the complicated or complex 112 applications that they receive. They do proceed with caution. I think that's reflected in the record here that there were a significant number of adequacy back and forth with the company. Division typically will do that to hone in on aspects of the application that need to be fine-tuned, that need to be further explained, all in an effort to get to a point where the division is satisfied with the applicant's response, the commitments that are coming from the applicant to be included as provisions of a permit application. So that's how the division proceeds cautiously for sites like this. Of course, this one has, as you know, from testimony today, has a complicated history with the slides. It is a complicated, unique site. Nobody is in a better position than division staff to assess how those complicated site conditions factor into permitting of this particular application. You received a lot of testimony today from objectors' experts. For the most part, they received their information from doing, seems to be a fairly thorough file review and reaching conclusions, but that is not a supplement or a match to the firsthand knowledge and understanding that division staff has from its years of not only conducting the permitting of this site, regulating the site, but also being boots on the ground out of this site. So they do have a unique expert level knowledge of this site, which is reflected in the AM 04, the Amendment 4 application process. So the division determined after conducting this thorough review process that Amendment 4 complies with the requirements of the Act and rules. And importantly, it's a superior plan to what currently exists through Amendment 3. You heard testimony today from staff that it's a better reclamation plan for a variety of reasons. The most important points, and I'll highlight them, it results in better reclamation. Reclamation will progress faster. The site will be stable and safer. And the bond will be sufficient in the rare event the company walks away from the site. And to clarify, I know that Karen had some questions on the bonding. That's the purpose of a bond. It's to cover the state in the rare event an operator just disappears, files bankrupt, walks away. That doesn't typically happen. And so long as the operator is tied to the site, they are responsible for all reclamation liability expenses, even if it exceeds the calculated bond amount. That bond is just the safety net for the state in the event the bond has to be forfeited, the permit needs to be revoked. Your staff is also experts in bonding calculations. They do it as a matter of course as part of their job. The last few years now, all of the experts assigned to a particular site are involved in the bond calculation. As you heard from testimony from staff, not only was the initial bond calculated by Tim, it went through an internal kind of peer review process. Zach was brought in to have a second set of eyes on this bond, which is unique. And also gives this bond a particular disadvantage over some other bonds. It was reviewed by a variety of people to make sure that it was accurate. And the division did testify that they believe that this bond is sufficient to cover liability as it exists. And I think to conclude, I kind of want to reiterate some of what Michael stated in his rebuttal. This is not the end of regulation or oversight of this mine. With this approval, there will be continued focus on this mine. There will likely be additional revisions, either from the company or revisions as a result of whatever additional permitting is necessary as the company continues to work with the city on its additional plans. So this will be an ongoing regulated site, but the division is confident in its ability to maintain the needed focus here. So with that, if there's no other questions, division staff does recommend that the board approve Amendment 4 as recommended in their rationale document. Available for questions if you have any. I know you've had a lot of testimonies, so you may not have any.
Any questions? Okay.
Again, thank you very much for your time today.
Thank you. All right. Move the room out here. And we'll be hearing from the objector. Oh, you are in the room. Wonderful.
Mr. Milliken, did you want that wiped down?
I appreciate the offer. I don't know if we need to, or I can wipe it down if you want.
Aye.
They said I'm scared of coronavirus, but we're all here and I appreciate that. Can you hear me okay?
Please reintroduce yourself.
I'm Steve Mullick, and I'm the attorney for the objector Warren Dean. One, thank you very much for your time and listening to the issues we have. I'm going to try to wrap this up as quickly as I can. I know I have 10 minutes. It's a complicated project, if you will, and there's some real issues here that you need to be sensitive to. And as I started out, I think the board needs to be cautious and conservative. I heard the staff say they're doing that. That is appropriate for a couple of reasons. One, it's an inherently dangerous site we have. It's not the normal site. Every piece of information, including Colorado Geologic Survey, says we can predict that there are going to be future slides. And so we have to approach it with that, knowing that this is a dangerous site. We had all the staff review done before the ultimate end use of this property changed from wildlife habitat to now a world-class bike park. Humans are going to be using it, and that justifies being cautious as well. We have concerns that what is being proposed is discarding Amendment 3, which was adopted after years and years of study, thousands of pages of engineering, all designed to answer the question, what do you need to do to make it safe? What do you need to do to make these walls stable? And they recognize that we've got high hanging blocks, we've got unstable areas up there. They are likely going to come down in the future. It's not a question of if, but when. And so how do you address that? Go back to the simple. This is an avalanche waiting to come down, but unfortunately it's not snow, it's granite. And so what do? We take it down. That's what Amendment 3 requires you to do. Pull it down, make it safe, make it stable. Your rules say you either take down those high walls or you shall make them stable. You don't try, you don't mitigate, you make them stable. Amendment 3 does that, Amendment 4 does not, and it's a risky thing. It's violating your policy, we think, to leave them up there. I was absolutely shocked to hear it said that Amendment 4 is a simpler plan. How can that be? How can you make that statement? What we know is with I got cut off, I think, by the.
Oh,
No, you've
There's
got
one more.
there's a dead battery there. There you go.
Yep.
Thought someone intentionally muted me, I'm sorry.
No.
Not the first time, probably won't be the last time. But the statement was said, Amendment 4 is a simpler plan. Patently wrong. With Amendment 3, you take down the unstable material, you use that as fill, you dirt balance, you don't have to get fill from anywhere, and you get slopes that are about 3.7 to 1, very gentle slopes. It's a simple process. We explained it as Reclamation 101. Amendment 4 requires a construction engineered wall where you can only use quality structural fill, unlike Amendment 3 where any fill is fine. And you have to compact it every foot. And you have to check out that fill before it's brought on site, making sure it's quality fill. And then you have to compact it. Someone has to supervise that and someone has to report it. And what's going to happen is that monitoring process for this very sophisticated engineering project is going to fall on your staff. You have great staff, but at least in my estimation, they're overworked. They don't have time to get out there. And you're, by approving Amendment 4, are going to put them in the hopper to be ground up with monitoring problems and reports to review, etc. It's much more complicated. There's no question about that. Amendment 4 is much more complicated. And it also is riskier. Why? Because you're fighting Mother Nature. You're leaving that stuff up there rather than bringing it down. And we all know from personal experience and history, that is a losing battle. Mother Nature almost always wins. And to try to build a wall that's going to hold it up is folly. We don't like Amendment 4 either because it is less safe on the factors of safety. And we put a lot of time in on factors of safety. I want to clarify a couple things. Our chart came from this letter, and that letter, as far as we know, hasn't been updated. We heard that it's been revised, and what this letter was good staff work saying, we've reviewed your information, and we come up with a 1.41 or 1.44, fails the 1.5 required minimum. Now, then the applicant went back and they said, well, no, we're going to use greater quality structural fill, so you can revise that number up and we get over the 1.5. That's what they said, right? And that's why now apparently the staff is okay with it. We question it. We question it, why? Because of the photograph I showed you where the toe of this new wall you're building, the first almost 200 feet, has junk in it. It is construction debris. That was found out by an inspection report, fortunately done by your staff. And then we got conflicting testimony afterwards. Mr. Cost says, we're leaving it all there, it is what it is. Mr. Schnabel said, well, we pull it out. But remember, the requirement is to check it out before you put it down there. Make sure it's the quality that you need before you put it in the hole. That obviously wasn't happening. Why? Because it's not required under Amendment 3. Amendment 3, you can put anything in there. They started the project with Amendment 3 appropriately because that's what they promised to do. That's what's on the books. Now they want to switch and put Amendment 4 in. But they've already started, and they're saying they're not going to pull that fill out and check it out and redo it. The toe of the wall is going to fail. The wall will fail. They started wrong, too late to change course, and they shouldn't have any right to. They've already promised 3 was what they're going to do. We think it's less safe. We don't think it meets your rules because it says you shall stabilize that wall. This is an effort at it, but they can't guarantee it. And safety is big. No one has refuted our position with that chart that the factors of safety are reduced by about 43%. Maybe they go down to 41 or 42 after they bumped up the number based on, we promise we're only using structural fill. But this is less safe based on the factors of safety. And I don't buy the factors of safety have nothing to do with safety. If you look at the rule, it says you will increase it. You've got discretion as a board. If you're uncertain about what material is going to go in there, which you should be, and also if the consequences of a failure are big, they've gone from, we might kill a mountain sheep, which I'd hate to see happen, to human beings. You should increase factors of safety. Do not let them substitute a less safe plan. Let me talk about the cost estimates for a second. Your rules say you'll get the bond that provides actual cost, sufficient bond based on actual cost. We presented Dan Barrett, he does this all the time. We don't think your unit costs were what they should be. And if you have to go contract it, we think our numbers are right. Secondly, but most importantly, there is a huge contingency here, and that is what fill can they get on site? They have been all over the board with this. Started out that they're going to get it donated, and in your materials, it shows that the fill has come from at least 4 different construction jobs right now. And when you're trying to get standard quality fill, pretty dangerous, right? Pretty hard to assume what that's going to be. So that's one question. Then they went to seeing we can get it all on site from this lower borrow area, 140 acres. And that is wrong. You heard today, the city of Colorado Springs has agreed to buy that property, but they will control what gets taken. And maybe it could be a 7 to 10 acres, but they're only getting to take what meets the city's grading plan for the parks and the bike park. You cannot go take it all. It is a huge issue. Dan Bear showed you, if you have to go out and acquire that fill, and quite honestly, if you need structural fill, quality fill, you're not going to find it handed out for free. You get construction debris maybe, but that'll be slow. You're going to have to go out and find potentially up to 2.3 million cubic yards of material, of quality fill material. It's a huge issue. That could be an $18 million ticket in and of itself. Now, the applicant has told you we've got it all available on site, but they've admitted they have not done any core sampling. They haven't really quantified how much is there or what is there. I learned early on in my career that one of the biggest ticket items, for construction is quantifying how much dirt moving you got to do and where you're going to get your dirt. Everybody knows that. And everybody does what's standard. They go out and do core samples and they prove it to you. You should say to them, if you think you have it, prove it to us. But until you prove it to us, we're gonna set the bond high enough so that if you have to go out, find it, buy it, transport it over long distances, there's money there to do it. Because if it's not, the state gets left holding the bag. On the bond, increasing the bond to what is needed so you can hire the work done is appropriate. And it costs the applicant maybe 1%. But if you set the bond too low, it costs your taxpayer 100% of the shortfall. And remember, there's no requirement that that money be spent. The applicant can do the work and they can do it for as cheap as they want to. But if you have to do it and the bond is insufficient, the taxpayers take the hit on it. And we shouldn't let that happen. We should not let them trade off today a plan that is less safe, really uncertain with costs, for a plan that was approved after years of study by a prior board with the specific requirements of what you need to do to make it safe. Thanks again for your attention. I know it's been a long afternoon. We've hit you with a lot of stuff, but we appreciate it. And ultimately, I just want to say it is the board's issue and the board's responsibility. City of Colorado Springs looks to you to protect it. Whether you like that or not, it is a fact of life. And that's really what the buck stops with you all. We got to get it right. We can't do anything less. Thank you very much.
Thank you. Give us a minute and we will have a 10-minute closing statement from the applicant.
Did you need gloves? So you don't have to. I'm not worried about it. These are so clean at this point. I'm gonna write it. I just don't want them to get all like super dry. Yeah. I know. You think so. Okay,
Okay. Welcome, 10 minutes from closing statements from Continental Materials. Just introduce yourself and speak in the microphone.
Okay, after 3 times, I got that. Scott Anderson, the attorney for Continental Materials Corporation. I really just want to draw things together here, and I won't take 10 minutes to do it. But really, fundamentally, what the board has to do is decide whether or not this permit amendment application meets the statutory and regulatory requirements. There are a lot of collateral issues floating around, but that's really what this is all about. This is a permit amendment that meets the law. And I think it's very clear from the testimony today that the division has properly performed its duties in making its recommendation. Mr. Dean raised kind of 4 issues, different ways to kind of 4 main issues. I just want to touch on each of those and explain how they've been adequately addressed. both in the division's recommendation and in the testimony for today. One of the big questions is whether this backfill would be stable. The division developed guidance that addressed how to do factor of safety. Heard a lot of testimony about both that calculation and the division's guidance. And Pikeview adopted the most conservative factors of safety set forth in those guidelines. The factors of safety that we're using are used to assure stability for critical structures like a residence or a dam. There's a lesser standard for non-critical structures. So we've treated this mine site as if it were as critical as being redesigned for residential development, the most conservative measure possible. Continental Materials calculated the factor of safety for those three cross sections you've seen and found that the backfill exceeded the required factor of safety across all parameters, both for static and pseudostatic. And then the division did its own analysis. They used a different model, a different computer methodology, the same data set, and came with effectively the same numbers, with rank clearly over the factor of safety requirements. So Mr. Dean asks, will the fill be stable? The answer is unequivocally yes. He also asked about vegetation. That was an issue. Mr. Humphreys talked about the review that he did of vegetation. There really aren't major changes to the vegetation plan from Amendment 3. There are some enhancements, the use of trees, and some of the related stuff. But again, the vegetation plan is very solid. The seed mix is a great seed mix. Forest Service is happy. And so there's really no issue about vegetation, and there's a lot of time to monitor it to make sure it works out well. You just heard a lot of testifying from Mr. Mulliken about sources of materials. I think Mr. Cost explained that pretty clearly, that there's more than adequate backfill within the permit area. We can do all the backfilling we need to from on site. The permit does allow third-party backfill to come in. There's still this confusion about the parcel that Colorado Springs is going to purchase. We don't need any backfill from that parcel at all. It is likely when that parcel gets developed, either for a park or for another purpose, there will be backfill available that will be used. It will be tested, it will be sampled, everything will be properly vetted. So, and there may be backfill from third-party sites as well. Again, subject to the same testing regime to make sure that it's appropriate. But there's no requirement and no need to use third-party backfill. So that's an opportunity, but it's not a necessary step to make sure that reclamation gets done. So again, the reclamation will proceed with the proper amount of backfill. There's more than enough backfill to do everything that's needed, and it will be plenty stable. Mr. Dean also asked about stormwater management. We've talked quite a bit about that. Mr. Cost explained that the water is directed through riprap drainage channels into settlement ponds. Not going to create any additional sedimentation. We recognize that in this project, we want to manage the water in a way that prevents potential adverse effects from stormwater and to protect downstream water quality. And that's clearly part of the design. And then the last issue that Mr. Dean raised is the reclamation bond. We know the division is very good at calculating reclamation bonds. I wasn't aware of the award that they got, but I know, I started out in the coal industry. I know how OSM calculates a reclamation bond, and the program that the division uses is similarly designed. And it is, after some of one of the most important things that the division does is to make sure they get that number right. So we have our number came in less. We didn't contest what the division calculated for reclamation bond. We accepted their number. The differences were not worth fighting over, basically. So we take that number, more than happy with that. The 30 million or 57 that was floated around, we might have some issues with that. We don't think that's appropriate. So what brings us here? This permit amendment is brought to you by kind of three forces driving it forward. There's very careful study of the site by Continental Materials and Stantec over the past decade and beyond to really understand the site. And they've designed a new reclamation program that is more than adequate to bring the site into productive use. At one point, Mr. Mulliken said it was a bait and switch, but the facts on the ground are just different. We're not mining anymore. And so we're going to have to do something, because Amendment 3 presumes another 5 years of mining, and that's just not going to happen. And so when we look at where we're at today, and a site where we have stopped mining, this amendment is a very well-designed amendment, and that's what CMC and Stantec have designed. Again, the second force, a very thorough review of this application by the division, lots of rounds of comments, lots of working together to really fine-tune and make this a really productive, useful reclamation permit application. And then finally, the kind of testing by Mr. Dean. I mean, he provided a lot of comments, commented on every round of adequacy review. That other element was another test, right? It's just another way to kind of vet everything and make sure that it holds up. And the division's more than comfortable that we've addressed Mr. Dean's concerns or the questions that he raised. So this process has resulted in a sophisticated, well-designed reclamation plan consistent with the future use of this area, either as open space or parkland, if we consummate this deal with the city of Colorado Springs, and we ask for your approval of the amendment.
Thank you. Any questions? Okay.
Thank you.
Thank you.
Yeah, I know the way now.
Nice work.
You got it down now.
Thank you.
So my guess is that next steps are close this, yeah, close, don't do anything to close testimony, just say that we've closed testimony. And now is an opportunity for deliberation. Who'd like to start?
Before we begin deliberation on the merits, should we address the motion on party status? Since we deferred it till now.
We can, if you want to kick off that discussion with Jill.
Yeah, I think so. With respect to this motion, I do think it's more appropriately considered to be a motion to dismiss, which would make it untimely. But that said, on its merits, I would vote against approving this motion for declaratory order. As Jeff Fugate mentioned this morning, party status and regulatory hearings, it's a pretty low bar. And I don't think that this is the case in which we would want to raise that bar. I think this discussion we had today is a good example as to why that bar is low, and we get to raise these issues and talk about them. And I also think that the objector has met the standards. So based on all that, I would recommend that we deny the motion.
I agree with you on that, Ms. Forrest. I think it is a pretty low bar.
Yeah.
In practice. So I think it's kind of a moot point anyway.
I think so too. I just want to make sure the record is clear and that all motions have been ruled on. So I'll make a motion now to deny the petition for declaratory order determining Mr. Warren Dean's lack of party status with respect to pending amendment application.
Oh, go ahead.
Forrest seconds.
Yeah, it was me.
Discussion. All those in favor?
Aye.
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 Any opposed? Okay, thank you, Jill. Motion passes, and thank you for clarifying that. I do think it's important that, given the discussion and given everything there, and moving forward as well, that it's important that we really identify where the bar is and we're consistent. So thanks, Jill. Okay, so moving forward, and we dealt with the time part of it, the consideration of the amendment. Any discussion on that?
This is Forrest. I guess I'd present a few comments. First of all, in terms of the bond calculation, I've been through the bonding process with DRMS multiple times in my career, and they take it very seriously. And there's a lot of back and forth. And I have no qualms with the fact that they came up with a bond that's suitable. Also, with regard to the amendment itself, I've been through that process many times as well. And I think they went through 4 different iterations of comments and responses. And basically, I think DRMS is comfortable with the amendment. I think as well they should be. And I am comfortable with that as well. As far as some of the other issues, I was very impressed with the expertise on both sides of the argument today. But I think there's a pretty important distinction between the roles they played. The opposition experts basically have very little skin in the game. Basically, they're hired to poke holes in the permit amendment, which they did a good job of. On the other hand, the operator experts, their reputations are on the line. If they're wrong about the geotechnical analysis, their reputations could be hurt. The same is true with DRMS geotechnical staff. The fact that they're comfortable with what they have proposed tells me that they've looked at it very carefully, and that even though they know that they could that if they're wrong, it could be a difficult situation. That gives me some comfort that they know what they're doing. So I guess that's basically my comments, and basically I'm in favor of approving the amendment as it stands.
Thank you, Forrest. Other comments?
Want me to go?
Sure, John.
Well, I think the minimum standards, it looks like it's been met here. And I've dealt with, when I was on GOCO and Parks and Wildlife and with El Paso County, and they've been less than good stewards. In fact, I think it was, if it were in any other county on the Front Range, there'd be a lot of people opposing this. But, as far as the criteria they needed to do, I mean, I can't imagine Colorado Springs not examining this a little further before they put in a bicycle park. We're going to have people running around out there. But I'm still really in a quandary over where they're going to get their material, because it changed several times. And this deal about, the volunteer material coming in, unless it's rotten, it isn't going to be there, because any topsoil that's available is a saleable commodity. And so, if it isn't on site, then we got a problem. But so the strength of the bond is very meaningful to me. I can't disagree with the staff's done a good job, and I can't, like Forrest said, I think both sides had very good witnesses, but, the Continental Materials also was a participant in the reclamation of the Queens pit several years ago. And the community actually had to get together and raise money to make sure that was rebuilt, that was reclamated. So, their past history is not always that good. That's why I think we need to keep a watchful eye, which I think our staff will. But I'm very uncomfortable. But I look at what the staff's done, and I can't argue with it.
Thanks, John.
I have to agree with both Forrest and John. As the applicant said, this application has to meet the minimum statutory regulations, and unfortunately it's the minimum. There were some, I would like to have seen things that the objector brought up incorporated into the application, but that was not what was required. I feel that there were compelling arguments all the way through. It was one of the better arguments, one of the better presentations I've heard. I do go away uncomfortable. I don't feel that there's a very clear answer to this, but I will go along with the division and agree to their approval of this application, but with reservation.
Thanks, Karen. Jill or Lauren, I just want to make sure I'm catching everyone on Zoom here.
Yeah, this is Lauren Duncan. I would just second some of the hesitancy that's being vocalized. I know, of course, the division has done a very thorough review of the site and a very thorough review of the plan. The only thing I think to offer my fellow board members is the requirements for monitoring, and that is going to be run through the division now, which I appreciate absolutely. And I think that maybe helps us sleep a little bit better at night, knowing that that data is being actively reviewed and it is not sort of sitting on its own, and people are wondering what the stability is at that site. So I think we've got at least a good monitoring system in place and a good monitoring process in place.
Thanks, Lauren. Jill, anything else?
Yeah, there were a lot of good arguments on both sides. I think the point is well taken, and as Mr. Anderson stated in his closing, that we're looking at whether this amendment meets the regulatory and statutory requirements, not necessarily how it stacks up to Amendment 3. And there may have been things that were better about Amendment 3, but things do change. And I wanted to echo Forrest's point on the bonding. What happened this morning where an operator made huge changes and then walked away and their bond is not sufficient. That's something that raises a lot of concerns, and I'd actually like to talk more about that, but that's not the case here. Here we have the division using their expertise and standard processes to come up with the bond. So I'm comfortable with that going forward.
Thanks. Tim, any comments?
Thanks, Madam Chair. I don't know that I've got anything else to add. I agree with what's being said. I do really appreciate everybody taking, again, the time today and working and hanging in there with us through this whole process. I generally go back to also what's been said here about in consideration of Amendment 4, does it comply with the Act and the rules? And I don't see anything that would suggest that it does not. That said, I do appreciate that we do have some differing professional opinions. It has been a very good conversation today, but I do believe that this does comply with the Act and rules.
Thanks. Yeah, I just want to say that I appreciate everyone's time, the applicant, the staff, the objectors. As Mr. Koss mentioned, Mr. Dean's robust questions really provided an opportunity to get into some more detail that maybe, doesn't always happen. I think that this is a really big project. I think this is a really important project to take very seriously. I really appreciated hearing from Colorado Springs Trails and from the Conservation Fund, and I'm trying to remember, I think it was in the very ending statements of some of the paperwork provided by Mr. Dean, and I can't remember who said it, but essentially, there is a common goal here, and the common goal is to do this and to do this well. And Forrest, what you said, or maybe it was Lauren, about having some skin in the game too. The operator has skin in the game to make this happen, but also Colorado Springs wants this to be the right kind of end use. And so I think that there will be a lot of eyes on this. There will be division eyes on the monitoring, and I would concur that it meets the requirements. I understand the concern about there being changes. I understand that, in 2013, maybe pulled in 5 more years of mining, and that's not what's happening. And that's why you have a life of mine plan, and that's why these things change, and that's why we have opportunities for discussion. So thank you for the time and the incredible amount of expertise and brain power put in by all parties on this. It was quite impressive, and I learned a lot, and I admire everyone and your dedication to the knowledge and to making sure that a lot of thought was put into all of this. So, all right, any other discussion before we want to consider a motion? All right, would anyone like? Huh?
I think we're ready.
All right, wonderful. Would anyone like to make a motion? Or reference page 180 in your packet has some division recommendation for some verbiage if you're interested, and that's probably the big one.
I think I was muted before.
Oh, sorry, first.
I'll take a crack at a motion. I move that we approve file number M-1977-211. That we approve amendment number 4 over objection.
A second. This is Jill.
Jill seconds. Okay, any discussion? Okay, all those in favor, please signify by saying aye.
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 Those in favor, say aye. Or those opposed? Hearing none, okay, the motion passes. Thank you so much.
Public comment. I guess.
Yeah, public
Yeah.
Thanks,
Right.
everyone.
Okay, anything else I need to do here, Chuck?
Open it.
And we're gonna open it up for public comment. Looking at the screen here, I don't see anyone jumping up and down.
Were we gonna discuss how the solar one?
When we can
Yeah.
close it out and do it real quick and stuff like that, so, but yeah, that's fine.
We're gonna discuss it with the board.
Oh, okay, all right, well, all right, just real quick before we close, kind of a lessons learned, we would really like to hear your comments on what you think about how the board meeting was conducted today. And also, you know, what we did right, and also some things and stuff that you might want to see that are better and stuff, because we may be in this position and stuff for July and August, if not longer and stuff. So this may be the new way. And then also it's my understanding that there are some other divisions in DNR that are kind of looking at this and seeing what we can do. So we'd like to pass on anything that we can learn from you all and stuff to those people if they're trying to conduct state business as well.
Still no dinner, Tim.
No dinner,
My first complaint is,
Yeah,
I'll take a shot real quick here. I actually thought this went very well for the first time out of the shoot. One, Nell, fantastic job chairing and playing through this. And so thanks to the staff also. I think this setup and the order of events and moving people around was well thought out. So congratulations. I mean, I think the one thing and the only comment that I really heard was the sound. And to the degree that we can get these microphones dialed straight into the system rather than coming off a speaker and then into another speaker hooked into the computer, I think is probably the one single barrier or criticism I would actually have today. I do think that, you know, obviously, I don't know that all other, I don't know that we're going to have as intense of hearings as we did today. I think this one was obviously pushed in the middle, although I guess next month we may have 2 days. So, and actually moving individuals in and out of here provided a nice light little breakup of the day to make it a little bit manageable. So I really don't have any further criticism other than the sound, but nice job.
It'll be fixed. Thank you.
Yeah, I agree with the sound. I thought, I didn't see the behind the scenes, you know, going back and forth between the rooms, but it certainly felt smooth. I thought it was time efficient. I appreciate at least that people have the option to come here and do this in person, because Can't tell you how many calls I'm on where I lose the audio, or you just feel like, gosh, I didn't do that. And certainly from a chair standpoint, and I know that I missed this last month a couple of times, for me, having the hierarchy and the formal setup of the room really helped to visualize what needed to happen next. I hope helped me make sure I gave everyone a fair chance to speak. I didn't miss anybody. Because it triggers you to kind of remember, these are the people who are standing in front of you. These are the people that need to be given a chance. And even though the other two rooms were broken out, there was still this tangible space that I could remember. There's 220, there's a division. Whereas on Zoom, sometimes if everyone's there, it can feel flat.
Right.
So audio and, traffic was nothing coming down here. So
Yay.
I'm happy to.
And you rocked in that.
Happy to do it.
You did good.
Cameron, you and Russ, you need to be really kind of.
This is Forrest. I would just say from the perspective of somebody listening in, I had a really hard time hearing people in the room.
We're gonna get that fixed. We've already had that conversation. I'll be working with Susan to ensure that it's better.
Okay. There were times I just couldn't understand what was being said. So
Part of that was patching together the equipment that we have instead of running out and buying stuff, which is a big no-no right now.
Well, and we didn't know if we tag or if we put the sound system into a laptop, if we wouldn't get reverberation,
So
especially when somebody else turned on their microphone or turned off their mute or whatnot, and that was our concern.
You didn't want to experiment midway through.
Exactly.
Yeah.
So we decided that we'll do that here within the next couple of weeks. Make sure that it's all put together. We'll set some up, see what kind of reverb we get back on it, and we're gonna probably add some other not microphones, but cameras, because that one seems to be a little on the weird side. And so if we can get another camera up here, that maybe this will be covered completely versus having to try to get one person here, so they don't have to jump seats, because I didn't like that. So that would be one of my criticisms, is a better camera so that people don't have to jump seats, because especially, once they're cleaned off, that's fine. But doing it while they're doing this, I didn't like that.
Yeah.
No, I'm good.
So,
all right. This.
Did Jill have?
Anyone else?
Anyone else?
Jill or Lauren, anything?
No, I was just gonna say I was gonna commute upstairs to dinner now, so I was gonna
Yay.
find out.
Tim was looking for dinner too, so depending on what you're having, you
Oh, there you go, Tim. See?
Yeah.
Well, I'm guessing, Cammie, you would be open if anyone had any other feedback, sending you an email,
Or call
something.
me, you guys. I talk to you guys all the time.
And I'd say too, if you observe something in one of your other meetings or something else that's worked out well, giving that kind of feedback too, because we want this to be good. And yeah, I appreciate everyone doing what we can right now. And please stay safe. Thanks for wearing your mask.
Thanks, everybody.
Thanks, everyone. Thanks, guys. Bye.
All right, bye, guys.
Thank you.
Oh, and the meeting.
The meeting is adjourned. Tim, you can take a break if you want. You have,
Guess what, Tim? You're free. Fly, bird, fly.
You did a nice job.
Yes.
Thank you.
Yes, you rocked it.
Everyone's done a good job. It's funny because we've been doing these town halls and, we haven't done a town hall yet, but my GM just said, okay, I want to do a town hall and now I want you to moderate it. And I was just like, oh my God. And then I was driving down here. I'm like, why am I scared of the company town hall? I'm like, I've got to go down here and do this thing. Like, I think I can moderate.
Well, I guess we'll hit the pavement.
All right, you heading back down south?
Yeah.
Yeah.
Yeah, oh, you bet.
Yeah, thank you.
Yeah, thanks, John.
Yeah, thanks, everyone. Really appreciate
And
it.
you'll give us a heads up on July
Yes.
sooner rather than later?
As soon as I know anything.
Yeah, we're working on it
It'll
already.
be, once I get the agenda together, I'll have a better
Good luck on
idea
Tuesday.
of what
Yeah, that'll
looks.
be kind of fun.
Okay,
Yeah.
so that will be,
We've done.
depends on the date. I'll go and look.
I thought it was like the 22nd or something.
If it's 27th, then it'll be like 2 weeks before.
We got, we got several things coming in, and the thing is, a couple of them could disappear, and some of them, there's a couple of them that won't, so.
Right.
I think
One
one
of
of
my
my like West Elk.
There you are.
Like West Elk, but they probably won't be here. They'll probably do it via Zoom.
Yeah. Do you want to pick up tablets, or are you just going, still need?
No, I'm done.
No problem.
I'll come grab you. I'll come grab you Friday morning.
You want to have a drink?
Russ, I'm gonna come grab you Friday morning.
Oh, no, sorry, I'm working from home on Friday.
Are you working from home on Friday? That's fine. I'm
Until
gonna have the
noon.
girls.
Yeah, until noon.
I'll have to go.
That's all you can do is.
I'm gonna have them in anyway, because I got a board order. I have.
Awesome job. So, yeah, I think they're just, leaving everything, so.
That's what I thought. They were thinking about it.
Right.
The one that got kind of messed up, and so I sent it back to you, and then we sent it back to John, and he sent it back to me. So that was like a week ago, but he didn't date it. So I still did.
Have a safe ride.
Yeah, I hope I get through
John, great to see you.
Hey, John?
Not bad at all. I left, it's actually gonna be really good right now. I left at 4 o'clock yesterday, 4:30, and then the day before I left at 6:30.
Just so you know.
And then what's in?
Well, it's like the.
What day did you sign?
It was bizarre. I mean, I'm used to coming like over that freeway to Sheridan and just gridlock, and I kept.
No, like, this, it feels crowded in email, like, doing the
Right,
trip
because you
every
did
single
it
day,
before, yeah.
but it's been interesting. On certain days now, like.
Thanks so much for your help
Yesterday.
today.
Oh, yeah.
There are like days and afternoons that just all of a sudden. But then the
Don't
next day,
work on
it's
that
not.
day.
Yeah. Nice job, Judy.
Thanks, I did it all. Well, you have a wonderful staff. Yeah. It's amazing.
This is a grudge.
And we appreciate your partnership.
Thank you.
Oh, yeah.
So I was bringing those, they're experience like yours. This is one of yours.
Yeah, my mom, when we drove to Utah, we stopped at Eagle for lunch. And you know how they have like 8 million roundabouts, which we have 8 million roundabouts in Summit County, but not like Eagle County. And we were like in Country Bumpkin, we were like, oh my God, we can't do it. And I accidentally got back on the, I mean, I just hadn't driven. I just wasn't. We're like, what is happening?
Yeah.
Thanks, everyone. Really appreciate it.
Thank you, Chuck.
Thank you.
Chuck. Oh, yeah.
Cammy, we need to shut everything off though, right? We're getting started with early.
I think we did. We definitely need to. You should, I should love that you met Lisa.
Yeah, no, I would
She's
too.
awesome. And poor thing, I mean, she started in February. I went down and did one all-day chat with her on Tuesday, and the next week she did MSHA, and the next week we got it done. And so she's starting this job, like she was working out of her friend's basement, and it's totally remote, and so, you know, we'll be on meetings, and I'm like, okay, this is so, she's like, 0. Just taking people around and meeting people, and so, you know, she's amazing, but I'd like, I'd like to meet her.
Yeah.
Yeah.
Oh, so turn back up. Great.
Thank you.
On this, he just kept going down, just kept fixing, so I didn't say anything.
Yep.
That worked out. Did any of your, did the objectors or the applicant, anybody protest this all or express anything?
Not to me. I saw that the objectives were.
Yeah, I mean, not even to address like, does it mean, I mean, we're sitting there just comparing A3 to A4 the whole time, like, that's not what our bar is in terms of determining this stuff.
Does it not, does it fail immediately?
Yeah. Right, no, yeah, I know. Tell that to Russ and staff. The fact that there was one objector and all this work, oh my God.
Oh, yeah. Oh, no, no, oh, yeah, no, I mean, I wanted to put something in writing and give to that effect, but I won't, I'll call them up, like, that was,
Yeah, yep,
wow, thanks.
Yeah,
Yeah.
this is over a year's worth of work.
That's,
yeah,
no, I mean, all we heard was like arguments for like a courtroom kind of argument, that's not
Yeah.
gonna,
yeah, and, we met with Lauren, I don't know how many times.
Yeah.
Well, I kept wondering, like, why is he doing this then? What's in it for him? And what, I couldn't understand, like, why lean so heavily on the Amendment 3 and keeping that around? I just don't know what.
Yeah, in the beginning, we attacked Amendment 3 and stuff because it was a really weird thing. I wasn't here, but they came in and had like a $21 million bond. And then what they were trying to do was some kind of bonding package and stuff with some other sites. And then they said, no, we don't want to do that. And then they pulled back. And so the bond was significantly lower and stuff and that. So he was attacking that we didn't take that bond. And the only way I found out about it was talking to Tony Waldron, because there's nothing in the record that really indicates what that whole thing was. And so in trying to explain it to him, he was just, hammering like we did some shady deal or something. Like, no.
But we don't know what Lauren's motivation is. I mean, I think he has a business interest that has a vista that can see behind the property.
I don't know.
But it's never been clear to us. And nor has he been forthcoming with his agreement. He's obviously got his agreement.
I mean, aesthetically, I don't think 8.3 or 8.4 is gonna matter necessarily.
No,
Is
not,
it
not really. Yeah, it's not going to be restoration.
Right.
It's always
Same
going to be
here.
there. So, all right.
Thank you. Appreciate it.
All right. We killed everything.
Well, apparently, we did okay.
Yeah, good job.
Thanks.
Good job.
Did you see our Jim?
But apparently we need more of them.
Yes, we need more of them. Lynn wants them downstairs if you want us to have people like overflow.
Oh, and then she also wants one this table.
Yep. So we'll talk about that on lessons learned. Me and
Okay.
Sydney and Lexi are gonna meet here on Friday morning, and we're gonna
Okay.
drop this whole room down, but
Okay.
I'm taking part of the morning off tomorrow just so that I can kind of sleep in. I'll still be available, but I'm gonna be kind of lax tomorrow, so. I've been going since 4 this morning, so.
Yeah. Got it. Loud and clear.
Yeah, I rolled in here at 6:45 or so.
Yeah, exactly. I was like right on your tail.
All right,
I was
cool.
here beforehand. All right, so what's up with you?
Not much. Is
Not
there anything
much?
else you need from me today?
Absolutely not.
I don't know if we're gonna go find a beer or not, or if we can find a beer.
I was just telling, I was telling Sydney how grateful we were for her. And how
Yeah,
grateful we
no,
were
it's
for
great.
Jenny.
Every time I turn around, there's somebody who's popping in here. We did it.
Yeah, now we gotta undo it.
No, we're not.
No.
No,
She's gonna.
we're doing it Friday.
I can't be here Friday.
You don't have to.
Well, I'll at least get this
Well,
stuff done.
That's fine. Do what you have to do.
We'll get it.
But
You're
no,
fine.
we'll take care of, that's my laptop. I mean, if there's
Yeah,
anything
but
that I need to bring down to
this
you.
out of here and down the stairs. Michael said he would help me get it downstairs.
Whatever you want to do, but
Okay.
just leave that stuff in here and we'll get it all wiped off and.
Uh-huh. Thank you.